Be cool, be kind, be classy. The cupcakes so sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. Not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Sack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good morning. Good morning. Good morning, everyone. Today is Friday, May 30th, 2025, and we're back. We're back for day 24 of the Upside Down, Inside Out Matrix glitch. That is the Karen Read persecution, Karen Read retrial, season number 2 of the Karen Read trial in Norfolk County. All right, that's better. Massachusetts. How's everyone this morning? Today's the day that the defense is going to start its case in chief, and we've been waiting 23 days for this. 23 days for the defense to finally be able to put on some of their evidence, all of their witnesses, and I'm here for every minute of it. Are you? It has been reported that the first witness that the defense is going to call is Matthew DiSogra. He is one of their accident reconstruction experts. I believe that his particular specialty is in the tech stream data, but I'm not exactly sure. There were so many pretrial motions about experts and what the different experts had to say. And I believe that is who is testifying first today. But I also found out, and I think Lana from Lana Del Turtle's Twitter, that when I thought that they were arguing their motion yesterday to have the case dismissed at sidebar, that I may have been incorrect and that it may be happening today. That it would be done today because remember the judge yesterday told the jury not to come in until 9:30. And so it is Lana's speculation, Lana Del Turtle. If you don't follow her on Twitter, you should, because her tweets are amazingly educational. And she gets it. She must have some sort of legal background because her tweets are very legalese. That the defense will make its motion for a required finding of not guilty under Massachusetts Rule of Criminal Procedure number 25. And basically, that happens in every single criminal case. Anybody who's ever watched a trial knows that. And basically, they argue to the judge that there is no way that a jury could find Karen Read guilty because the evidence presented would in no way lead to a reasonable conclusion of guilty on behalf of any reasonable jury. And it's always denied. I don't think, have we ever seen a motion for a directed verdict or a motion for a required finding of not guilty in any trial that we've watched where a judge has decided to toss the case rather than let a jury hear it, other than, cases that are dismissed by the judge, like in the Alec Baldwin case? It will be denied. Do not be surprised when it is not granted, because it is rare. It is very rare. And so, in criminal cases anyway, sometimes in civil cases, you can get a directed verdict. saying that your client was not liable and that all the liability rests on the other side, but that is rare. That is maybe a rear end accident, rear end collision. Sometimes if they don't concede liability, you will get a directed verdict on liability if the evidence pans out that way. The jury won't be in the room while the defense argues the motion, and we will see what happens, but we're going to get the opportunity to hear the arguments, which I was kind of upset about when we didn't hear it yesterday. And so that is good. I always like to hear a good legal argument in the morning. They don't, it's not on papers. Usually it's done orally, Michael, and the judge could, direct a verdict on one of the charges or two of the charges or three of the charges or 2 out of 3. She could. Will she? Highly doubtful. Ordinarily, judges like to defer to the finder of fact, which in this case is the jury. We did see a bench trial with Judge Cannoni. Remember, we watched the Penny McGee trial together. Those of you who watched it with me, those of you who didn't should have, because the Penny McGee trial was wild. It was a woman who was on trial for manslaughter because she had a verbal argument with her ex-husband, who she was still living with at the time, and he died in the foyer of their home. She may or may not have shoved him. It was disputed. And he died of a heart attack after the argument. And crazy story. This was in Norfolk County also. The medical examiner in that case determined that it was a homicide by argument. At autopsy, the man had something like a 90% occlusion of both descending coronary arteries. A lot of pre-existing conditions. He also had, I can't remember if it was diabetes. He had had 2 major car accidents. He had some cognitive difficulties. And so there were a lot of contributing factors to his death, none of which were a verbal argument. And after a trial, in that case, Larry Tipton was the defense attorney. Larry Tipton is also representing Brian Walsh. Penny McGee was acquitted by Judge Cannoni of all charges. And it was wild. And it was a bench trial. We watched it not just because it was Judge Cannoni, but because I also found that it was a very interesting case. Penny McGee never should have been on trial for this. But the brothers-in-law, the two brothers of her deceased husband, apparently are very well connected and very wealthy. And they insisted on charges. Did you guys watch that trial with me? If you didn't, you should. It's not a very long playlist. It's only a couple of videos long because it wasn't a very long trial. She had no choice. But were you shocked when she just ruled from the bench and didn't even take time to go have a timeout and a Yeti to make her determination, her findings of not guilty? I was shocked. And her behavior was so much different. And it was so interesting. And Penny McGee, because I was reporting on the case, she reached out to me during the trial. One of her childhood friends was watching my coverage of it. And Penny McGee reached out to me and we had a couple of conversations. And I mean, her life was upside down, inside out, destroyed by what happened in Norfolk County. It was insane. And thank God she was finally acquitted. And her daughter testified against her. And you could tell that her daughter really had a lot of animosity towards her mom. And it was a very, very sad case. But in the end, Judge Cannoni threw it out. And we were all, I think, surprised. But that was one of 3 acquittals that we watched last year. And we were very, very happy about them. If you guys have been following me for a long time, well, a long time. My channel's been here for not even 2 years yet. But I choose cases that I feel really passionately about and cases that I really feel are interesting and important. And so I don't just cover something because everyone else is covering it. And in fact, I just want to put it out there to say that I don't know how many law tubers were covering Karen Read when I first decided to cover it. And a lot ran away and didn't want to cover it because of the troll factor and all of the hatred and vitriol that anybody who was covering this case was on the receiving end of at the beginning. And so I choose my cases carefully, and I don't like to do them in a shallow way, and I like to deep dive them. And we covered Penny McGee, and we covered the case of Brian Camp, which was out of Hampshire County, Massachusetts. That case was wild. Tom Kokonowski, who's been on the show with me a couple of times, was the defense attorney in that case. He represented a young man by the name of Brian Camp. My plaque is coming. I ordered it. They sent me the email that I get my $100,000. It's like a chocolate bar. My 100,000 silver play button is coming. It'll take about 2 weeks to get here. And it took a little while before they could, determine your eligibility because they want to make sure that there's not a bot farm, giving you the subscribers to get to 100K. Carly Gregg, I tried. Yes, we also covered Carly Gregg. Carly Gregg was a 14-year-old who was on trial as an adult for the murder of her mother. And Carly Gregg, in my opinion, snapped. She had been on a number of medications given her to her by a psychiatrist, and they switched up her meds. And it was my opinion that she snapped. She was sentenced in Mississippi to life in prison without the possibility ever of parole. And that was a tragic case. She was 14 years old, like a baby. It was my opinion that she was mentally ill and she needed to go into a mental institution or a place where she would get the mental health that she deserved. But that is not what happened in Mississippi. Her attorney also came on my show a couple of times, Bridget Todd. Amazing, amazing woman. I heard she moved to Utah. I got to reach out to Bridget. Brian Camp's girlfriend is watching. Hi, Brian Camp's girlfriend. What do you mean wife? Did they get married or they got engaged after the trial? Here's the story of Brian Camp. 24-year-old man living with his girlfriend in Hampshire County. Do you guys remember the exact town? It was kind of far away because it took 20 minutes for law enforcement to get there. Brian Camp was sleeping in bed with his girlfriend, Brooke. They had 2 little girls sleeping in the next room, 2 little children. A home intruder broke into their home. A home invader broke into their home in the middle of the night. And the next thing that happened was Brian Camp woke up and this man was on top of him, slamming his head against the wall, trying to kill him. Turns out this guy, Jonathan Latender, was the boss of Brooke from Dunkin' Donuts. And they struggled and they tussled. And somehow Brian Camp was a lot smaller than this Jonathan Latender, made it downstairs where Brian Camp had a number of legal weapons, got a hold of his gun, somehow managed to shoot Jonathan Latender, but not fatally, and was able to get him off of him. Brooke came down the stairs. She was hysterical. And really, I'm summarizing. These are not the exact details, but very similar. Ran outside. She's on the phone with 911, trying to get 911 to come because now Jonathan Latender is like on the ground, but I don't remember where the first shot was. Maybe it was into the leg or somewhere. Do you guys remember? It took over 20 minutes for law enforcement to get there. And at one point, Jonathan's outside with Brooke to make sure she's okay. The 2 little girls are still sleeping upstairs in the bedroom. And the 911 operator tells Brian Camp to go inside and check on Jonathan Latender to see what his medical condition is. It was wild. Oh, here's Sierra. Sierra did the GoFundMe, or we did, after it was over, we did an Amazon wish list for the girls to make them have a nice Christmas.
You are unmuted.
Massachusetts prosecuted Brian Camp. He was on trial for manslaughter because he shot him again after they sent him back in the house. Hold on, she can wait. She can wait. After they sent him back in the house, he shot him a second time because Jonathan Latender got up and was going to try and kill him again. Shot him again. The DA in Hampshire County was like, yeah, the first shot was okay. It's the second shot that we're going to try you for. And we watched that case, and Tom Kokonowski put Brian Camp on the stand. He became our collective son, and he was acquitted by a Hampshire County jury. Praise be, Hampshire County. But here we are back in Norfolk. All right. If you didn't watch that trial, watch it. It's very interesting. I think it's only like 4 videos because nobody would cover it. None of the mainstream media would cover it in Massachusetts. They didn't want anyone to know this was happening. God save us from the Commonwealth.
Thank you. So I was told council want to see me at sidebar.
Oh, good. Well, we have another minute then. And after something that was only maybe a 4 or 5 day trial, Brian Camp was acquitted by a Hampshire County jury. One of our listeners, Bo, I said Brian Camp needs support. The courtroom was empty. Nobody was there except for a couple of friends and family of Brian Camp. I don't even know if Jonathan Latender's family showed up. And so Bo, our girl Bo, she also had a name of, her name used to be Adam Lally's Resignation, but people were like every time she would come into the chat, people would say, Adam Lally resigned, what? And it was her username. She had to change it. Bo went to court. She was there. She was keeping Brian Camp and his girlfriend company in the hallway while they were waiting for a verdict. I mean, it was so heartwarming. We all burst out into tears when he was acquitted. And it was Not my most highly viewed trial by any means, but it was such an important case. And boy, did the state of Massachusetts not want to know. They didn't want you to know that this case was happening. Good morning, gallery. Good morning, Mr. and Mrs. Reed. They've become our collective parents. There's Nathan Reed. I'm not sure who's sitting next to Nathan. I don't see, where's Kelly today? I don't see Kelly Reed today. Kelly, if you're out there, sure you're looking beautiful as always. Brooke and Brian. I think they got engaged after he was acquitted. But, you know, again, this upended his life. He worked something like 3 jobs to pay Tom Kokonowski, his attorney, because he didn't qualify for a public defender. Penny McGee, on the other hand, did qualify for a public defender. And Larry Tipton, what a sweetheart he is. Larry Tipton, although he's now in private practice, he was a public defender for many years, took her case on as a public defender. I think because he felt so strongly about this case. And, you know, it just goes to show you how great, I mean, everyone hates a defense attorney, right? Until they need one. Many people hate lawyers in general, but defense attorneys are fiercely passionate about what they do. And you can see that in so many cases. Larry Tipton took on Penny McGee's case at a highly discounted rate because he was paid as a public defender. They chose a bench trial in front of Judge Cannoni, and that's one of the other reasons we covered it, is because we wanted to see what it would be like. It was after the first Karen Reed persecution, and many people had theorized, you know, maybe Karen should have chosen a bench trial because juries don't really get it all the time and they don't really understand reasonable doubt. And it just, it was so different. It was so different. Hughes thinks that defense attorneys are sexy. But again, in this case, you have a defense team working for free. Karen's already $5 million in debt, or was before this trial even started, to her attorneys. They said they're not going to be collecting from her. They said that all of the money in the defense fund, which is now over $1 million, most of it's been spent. It's all going to experts. And you see how expensive experts are, because the Timu expert, Judd the Dud Welcher, shout out to girl with the sunglasses, who, by the way, made such a sweet video about me last night. I put it on my Instagram. Just like thanking me for sending people to her TikTok, because she got banned from TikTok. I don't know how you get banned from TikTok for 24 hours. Was it graphic content, or I don't know what goes on over there, because I don't really understand TikTok. I have a TikTok, but I don't understand. Oh, congratulations to Brooke and Brian. No, I don't give legal advice, Elise. Thank you so much. I don't give legal advice on this channel. I'm retired, but somebody wants to know how I can email you to get legal advice. No, I don't do that. But if you need an attorney, I suggest that you call the Bar Association in your county, and they can recommend you to someone who does the kind of work that you need. Karen Reed's team is not going to collect any money from her. They fiercely believe in her innocence. As I've been screaming into a closet from day one, when I first started covering this in January of 2024, John O'Keefe was not hit by a car, and a car did not hit John O'Keefe. And therefore, Karen Reed is not guilty. You saw the Timu expert, Judd the Dud Welcher, come in and tell you that Norfolk County is paying him almost $400,000. I'm sure that's not even including the bill for everything else that happened here, his travel, his meetings with Tully, his prep. The guy was prepping the entire time he was on the stand. It was like being in a Broadway show and having your script in front of you the entire time. I mean, that's what we watched in open court. The man was on his laptop constantly. We don't know who was communicating with him. It was wild. Almost $400,000 for that. So, and Karen has a number of experts that have been working on this case for 3 years. It's very, very expensive. If she had to pay the ARCA experts, and you'll see the difference in quality if you haven't met the ARCA experts yet, the crash daddies, Dr. Wolf and Dr. Rentschler, you will see the difference in quality. You get what you pay for sometimes, right? It's been theorized that the FBI paid the ARCA witnesses something like $500,000 to conduct their initial reconstruction. And after seeing how much Welcher charges, it might be much more than that. It's expensive. They're going to show how it's really done in the courtroom. Olaf said, Welcher is the milkman of sandbagging. Well done. Morning, Gen X 1968. I know we're so excited for the defense to start today. One step closer to free Karen Reed. Hashtag positive thoughts. Well done. Well done. Thank you, Kimberly, for your early morning 20. It's my understanding that all the sirens are making noise and being annoying toward the defense, or is it against the Commonwealth? A few of your fans are asking on Facebook. Hope this is a great day for the defense. I don't want to get anybody in trouble, so I'm not going to tell you how I know this, but I'm going to tell you that I know. And, you know, the trolls out there are like, yeah, Melanie Little's making up these lies that Dedham Fire Department is pro Karen Reed. It's true. If you know anybody who works for Dedham Fire Department, you can ask them yourselves. But they make those, apparently they put their sirens on as a show of support. I don't want to get them in trouble. But it's what I hear from people who know. So they're not doing it to annoy the defense. It is free Karen Reed, justice for John O'Keefe, because many of the fellow brothers in blue and other service people, firefighters, EMTs, know that this was not a motor vehicle accident, including some of the nurses from Good Samaritan Hospital who I hear also watch the show. So shout out to all the nurses doing the Lord's work who don't get enough credit at Good Samaritan Hospital and every hospital, because really the nurses do a lot of the work. And people who are in the business know. They just know. The body tells the story. The injuries tell the story. I still don't know how the taillight exploded. Did Welcher ever explain that? Because I must have missed it. Oh, Billy. Oh, really? No Niece Treasure House said a few days ago, I told Billy from Hot Mics to do a show with you. He responded, he loves you. They reached out to me. The problem is that they reached out to me on Instagram messages.
Start with the required finding argument.
And those Instagram messages get caught in a black hole. But I've been in touch with the producer and we're trying to set it up so I can go on Billy Bush's case. I mean,
So
Billy
I'll
Bush's
hear you
show.
whenever you're ready, Mr. Jackson.
Thank you, Your Honor.
Sure.
Thank you, Your Honor. We filed this morning a motion for required finding of not guilty under Massachusetts Rule of Criminal Procedure 25A. I think that's before the court. My comments will be relatively brief, but it's important, and the points that I'm going to make in the next couple of seconds or next couple of minutes are equally important. It comes down to the following. The Commonwealth has simply not proven, even in a light most favorable to them, that there was a collision on January 29th, 2022 at 34 Fairview in Canton, Massachusetts. There was no collision proven to have occurred. There was no eyewitness presented. There was no video evidence, no audio evidence, no evidence in the form of physical evidence at the scene by searches that were done by officers on the morning of January 29th, 2022. The Commonwealth, through suspect experts based on circumstantial technical data, only sought to prove a backing event, and that's important. They sought to prove that at 34 Fairview, the SUV went backward. They did not prove, and every single one of their experts was asked this question, they did not prove that there was actually a collision associated with that backing event. The Commonwealth experts said at best that the car went in reverse, and it was suspect whether it went in reverse at 34 Fairview or some other place, time, or date. The Commonwealth also put on an expert who said that she found no injuries, none, mind you, indicative of a vehicle strike on John O'Keefe's body. And she, Dr. Irini Scordibello, was arguably their most important witness. The Commonwealth cannot and did not say or prove a collision at a particular time, a collision at a particular place, a collision with a particular person, or that a collision even occurred on January 29th, 2022 at or around or at or after 12:30 in the morning. Their own expert, I think it was yesterday, if not the day before yesterday, was asked on examination by Mr. Alessi, can you tell us the particulars of the collision, pardon me, as you suggested in your testimony? And his answer was, there's simply not enough evidence. He was asked specifically, why didn't you try to recreate the circumstances, the force impact? That's what you do, sir. You're a biomechanic expert. Recreate it for us. And he said, there's not enough evidence. There is evidence, however, that Brian Higgins and Brian Albert were sparring at 34 Fairview. There is evidence, however, that that was just minutes, not hours, not days, minutes before John O'Keefe ultimately met his fate at 34 Fairview. There is evidence that Brian Higgins was love-struck, that he was jealous, that he was aggressively coaxing John O'Keefe out of the waterfall, that he was passively aggressively coaxing Miss Reed to engage with him rather than John O'Keefe. Again, there's not a single eyewitness to a collision. There was not even a single eyewitness to a backing event at 34 Fairview. The court will recall Jennifer McCabe testified that she basically watched the SUV the entirety of the time it was in front of the location at 34 Fairview with Miss Reed in the driver's seat. She saw it pull up once. She saw it pull up twice. She saw it pull up a third time. And then she saw it was gone. And at no time did she ever see the car go in reverse. She certainly didn't see the SUV go in reverse at a high speed. And she darn sure didn't see the car go in reverse at a high speed and strike a pedestrian. Her focus was defined enough to see thin tire tracks in a dusting of snow, thin enough, I think the phrase was, to track a cat. That's how detailed she was in her observations, yet she did not see John O'Keefe hit by an SUV. She did not see John O'Keefe's body in the snow, in the yard, laying prostrate, a 216-pound, 6'1" man in the snow, directly in front of the SUV she was tracking the entire time. There are two other witnesses, Ryan Nagel, Heather Maxson. They both noted that John O'Keefe, not that they didn't see him, Your Honor, that John O'Keefe was not in the vehicle when they were behind it. The dome light was on. They could see inside the interior of the vehicle. Miss Reed was sitting there with her hands at 10 and 2, and the passenger seat, notably and markedly, was empty. He was not outside the vehicle. He wasn't standing. He wasn't sitting. He wasn't lying down. There's only one place he could be: inside the curtilage of the home, inside the house, or inside the garage. Not one witness that was inside the house, not one passerby, not one neighbor, not one plow driver ever saw John O'Keefe's body laying prostrate in the snow that morning. Not one. Not until Karen Reed found Mr. O'Keefe at about 6:03. And again, the Commonwealth's chief medical expert, Dr. Scortibello, their medical examiner, who's the only person that the court heard from or will ever hear from who actually investigated John O'Keefe's physical body, the only person to have physical access to John O'Keefe, testified he did not have any injuries consistent with being struck by a vehicle. But she did indicate that the injuries, as did the firefighters, the first responders, indicate that he had injuries consistent with a physical altercation. And certainly, as to counts 1 and 3, no evidence has been presented or proffered whatsoever by the Commonwealth that Karen Reed intended to run over and harm John O'Keefe in any way, shape, form, or fashion. Hearken to the video at C.F. McCarthy's. Hearken to the video at the waterfall. Every witness confirmed what our eyes could see. That night, John O'Keefe, Karen Reed were loving, caring, affectionate. There's absolutely no evidence that Karen Reed had an intent to harm John O'Keefe, or that that after the fact, that she intended to leave him for dead, because there was no fact to be after. There was no collision in the first place. The Commonwealth's case, certainly on counts 1 and 3, taken separate from count 2, because of the mens rea associated with counts 1 and 3, fails miserably. The Commonwealth, at the end of the day, has presented their best case. They've done their best. Some would say they've done their worst. And their case has failed. No reasonable jury, hearkening back to the standard under Rule 25, no reasonable jury could find Karen Reed guilty of count 1, count 2, or count 3. But taking count 1 and 3 aside, those are separate counts because of the mens rea required and the high burden that's required, even taken in the light most favorable to the Commonwealth. What evidence have they proven that Karen Reed intended to kill or harm John O'Keefe, or that she intended to leave him for dead in the snow? The answer is none, 0. No reasonable jury could find Karen Reed guilty. This case never should have been brought in the first place. There are reasons that I won't go into here. The court knows those reasons, or knows our position on those reasons. This was a vindictive prosecution, and I believe that the court is duty-bound pursuant to the precepts of Rule 25A, as well as the principles of justice, to dismiss all 3 counts, and certainly taking count 1 and count 3 aside, the court is duty-bound to dismiss those 2 counts. Thank you.
Bravo, sir. Bravo. AJ, smooth as butter. We have an emoji for him because he is smooth as butter. The jury is not in the room now.
In a light most favorable to the Commonwealth, the first issue the court should look to is intoxication. The reasonable fact finder would find that the defendant was in fact intoxicated. Based on the serum conversion.
Serum?
And based on Karen Reed's statements herself, you've heard many, many admissions by the defendant about her level of intoxication, which far surpassed the statutory mandate that she consumed alcohol in a way that would affect her ability to operate safely. Those are just 2 of the cornerstone pieces of intoxication, which are clear, light most favorable to the Commonwealth, a reasonable fact finder could find beyond a reasonable doubt. The evidence.
Unfortunately for you, there is no standalone DUI charge. It is driving while intoxicated, causing a death. There's no standalone charge. I don't care if she was drunk or not. Makes no difference, really. Is that your argument, sir?
Of collision is abundant, I pulled out. The evidence of collision is abundant. I do not want to go through an entire closing argument or rhetoric.
Because you don't have one shred of evidence that he was hit by a car. It's abundant, but he doesn't want to go through it. Yeah, he doesn't want to go through it because it's embarrassing. There is none.
But suffice to say, there are taillight fragments from the defendant's own Lexus, from her shattered right taillight, that are found in Mr. O'Keefe's clothes. Mr. O'Keefe is left at the very spot where she expects to find him, according to her statements, where her car does a backing maneuver at least 24 miles per hour.
I'm sorry, did one of her statements say that she expected to find him there? Because I forgot that statement. Am I super loud? Let me know, because I feel like the court's not very loud today.
He is left with injuries on his arm consistent with the damage to her Lexus right rear taillight. The scientific data is substantial. Telestream data, Apple Healthcare data, battery temperature data. And again, Ms. Reed's statements herself about clipping, hitting. The evidence of a collision in this case is overwhelming. It is a public way. Lieutenant Gallagher told us about Fairview as being a public way. And so as to the operating under the influence of alcohol, manslaughter, the conduct of driving in that forward and backing maneuver after being intoxicated meets clearly the standard for OUI manslaughter. Regarding second-degree murder, as highlighted in my opening statement, the defendant engaged in intentional conduct that was her maneuver of driving forward, stopping, and then driving back to Mr. O'Keefe on January 29, 2022. Under the conditions at night after being intoxicated, that conduct was intentional, and any reasonable person could find that her conduct that night created a plain and strong likelihood of death. There was no predicate of intending to kill or even intending to hit. There was clearly a plain and strong likelihood of death driving a 6,000-pound SUV forward and then back. In addition to state of mind, again, the defendant tells us herself. Through firefighter Becker, they're arguing, they're upset. We see the text messages, evidence of attempted breakup, and we hear the words of Karen Reed when she leaves numerous voicemails that night, and you can hear her voice. There are statements, I do not want to go through a summary of all of them.
You should, because you have nothing.
Statements from the defendant herself where she acknowledges an injury to Mr. O'Keefe.
No.
She's the last one with him, where to find him, and her hypothesis about hitting and clipping him. As to leaving the scene, again, the defendant tells us that when she leaves, he doesn't look mortally wounded. She leaves him, makes dozens and dozens of calls.
Okay, it's too early for the bullshit button, but really it's never too early for the bullshit button. Her statement did not say that when she left, he didn't look mortally wounded. Her statement said that when she saw him in the morning, when she came upon his body, he did not look mortally wounded. But this guy lies in open court constantly, so I'm not surprised. Listen to that again. He has nothing. He has nothing. This could be the worst argument I've ever heard. Talk about grasping at straws. The paper straws that he's grasping at. Boy, do I hate paper straws, by the way. McDonald's, up your game.
Him, where to find him, and her hypothesis about hitting and clipping him. As to leaving the scene, again, the defendant tells us that when she leaves, he doesn't look mortally wounded. She leaves him.
When she found him.
Dozens and dozens of calls, but never goes back to help him and leaves him to die. And we heard from Dr. Wolf about the life-saving procedures that could have been initiated. The chance of survival was never given to John O'Keefe. All those facts suffice under Lattimore, a light most favorable to the government, that a reasonable fact finder would find beyond a reasonable doubt, or could find beyond a reasonable doubt, each and every element of each and every one of these charges.
Wrong. Wrong.
The motion is denied as to all three of them.
Of course it is.
On the other topic that we were discussing at sidebar, I don't need to hear argument on that right now, Ms. Giannetti. I'd prefer to get started. I would like you and Mr. Brennan to talk to see about proposal. So are we ready to bring the jury in? I did not ask you at sidebar. Are you ready for this witness, Mr. Brennan?
I'm ready.
Okay.
Mr. Brennan? Who cares if he's
So
ready?
we'll bring the jury in. That will take 5 minutes, Paul. All right, so we'll take the lead.
Who cares if Brennan is ready for this witness? Really? Or is it all about him now? Pull out the binkies, my friends. Pull out the binkies and the boss babies, because we are here. We're in the matrix. There's a glitch, but we're here. It is a fantasy world. It is Narnia. Happy birthday, Danielle. It's Danielle's 50th. Excellent argument by Alan Jackson. The Commonwealth has not shown that there was a collision. The Commonwealth has not shown any injuries lining up to a pedestrian motor vehicle accident, including the Commonwealth's own medical examiner, who said she looked for signs of a pedestrian collision, but she could not find them on the body of the decedent Boston police officer, John O'Keefe, because that seems to be lost here as well. He pointed out, Alan Jackson did, that even the Commonwealth's most highly paid expert, I don't know if he said that, those are my words, Judson Welcher, supposed to be the man of the day, Judd the Dud, according to the girl with the sunglasses. Even Judson Welcher testified that he didn't have enough evidence. He didn't have enough evidence to recreate the circumstances of the accident? He didn't know because nobody knew where John O'Keefe was hit. Nobody knew where his body was. Nobody knew the speed of the vehicle as she was going backwards. I never said it was 24 miles an hour. Where did you get that from? Did he show a forward event and then perhaps a backing event? Maybe, but he didn't show any collision. Even in the light most favorable to the Commonwealth, he still didn't show an impact with the body of John O'Keefe. Alan Jackson brought out the fact that Brian Higgins, the evidence showed that Brian Higgins was jealous, he was love struck, and that there's video of him and Brian Albert play fighting, showing aggressive behavior at the waterfall before they were before they were, asked to come back to 34 Fairview, before Karen Reed dropped him off. Alan Jackson went on to say that Jennifer McCabe, in her own testimony, looked constantly outside for the vehicle. She saw Karen's car move up 3 times. He didn't bring it up, but I'm going to tell you that at 11:45, she's still texting. And in the first trial, I think it was brought out that she said the car was still there at 11:45 during the time of her last text message. And then it was gone. She didn't see a body. She's the only witness produced from inside the house. He didn't mention this either, but I'm going to. Other than Sarah Levinson, who said he never came in the house. Commonwealth didn't produce anybody else who was inside 34 Fairview. Neither of them saw the body on the lawn, despite the fact that he's 216 pounds or was, and 6'1". He said they were darn sure. He put darn sure in there somehow, and I can't remember why. They darn sure didn't see a body on the lawn. He also said that Ryan Nagel and Heather Maxson also said definitively that John O'Keefe was not in the car when they left. That Karen was in the car by herself, and that leads to only one conclusion, that he was inside the house or the garage. He said, as I have been screaming, that the medical examiner, the Commonwealth's own medical examiner, is the only witness that they produced to examine the body of John O'Keefe, the only one who had direct contact with the body. And that she could not determine that it was a homicide. She could not determine that it was a pedestrian versus motor vehicle accident. But what we do have here is evidence of a physical altercation. Hearken. He said hearken a couple of times, which I like because they always say hearken in the beginning, at the beginning of court. Hearken and draw yourselves near. Anybody who has business in front of the Honorable Justice Beverly Cannoni, God save us from the Commonwealth. He said, Your Honor, there is no way that they have shown any mens rea with regard to charges counts 1 and 3. Mens rea is a fancy Latin word for intent. The mindset, what is in your mind, there needs to be intent on a murder 2 charge and on leaving the scene of the accident, because she would need to know that she was in an accident in order to leave it. And on murder 2, she needs to intentionally have killed him or intentionally engaged in behavior that she knew would kill him. And there's absolutely no evidence produced by the Commonwealth to indicate either of those things. He said that no reasonable jury would ever come to the conclusion that she was guilty on at least counts 1 and 3, that this has been a vindictive prosecution, and that you, Your Honor, are left with no other choice but then to dismiss this case. Thank you, Suzanne. There are 2 new motions filed this morning. I have both of them. When we have a break, we will go over them. So if anybody's going to email them to me, please refrain. They are dockets number 700 and 701. They're fresh up on my screen. I have not read them yet, but we will as soon as we have a break. Brennan got up, stomped his feet a little bit, sucked on his binky. Well, I think he put his binky back on the desk before he got up there, and he called it a serum test. He said, according to the serum test, it's obviously that she was drunk and that she was driving drunk. And so there's so much proof of intoxication, Your Honor. And I pointed out to you, as I've pointed out to you many, many times, that there are no standalone DUI charges here. There aren't. She cannot be convicted just of drunk driving. It doesn't exist here. He said that there's abundant evidence of a collision, but I'm not going to get into every single reason. And he had no reasons. Forward, then reversed. We have evidence of that, he said. And then he said, firefighter Becker said that they were in an argument. Karen Reed's own statement proved that she was guilty, as addition to her voicemails. I don't agree with any of that, but in no shocking surprise, the motion was denied, and the defense will now present its case in chief. Apparently, Mr. Yannetti made another motion. She said, we don't need to deal with that right now.
All persons have any business before the Honorable Beverly Canoe, Justice of the Norfolk Superior Court, and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
Good morning again, council. Good morning again, Ms. Reed. Good morning, jurors. Happy Friday. So I do have to ask you those 3 questions. Were you all able to follow my instructions and refrain from discussing this case with anyone since we left yesterday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Yes. Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday? No. As you know, yesterday the Commonwealth rested, and as you know, the defendant has absolutely no burden of proof in this case. Does not have to put on a case, but I hear that you are. So your first witness, please, Mr. Jackson.
Thank you, Your Honor. With the court's permission, we would ask that Matthew DiSogra join us.
Okay.
Witness number 1 for the defense, Matthew DiSogra. He's an expert witness. He's a technology expert. I think he's going to testify about the text stream data and or the EDR data and or maybe some cell phone data too. We'll see. If you ever tune in late and you're wondering what's happening, I have made banners for you. They are scrolling at the bottom of the screen.
So you're going to step up, face the clerk, and raise your right hand.
You solemnly swear the evidence you give to the court and jury in the case down here is for the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
Thank you.
Shout out to Eugenia, the court clerk. We love her. She just swore him in, or was standing next to him while he was sworn in, rather. This witness did not testify in season 1. And so therefore, we've never seen him before. We've never met. We will have to find a nickname for him. Let's go.
All right, Mr. Jackson, whenever you're ready.
Thank you. Mr. DiSogra, could you please state your full name and spell your last name for the jurors, please?
Sure. Matthew DiSogra, last name DiSogra.
What do you do for a living, sir?
I am a licensed professional engineer. I practice in the field of accident reconstruction. And within that field, I specialize in analysis, interpretation, and accessing all types of vehicle data.
How are you currently employed?
I'm employed by Delta V Forensic Engineering, which is an engineering firm that specializes in accident reconstruction, all parts of accident reconstruction.
Tell us a little bit more about Delta V. What is it? What kind of company is it? But other than that specialty, what else does it do?
So accident reconstruction is a broad field. There are a lot of subspecialties within that. So accident reconstruction is everything from the initial investigation phases of a crash all the way through testimony, like here today. Some of the specialties within that could be things like biomechanics, could be human factors, and my specialty is data, vehicle data, and event data recorders.
Staying on that topic, what is your current title or position with Delta V?
I am the director of engineering for our EDR services line.
What does EDR services mean?
So, event data recorders. So EDR is a general term we can use to talk about all types of data from all types of vehicles.
And how would you describe your role as the director of engineering for EDR services for Delta V?
I wear a couple of different hats. First and foremost, I'm still a practicing engineer. I still conduct investigations. I still perform analyses, and I testify. On top of that, in the director role, I oversee a group. It's not just me doing this kind of work. I have 3 other engineers that work with me, all specializing in EDRs. So I oversee that group and focus on kind of the day-to-day operations as well as the direction we're going. You know, with things like autonomous vehicles coming, the role of data is growing. So we're kind of looking to the future in a lot of those ways.
As a consulting engineer, you've indicated what your specialization is. Do you specialize in motor vehicle accident reconstruction as well as vehicle system analyses?
I began my career at Delta V doing traditional accident reconstruction in the broadest sense. And as I have progressed, I have sort of narrowed myself down and now specialize in that. But I still consider myself an expert in accident reconstruction because
And-
ultimately, sorry,
No, please finish.
ultimately, anytime we're doing EDR or data analysis, it is in support of an accident reconstruction.
You talked about event data recorders. Do you also engage in the specialty of advanced data recovery methods? In other words, methods of pulling the data. It's one thing to have it sitting in a car. It's another thing to pull it out and make it useful, correct?
That's right. There are a lot of different ways data can be accessed, all the way from just plugging into a port on a working vehicle, all the way through when a vehicle is catastrophically damaged and even the modules themselves are damaged, accessing the data at the chip level. So no matter what condition a vehicle or the remnants of a vehicle are in, generally we can still get the data from that.
Do you have any specific knowledge about Toyota data?
I do.
Describe that for us.
Beyond Toyota being a common vehicle in general, so we run into that data quite frequently. Just this year, we published a paper specifically studying some of the behaviors of the additional data recorder that's in Toyota vehicles.
Does Toyota make another sub-brand, for lack of a better phrase?
Lexus, I believe you're. Mhm.
So Lexus is a Toyota brand. Right?
Correct.
Okay. What is infotainment? It's kind of a combination of a couple of words, information and entertainment. What is infotainment data as it relates to vehicles, modern vehicles?
So it's a generic term, which more or less means the thing that's in the middle of the dashboard with the screen on it. A lot of manufacturers implement that a little bit differently, so they all look different, but it's a general term we use in the industry to describe that system.
And what about, I'm going to change gears a little bit. What about your experience with regard to GPS as it relates to vehicles on the road, on the common roadways of the country?
GPS is a pretty fundamental part of vehicle data as a whole at this point, and we run into it in a lot of different places. We see GPS data from infotainment systems, so we're analyzing that data. Most of that's GPS based. I do a lot of heavy truck work, and almost every heavy truck has some kind of GPS system in it for the fleets to track them. So we're analyzing that as part of data. And then the last area would be when we conduct testing, any kind of research, we're generally going to put our own GPS systems on vehicles so we can study that data. So analyzing GPS is a regular part of my job.
GPS, global, I'm going by memory, global positioning satellites?
Global positioning system.
System, got it. GPS is a mechanism to figure out where on Earth a certain item might be, whether it's this pin or an 18-wheel tractor trailer, correct?
That's correct.
Is there any difference inherently in the GPS mechanism that's installed in an infotainment center in a Toyota/Lexus, versus a heavy truck or a heavy vehicle that's on the road?
The core technology behind how it works is fundamentally the same.
What is instrumented testing as it relates to Toyotas and VCH testing and things of that nature? Can you explain that for the jurors?
Sure. What instrumented testing means is, let's say we want to study, let's say how accurate some data is that comes out of one of these vehicles. So we need an independent source of that information. So what we'll do is we'll equip a vehicle with one of these GPS data acquisition systems. Basically, we can drive the vehicle around and we know exactly where it is, how fast it's going, all these parameters. We can do some maneuvers with the vehicle. Then we can download the data that the vehicle stored, and now we can compare the two and say, okay, well, if we have really high confidence in our system, how accurate is the vehicle system? Because the reality is there's always some small errors in these vehicle systems. And in a lot of cases, what's important is quantifying that error.
So you're obviously familiar with GPS systems in many different platforms.
That's correct.
Okay. How many cases have you been a part of in terms of investigating and or analyzing infotainment center or infotainment system data?
Infotainment specifically, probably around 30.
And are you also familiar with engaging in some sort of analysis that's referred to as clock alignment?
Yes.
What is clock alignment?
Clock alignment would mean that anytime we have a timestamp in any set of data, a singular clock value, there's a good likelihood that that's not 100% accurate. So clock alignment would mean finding an independent source of time to compare that to, preferably one that's more reliable, and then making the necessary adjustments so that time can be considered real time.
Interesting. Interesting. So clock drift really is a thing. It really is a thing. Let's see if he's going to say that Ian Whiffen did it wrong and he used the wrong thing, or it's not 21 to 29 seconds. This is what a real expert looks like. He comes in, he's polished, he's nice to the jury, he's explaining things in a way that people can understand it. We'll see how he handles cross with Brennan, because Brennan can push people's buttons. But so far, I'm a fan. How about you? This is not a hired gun, a typical hack expert like we've seen some of in the prosecution's case. I like him. Gives me a good vibe.
How many cases have you been involved in that deal with clock alignment specifically?
Thousands, over 1,000. That's a regular part of data analysis. Any data set that has a timestamp, it's normal. It's part of the analysis. It's really the first step is let's get that clock aligned. So it's something I'm doing regularly.
And how long have you worked for Delta V?
It'll be my 13-year anniversary next month, actually.
Okay. These things that you've just described that we've talked about for the last few minutes, these are all duties that you perform within the rubric of your employment as the director of engineering at Delta V, correct?
Correct.
Now let's shift gears real quick and talk about your education, training, and background that qualifies you to perform these duties that you just talked about. Go ahead. The road is open and it's yours.
Certainly. So I began my academic career. I got an undergraduate degree in mechanical engineering from the University of North Carolina at Charlotte. I then went on and got a master's degree also in mechanical engineering from the same school. And then when I came out of school, I immediately started working for Delta V Forensic Engineering. In order to get a professional engineer license, I then needed to acquire 4 additional years of work directly under the supervision of another licensed engineer. So then I completed that phase of work. And then in order to maintain my license, I have to complete continuing education every year in the field that I practice.
So you got both a Bachelor of Science, correct?
Correct, Bachelor of Science.
Did you mention the year that you got your Bachelor of Science?
2011.
And you have a Master's?
Correct.
In engineering?
That is correct.
And when did you secure that degree?
2013.
You just mentioned engaging in continuing education. What is continuing education in terms of the engineering field or the reconstruction field in your world?
So in the state that I'm licensed in North Carolina, they define that really as any activity you're participating in that's keeping you abreast with the field, keeping you up to date with what's going on. So taking formal classes counts for continuing education, but also some of the other work that I do, like publishing research in peer-reviewed journals, also counts as continuing education.
Do you regularly attend symposiums or symposia, I guess is the right
Yes.
word? Have you attended symposia related to EDR research and training?
Yes.
How about advanced applications of heavy vehicle EDR data?
Correct. Yeah, I attend. There's a couple of regular conferences in our industry specifically tailored to EDRs as a whole for passenger vehicles and heavy trucks. I'm a regular attendee of those. I'm also a regular speaker at most of those. And I'm usually presenting some of the new research that we have for that year.
So not only do you attend, you actually teach.
Correct.
Have you attended data? Have you attended events that deal with data, event data recording systems, and event data recording system extraction?
Yes.
What about vehicle crash reconstruction?
Yes.
What about electronic control module imaging?
Yes.
What about electronic control model analysis?
Yes.
Applying automotive EDR data to traffic reconstruction?
Yes.
These are samples of the type of continuing education that you routinely engage in, correct?
All that's accurate.
You talked about additional licenses and professional registrations. You're a licensed professional engineer, correct?
That's correct.
In North Carolina?
Correct.
You're also a certified IPC specialist?
Yes.
What is an IPC specialist?
IPC is an organization that offers certifications in basically soldering. I could say it in more technical ways, but it boils down to soldering. So as it relates to what I do, when we are recovering data from damaged EDRs at the chip level, that involves some really precise soldering work. And so IPC offers courses in how to do that at basically the highest level, and then they offer certifications for that.
Are you a member of the Society of Automotive Engineers?
I am active member.
When you say an active member, is that a nationally recognized society for academic engineers?
Yes.
The teaching roles that you've held within organizations, have you been an instructor concerning accessing and interpreting heavy vehicle data event recorders?
I am. I'm currently an instructor of that course, which is offered through the Society of Automotive Engineers.
As a matter of fact, next week, are you going someplace to teach?
I am. I will be in Wisconsin next week teaching that very course.
Are you a member of any subcommittees within that organization?
All right, ladies, are you looking at plane tickets for Wisconsin? This is what a real expert looks like.
Within the organization of the Society for Automotive Engineers?
I am a voting member in the J2728 subcommittee, which is a subcommittee for event data recorders on trucks and buses.
Are you also a member of the National Association of Professional Reconstruction Specialists?
I am.
Does that require a certain level of education?
It does, and it requires, as far as I know, when I joined, sort of proof that you are active within the field of accident reconstruction.
That was my next question. It requires you to stay current on accident reconstruction issues, correct?
Correct.
Have you also authored peer-reviewed articles on within your field and
Yes.
subfield? Is it fair to say that you've authored or co-authored a number of peer-reviewed papers in the field of accident reconstruction specifically, as well as EDR data retrieval?
That's correct.
Have any of your peer-reviewed articles that you've either authored or co-authored specifically focused on Toyota vehicles?
Yes.
Can you name one, please?
Specifically, this year published a paper where we studied the effects of collision-induced power loss on the way data is recorded in Toyota systems. And that would include Lexus systems. Fundamentally, they're the same components. It's just a different brand on top.
In January 2025, did you co-author a publication entitled Simulation of Vehicle Speed Sensor Data for Use in Heavy Vehicle Event Data Recording Testing?
Mr. Jackson, you're going to have to repeat that.
Of course. Sorry. In January 2025, did you co-author a publication entitled Simulation of Vehicle Speed Sensor Data for Use in Heavy Vehicle Event Data Recorder Testing?
Yes, I was the lead author on that paper.
When you're dealing with retrieving data from a vehicle, an EDR, an event data recorder, Toyota paper, whatever it might be, and that's a term of art, Toyota paper, correct?
Sure.
Does it matter if the vehicle is a heavy vehicle, a small vehicle, a passenger vehicle, a moped, or a skateboard if they happen to have an infotainment center on it?
There are differences, of course, between the data that comes out of passenger vehicles and the data that comes out of heavy trucks, but there are also a lot of fundamental similarities to those. Like, for example, they all record vehicle speed. They all have accelerator pedals. They all have brake pedals. So a lot of the core data we're analyzing is very similar.
In January 2020, did you co-author a publication entitled Chip and Board Level Digital Forensics of Cummins Heavy Vehicle Data Event Recorders?
Yes, I did.
Okay. And what was the fundamental, without getting into the granular details, the fundamental aspect of that paper?
So, in that research, we introduced a new technique for getting data out of damaged modules. So, you know, they're either burned, they've been submerged in the water, they're crushed physically from impact. We demonstrated a new method to be able to get data less invasively, but still at the chip level. And we also demonstrated that we could translate that data from the chips outside of the software that was provided. So you could use the software and get the data that way. We demonstrated we could basically do it ourselves if we wanted to.
Mr. DiSogra, have you been qualified in other courts to testify as an expert in the area of accident reconstruction, EDR data retrieval? And recovery?
Yes.
How many times?
Once.
When was that?
In New York.
You were deemed qualified as an expert in that court in this field that you're talking about today?
Specifically with, as it relates to data, yes.
I want to talk a little bit about what you were asked to do in this case. We asked to undertake a review of certain work performed by a person by the name of Shannon Burgess with Aperture LLC.
Yes,
Are you familiar with Aperture?
yes,
Before you were asked to undertake that review, were you familiar with Aperture?
yes,
Were you familiar specifically with Shannon Burgess?
yes.
Oh,
Were you asked to
That's
engage in
proceeded.
any original analysis in this case?
All of my analysis is fundamentally based on all of the data and the numbers provided in the Aperture reports. So more or less the answer to your question is no.
So you were asked specifically to give the court and the jurors clarity on data that Shannon Burgess had analyzed and provided a report about, correct?
Correct.
And that dealt with data obtained from Miss Reed's SUV, Karen Reed's SUV, correct?
Correct.
Did you in fact review Shannon Burgess's report summarizing his findings and conclusions regarding clock drift? That report was dated in January of 2025.
Yes.
And what did you do in that regard?
I analyzed the methods that Mr. Burgess proposed for aligning the clocks in that report.
Were you also asked at some point to review Judson Welcher's report and PowerPoint presentation regarding the timing of the text stream event known as 1162-2, 1162-2?
Yes.
Did you determine whether Dr. Welcher had based his report on Shannon Burgess's analysis?
here we go.
Yes.
Before we get into that, I want to ask you a couple of questions about text stream events. So we're all talking sort of with the same vocabulary if we could.
Good morning, Rich Schiffer. Good morning, case friggin' closed. Just to point out, this expert was hired for the sole purpose of refuting Shannon Burgess's report and Welcher's report on key cycle 1162.2. He is not only an expert, but he's an expert in Toyota/Lexus EDR recorders. He's an experty expert in this exact particular thing.
When I say text stream event, have you ever heard that called a trigger event?
Yes.
Are those sort of synonymous?
The event, in order to be generated, has to be triggered by something. So, yes.
You became aware in your analysis, I'm assuming, that Dr. Welcher reported a trigger event at a particular time or span of time, correct?
Correct.
What span of time was that? I should say, what time was that?
For which event? Just so
For
I'm
the
clear.
1162-2 event, sorry.
Do you mind if I reference the slide? Because I don't have the number committed.
With the court's
to
permission.
Go ahead.
Do you have a copy of it in front of you?
I do, Your Honor.
Are you cheating by texting with people on your laptop or looking at your Garmin watch? Thank you, Lisa McCarthy. I appreciate it. Let's keep the good energy flowing, my friends.
So the original analysis places event 1162-2 ending at 12:31:43 a.m.
Now, Dr. Welcher, and this is what I want to talk about for just a quick second. Dr. Welcher indicated that the trigger event began at 12:31:38, correct?
I believe so.
That would suggest that a trigger event lasts 5 seconds, 12:31:38 to 12:31:43, correct?
Objection.
Sustained is to form.
Let me ask you this. Does a trigger event or does a text stream event last 5 seconds or 10 seconds?
The trigger is a singular point in time.
That's my question. All right, so if we're thinking about a trigger event, it's like that clap, snap, right? It's a point in time, not a series of, not a time span, correct?
It's a singular point, correct?
Okay. Does a trigger event or a text stream event cause a recording to bookend the trigger event itself.
Yes,
Explain that for the jurors so that we're very clear about that.
sure. So when an event is triggered, what we end up with is some data from before the event was triggered and some data from after the event was triggered. The way it does that is it's kind of always recording. And as soon as it sees a trigger, it says, aha, and it goes and it grabs the previous 5 seconds. That number can vary. It can be more or less than 5, but for the specific trigger we're talking about, it grabs the previous 5 seconds of data, and then it keeps recording for an additional 5 seconds, and that completes its recording phase.
Right. So if Dr. Welcher indicated that the text stream event, the trigger, was at 12:31:38, would it be accurate if he said that trigger ended at 12:31:43?
Sustained is to form.
Is there any, if a trigger event is one point in time, one snap in time, would it be accurate to say that the trigger event itself lasted 5 seconds and ended 5 seconds later?
It wouldn't be accurate to say the trigger lasted that
That's
long.
my question.
The event lasts that long, but the trigger is only one point within the event.
The recording lasts that long,
Right.
correct?
Correct.
So in other words, it captures, or does it? Let me ask you this. Does it capture 5 seconds before and 5 seconds after? But the trigger event is the singular point right in the middle.
That's correct.
Okay. If we were to calculate the window between the trigger event or the text stream event and a lock event on John O'Keefe's phone, you analyzed both, correct? Or you reviewed both, correct?
Correct.
Would you calculate from the point of the trigger, would you calculate from 12:31:38, that point in time, and I'm using the tip of my pen to represent the point, at 12:31:38, or would you calculate it from 12:31:43?
Customarily, when we're doing any analysis, we're referencing everything off of the trigger. That's the normal way. Everything in the aperture reports was referenced off of the end of the event. So
Of the recording event,
of the recording event.
not
So,
the trigger.
Correct. And I didn't correct that. I just went with that convention for all of the analysis I did.
But you noted it, correct?
Correct.
And you noted that that would be 5 seconds inaccurate. I'll withdraw it. I'll ask it a different way. What
The
would
witness-
be the effect?
If you're not watching your screen, the witness keeps looking over at Brennan for some reason, because I think Brennan makes a big show of when he's going to object. Like he starts to stand up, or maybe he's making faces or something. And we've been wondering for a long time why a lot of witnesses, well, prosecution witnesses, because that's all that we've seen so far, keep looking at Brennan. And it's leading me to believe now that this witness is doing it, that he's doing something distracting, causing them to stop talking or not answer, because he looks like he's about to object in some way. Having not been in the courtroom this time, I don't know, but that is my guess. Sonia Pedro, thank you so much for watching from Portugal. You're amazing. She says, this is a teacher of Latin and Portuguese. Listening to Melanie is such an intelligent road that helps me be more attentive to people and what they say. Thank you so much, Sonia Pedro, for tuning in from Portugal. The world is watching, and for your generous super chat.
Of timing if you were to start at the trigger event 12:31:38 versus timing the event if you were to start at 12:31:43.
There'd be approximately 5-second difference in every subsequent calculation.
And if in fact there was a lock event, which you reviewed at 12:32:09, how long would the actual window be from the trigger event to 12:32:09?
It would be larger by 5 seconds, approximately.
So it would actually be 31 seconds, correct? Did I do my math right?
You did.
Let's get back, if we can, to the offsets that you identified in Shannon Burgess's, the time offsets that you
I just want to be clear on that because he was talking about vehicle data, but then he said a lock event at 12:32:09. Was he talking about the car or is he talking about the vehicle? Because I don't think did she lock her vehicle at 12:32:09? I'm sorry, I have to take that back because it wasn't clear to me.
event. If you were to start at the trigger event,
The phone.
12:31,
Thank
12:30,
you.
Every subsequent calculation.
Okay.
and if
Thank
in
you.
fact
Sorry.
there was a lock event, which you reviewed, at 12:32:09, how long would the actual window be from the trigger event to 12:32:09?
It would be larger by 5 seconds, approximately.
So it would actually be 31 seconds, correct? Did I do my math right?
You did.
Let's get back, if we can, to the offsets that you identified in Shannon Burgess's, the time offsets that you identified in Shannon Burgess's report. When you applied the potential offsets identified by Mr. Burgess to the text stream event at 1162-2, what opinions or conclusions did you come to with regard to that analysis or that question?
Just looking at Brennan.
Sustained, ask it differently.
Do you have an opinion with a reasonable degree of scientific certainty?
Did you apply the potential offsets identified by Mr. Burgess in his January 2025 report to the text stream event 1162-2?
Yes.
Did you also apply Dr. Welcher's analysis based on that same Shannon Burgess analysis to reach an opinion or a conclusion?
Yes.
And what was your opinion or conclusion with regard to that event and the timing following that event?
Based on all of the data in those two original reports, regardless of what adjustment is made or which 2 points are used to try to correct the clock, the phone lock event always occurs after the end of the event, using their convention of referencing off the end of the event, not the trigger, but it always occurs after.
And that was based on Shannon Burgess's January 2025 report, correct?
Correct.
Sustained.
What was that based on? Which report? We're dealing with two different reports, May and January. I want to make sure we differentiate. Which report are you just now talking about?
I'm talking about the January report.
Now, did Mr. Burgess, were you supplied with a supplemental report by Mr. Burgess?
Yes, I was.
When was that?
Slightly after he issued it, but I don't know the exact date.
Say that again?
It was issued on, his report was dated May 8th, and I think I was provided it a couple days after that. I don't
Okay.
remember the exact date.
So after, well, do you know when this trial started?
No, I don't know the exact date.
I know you're not watching the trial, but it was in the middle of this trial, correct?
Sustained.
I'll ask a different question.
Remember, the report was dated May 9th. The defense did not receive it until May 11th. The trial started on April 22nd. So it was in the middle of the trial.
With regard to the original report, the January 2025 report, was there any circumstance in which Mr. Burgess and Mr. Welcher could conclude that the lock event on John O'Keefe's phone, that lock event, occurred before the trigger event?
Objection.
Sustained. Ask it differently, Mr. Jackson.
What is your opinion about whether or not there was any analysis done by Mr. Burgess or Mr. Welcher that put the lock event occurring before the trigger?
Objection.
Sustained.
She's not going to let him get anything out of this witness.
May we approach, Your Honor?
Yes.
Maybe do you have an opinion with a reasonable degree of scientific certainty whether or not John O'Keefe's lock event of his phone occurred after the trigger event in Burgess's report. Thank you. Amber Dawn says that she wishes that I were her mom. I love you too. I will adopt you. I already have 5, so a couple more. Doesn't really matter. Little sidebar. He's back.
May I, Your Honor?
Yes.
Thank you.
Everyone hit the acknowledge button.
Back to
Thank
my
you.
question. Was there any circumstance based on your review that if the tech stream event occurred at 12:31:38, that there was any circumstance that the lock event occurred before that trigger event?
There was not.
Never could have occurred before the alleged collision is what they're getting at here.
Did you create a PowerPoint for clarity's sake in March of 2025?
Yes,
Did you provide that to us?
I did.
What was the purpose of creating the PowerPoint?
The purpose of the PowerPoint was really to take a bunch of different data elements that were kind of placed throughout Mr. Burgess's report and Dr. Welcher's report in PowerPoint and compile them into a single source, a single table, essentially, to show as clearly as possible what the conclusions would be if we look at the data as a whole.
When you created that PowerPoint presentation, did you create it with the intention of providing it to the defense, which would then be provided to the Commonwealth?
Yes,
Are you aware of whether or not that was disclosed to the Commonwealth as part of the normal discovery process?
no,
So the answer is no. The answer is
Sorry, what now? The answer is what? Are you aware whether or not it was provided to the Commonwealth? I don't know that he would be aware of that, but
Whether or not that was disclosed to the, you create it with the intention of providing it to the defense, which would then be provided to the Commonwealth?
yes,
Are you aware of whether or not that was disclosed to the Commonwealth as part of the normal discovery process?
no,
so the answer is no. The answer is
Following your presentation of the PowerPoint to us, at some point, did you receive from Mr. Burgess an amended report, an amended PowerPoint?
I received an amended PowerPoint by Mr. Burgess, not from him, though, from you.
Fair enough. Fair enough. Did that report or did that PowerPoint, however you want to put it, markedly, was it any different than his January 2025 report?
Yes,
Did you note any conclusions? Did you note the conclusions that he came to in January 2025? Going back to the original report,
yes,
did you note conclusions and opinions that he came to in May of 2025?
yes.
Were those two things different?
sustained.
why? He
Were the
compared the two
conclusions,
reports.
not his opinions, were his conclusions different?
Sustained.
Was there any difference in the two reports?
There was.
Tell me the differences.
In the first report, Mr. Burgess did some of the calculations that are necessary to correct or adjust the times based on certain approaches, but never went through the final step of applying those calculations to the times and coming up with a final time. In the supplemental report, he then essentially took that analysis to the end. He approached it in a new way, a different way than he had previously laid out in the first report, but then he also took it all the way to the end by applying those calculations to the times.
What were the main differences? Explain for the court and for the jurors, what were the main differences that he changed in the May 2025 report?
Contrasting it with the original
Correct.
report. In the
Right.
original report, he laid out some methodologies for correcting the clock using phone calls that were shared between the vehicle, and Mr. O'Keefe's phone. And in the supplemental report, he moved away from the phone call analysis and moved to attempting to align the clocks using a shared maneuver between the vehicle and the phone.
What was the shared maneuver?
It was a 3-point turn.
Was that the same analysis that he had in January 2025?
He did not have that analysis in the January 2025 report.
Thank you. Based on the new information in the May 2025 report, what was the effect, as you see it, regarding the possible scenarios?
So I did the exact same process I did using the supplemental report as I did on the first report. And when I ran all those numbers and those calculations, it turned out there are now some scenarios in which the phone lock occurs after the end of the event. There's some scenarios where the phone lock occurs simultaneously, like literally at the same second. And there are some scenarios where it occurs before. So now there's a range.
So Mr. Burgess's report, his new report, his amended report, widened that gap to allow him to opine that there were scenarios that occurred after the phone lock event, correct?
Objection.
The objection sustained.
Did you prepare a PowerPoint presentation in furtherance of clarifying Mr. Burgess's analysis?
Sustained.
Well, it's asked and
Did you
answered because he
seek to
said he did.
clarify Mr. Burgess's analysis?
Boy, this is like,
Sustained.
Your Honor, may we approach?
Yes.
I mean, he prepared a PowerPoint. It's been exchanged with the prosecution. I think he asked him, do you know if it was exchanged with the prosecution? He said no. He does give me Andy Garcia vibes too, says irony in the land of the lost. Thank you for your 20. I don't know why he keeps objecting. I asked and answered. He said he already did provide a PowerPoint presentation. Is Brennan objecting to the use of this PowerPoint presentation? I don't know. But I think the binky emojis are appropriate here. You know, he'll probably cry trial by ambush if they didn't turn it over. But this expert has been in the arsenal of the defense for a very long time.
May I?
Yes.
Did you prepare a PowerPoint presentation in furtherance of your analysis?
Yes.
What was the reason, and what was the purpose for your PowerPoint presentation?
I needed to include in my analysis the approach and the conclusions from the supplemental report by Mr. Burgess.
May I have a moment, Your Honor?
Yes.
We have some nickname nominations.
Yes.
We've got Delta Data Daddy. I like that. Delta Data Daddy, Jen Shep.
If you wouldn't mind taking a look at that document, it's a multi-page document I just handed you, and just flip through it and let me know once you've familiarized yourself with it.
Funeral lady says, Daddy to Cobra. Did you mean DiSogra because his name is DiSogra, or are you making a reference to a cobra? Data Daddy.
What is that document?
This is a printout of the PowerPoint presentation that I prepared.
Is it true and accurate,
Yes,
and it's complete?
it appears to be.
Your Honor, I would move for its admission, please.
I have no objection.
May I have
Okay.
that back, please?
Being admitted. Can we see it on the big screen, please?
208. Thank you.
Call me Jeeve. We love spending our Friday afternoon with you as well. If you're happy to be here today, put a heart in the chat.
Your Honor, permission to display the PowerPoint presentation?
Okay.
She says, who's ready for Hanky to embarrass himself
Mr.
on every
DiSogra,
single
can you still
cross?
see with the lights off sufficient to see what's on the screen and what's in front of you?
Yes.
Okay. Do you recognize what's on the screen?
Yes.
What is that?
That is the title page of the PowerPoint that I prepared.
And what is how would you describe the PowerPoint?
So this PowerPoint is largely identical to the first PowerPoint I prepared in that it seeks to take all of the different approaches between the initial Burgess report, the supplemental Burgess report, and Dr. Welcher's report, lay out all of those approaches in one kind of coherent fashion so we can look at what conclusions we can draw from all of that data.
With
Well,
permission-
looking at the title page of his PowerPoint, I can see why Hanky is sucking on his binky because this PowerPoint presentation is dated May 25th of 2025, which would have been 5 days ago. And you may recall that there was just some data that was turned over to the defense team on Memorial Day at 3 p.m. Memorial Day was the 26th. This was prepared the day before that. I don't know if it's been amended since because of the additional data provided by whichever witness that was. Now I'm conflating everything. What's up with all the hearts? I said, if you're happy to be here today, put a heart in the chat because the viewer said she was so happy to be here today. And that's what it is. Showing love for each other.
We go to slide 2.
Yes.
Thanks, Becky.
Mr. Jackson, you can just use this PowerPoint. It's in evidence. You don't have to ask slide to slide.
Thank you, Your Honor. Taking a look at this next slide, what is this? What are we looking at?
This is a slide from Dr. Welcher's presentation that I was provided. Specifically, this is his slide number 33.
And what does it show?
This is where he introduces the first, acknowledgement that there's a difference between the time that Aperture calculated for the end of event 1162-2 and the lock event on Mr. O'Keefe's cell phone.
Is there anything in this?
Okay, because many of you are not looking at your screen and because I think this is important, I'm going to read what this slide says. This is Judson Blair Welcher's slide number 33 from his PowerPoint. And it says at the top, Aperture, read Lexus travel time, text stream, infotainment, O'Keefe cell phone. At trigger event, and then we can't read it because it's black font on a black background. Ignition has been on for approximately 19 minutes and 2.2 seconds. 18 minutes, 57.6 seconds to 19 minutes, 7.5 seconds, with infotainment trigger 1162-2 occurred at approximately, and then it's impossible to read because it's in red lettering. I'll enlarge it for myself. I can't because it's hard to read. 12:12:36 infotainment plus 19.7.5 tech end 1162-2 equals 12:31:43 is the end of the 1162-2 is at 12:31:43. Okay, he's showing his math here. This is Welcher. Then it looks like maybe there's some more black font on black background, but it says, per report from Ian Whiffen, O'Keefe's cell phone data showed, quote, most notably, all device lock events, including the final lock event at whatever time that is in red font that I can't read, were user initiated by the user pressing the side button briefly. This data indicates that the final user interaction with the device was at 32 minutes and 9 seconds. So 12:32:09, this is military time, when the device was locked. And then it says after, and there's a green box, which I'm not sure if it was added by this witness. We'll find out. That is circled, or there's a little square around it that is green. It says last O'Keefe cell phone event lock occurred within approximately 26 seconds of the event of the end of the text stream event. Then there's some blue font under there that is unreadable as well. This is in evidence, so it is something that the jury will get to bring back with them into the room while they're deliberating and review it at their leisure. But I want you to know what he's talking about to put some context on it. Okay, moving on.
The slide that you disagree with in Mr. Welcher's presentation that you disagree with, it's up on the...
I added the 2 green boxes and the text, the word after. That's not Dr. Welcher's.
Okay.
And I added that because it's stated here that the event occurred within 26 seconds. But if we do the math, and he actually does the math, he really means after. It means the phone lock event occurred 26 seconds after the end of the vehicle event as calculated.
Move to strike.
Going to allow it.
Oh, good. A win.
The phone
1W.
interaction happens how many seconds after the text stream event?
Based on this slide, 26 seconds.
Thank you. And the text stream event that we're talking about is what number?
1162-2.
And this slide, other than the green, is this slide or the portion of the slide that we're looking at, other than what you've described, is this directly from Mr. Welcher's own analysis or his PowerPoint?
Right. I added the green box around within, the dashed green box around the whole paragraph, the line, and the words after. Those are my additions.
Let's go to the next slide. Can you tell us what this is?
This is more or less a repeat of what's on the first slide, but just shown with a little more focus. The first slide is a little busy. So
Yeah, a little. We can't read. We can
What
read it.
Did you, I'm sorry, Mr. DiSogra, did you create this or is this from Dr. Welcher's report?
I created everything on this slide apart from in the top right. That came from Dr. Welcher's slide 33.
Although you created the slide, where's the data coming from for this slide?
All of the data on this slide and all of my subsequent slides comes from the Aperture reports collectively, either Dr. Welcher's report or slides or Mr. Burgess's first and second reports.
What did their analysis reveal in terms of the time, the exact time of the lock event for Mr. O'Keefe's phone?
So in their analysis, in Aperture's analysis, they report the Lexus event 1162.2 ends at 12:31:43. And they also report there's a phone lock at 12:32:09. So if we just simply take the difference in those two times, we get 26 seconds.
If you were to add the 5 seconds back to 12:31:38, which is the actual trigger event, what would you come up with?
31 seconds.
Which of the two, in your expert opinion, which of those two numbers is more accurate as it relates to the trigger event?
Before he answers that, I thought they were going to read the whole slide. I'm going to read it to you. And this is using Aperture's data. It says Lexus event 1162-2 ends at 12:31:43 a.m. Phone lock interaction is at 12:32:09 a.m. 12:32:09 minus 12:31:43 equals plus 26 seconds. Let's call this 26-second difference John's interaction window. It's important to note that Karen Reed connected to, according to Trooperino, Nick Garino, she was back at One Meadows connected to the Wi-Fi by 12:36. Unless she was driving chitty chitty bang bang, there's no way that she hit him in the 12:31 range. It's a 10-minute drive, according to Jennifer McCabe, from Fairview to One Meadows. And there's also no way that if John O'Keefe was dead, he would be looking at locking his phone, right? Of course, right?
Which of the two, in your expert opinion, which of those two numbers is more accurate as it relates to the trigger event?
If we wanted to conduct the analysis relative to the trigger, it would be better to use the actual trigger time. However, as long as we're consistent through the analysis, it's not entirely wrong to use the end. It would be wrong if I suddenly switched up and started talking about this relative to the trigger event, but they present it as the end of the event. So I conduct the rest of my analysis using that convention.
Is another word for the end of the event the end of the recording?
End of the recording. Yeah. When I say event, what I mean by that is the data event, the data recording event.
But the trigger event itself, 12:31:38.
Correct.
Okay. Did you put a name on this gap, if you will, this time frame?
Yes, I did. For the sake of the rest of the analysis that I'm going to do, I thought it would be helpful to just refer to this difference in time as John's interaction window.
And that refers directly to the interaction with the phone, the human interaction of locking the phone.
The 12:32:09 lock.
Okay, let's go to the next slide, please. What does this slide show us?
So this here, what I'm doing is I'm kind of laying out the bounds of what I mean in John's interaction window. which should make, we have a lot of numbers to go through here. And so this should give us a very easy metric for kind of determining whether we have an event before or after. So what I mean by that is when we calculate John's interaction window, if that number comes out and is positive, that means the phone interaction occurs after the end of the vehicle event. And if we calculate John's interaction window and that number becomes a negative value, then that means the phone interaction occurs before. So now we have just a convention we can use really quickly to say, is it positive or is it negative? And we can maybe spare ourselves some of the math with 1,000 numbers.
So positive means what? One more time.
I'm going to read this again. I'm going to read it to you, actually. John's interaction window. When John's interaction window is positive, the phone interaction occurs after the vehicle event. If John's interaction window becomes negative, the phone interaction occurs before the vehicle event. When they say event, it's that 10-second window of the recording, but the trigger would be in the middle of that 10-second recording. Are we following? I know it's hard, but here we go.
Some of the math with 1,000 numbers.
So positive means what? One more time.
Positive, John's interaction window positive means the phone lock occurs after the end of vehicle event 1162-2.
Got it. Let's go to the next slide, please.
Thank you, Kay Willis, for gifting 5 memberships. You want to sell your house
What does
south
this
of
slide
Boston?
show us?
Call Kay.
So what I'm saying here, I'm kind of laying the foundation for why we're going to even do this. Why do we need to start doing math on these clocks? So fundamentally, the phone, Mr. O'Keefe's phone, and the vehicle, Ms. Reed's vehicle, they're separate clocks. And it's very unlikely that they're going to be aligned perfectly in time. Right? If I compared my watch to your watch, it would probably be off. And that's the same case for any 2 independent clock sources. So Aperture, in their collective reports, propose a number of different ways in which that can be corrected. So I'm going to go through all of those ways that Aperture has proposed and show if we align the clocks based on how they laid out, does John's interaction window stay positive or does it ever become negative? Where does it end up when we run all those analyses? Or another way to put it is, does the phone interaction always occur after the end of the vehicle event?
And what did you determine?
Based on the initial reports,
Yes.
the phone interaction always occurs after the end of the vehicle event.
He does look like Larry, Foreman DUI guy. Larry came in and said, hey, Larry, thanks for the 20. Larry says, I had no idea I was testifying today. He does look like he could be your brother. He could be Larry's brother. You guys will you guys allow that? DUI data Delta data Diddy DUI guy's brother. Delta. Wait, what did you call him? Delta data daddy. Thanks, Larry.
Did all of the information that's on this slide come from the same source or multiple sources, meaning Mr. Burgess and Dr. Welcher?
In the PowerPoint as a whole, all the information comes from the Aperture reports collectively.
Okay.
From Dr. Welcher and Mr. Burgess.
Did Mr. Burgess make any adjustments from his original report to his subsequent report in May of 2025?
Yes.
Let's go to slide 6, please.
Larry, can I shout
Tell
it
me
out?
about this slide.
Shout out that
Yeah,
you're
so
hiring
this is-
any good attorneys or paralegals in the Kentucky area. Find DUI Guy's channel. Buckle up. Send him a resume. Probably has his email in there.
The first adjustment we're going to talk about and this one comes from Mr. Burgess's original report. And to summarize this adjustment, this is a key on timing adjustment. And we're going to show that the key on, the actual turning of the vehicle on, occurs about 3 seconds before that time gets registered in the infotainment. So the time we see is basically stale by 3 seconds.
We're all familiar with how computers turn on. When you say key on, do you mean a physical key or could it be the push button to turn the car on?
In this case, it's a button. I refer to key on because generally that event is considered the key on in-vehicle parlance, regardless of whether there's a physical key or it's a push button.
So those 3 seconds mean what? What's the difference between pushing that button and the 3 seconds later that you just described?
It means that when we're trying to use the timestamps that were recovered from the infotainment system that show when the vehicle was keyed on or turned on, that the vehicle was actually or likely turned on 3 seconds before that.
Do you know where the 3-second conclusion came from in Mr. Burgess's report?
That came from the testing that Aperture conducted with the exemplar Lexus that they purchased.
Was there anything in the report that indicated testing, this type of exact testing on Ms. Reed's actual Lexus?
No.
Do you have an opinion as to whether or not all Lexuses, at least of this make and model and year, would have the exact same 3-second delay? Or could that be different?
It could be different in their testing. In their testing, they only tested one exemplar vehicle. So I think there was a solid foundation that the exemplar that was used exhibited this 3-second delay. It was a very close match in terms of part numbers and software versions to Ms. Reed's Lexus, but without any kind of testing of, let's say, a second vehicle, a second exemplar, we wouldn't know, we wouldn't have any basis to say it must be 3. We could test a second vehicle and it could be 5. So we say, well, there's a delay, but it varies vehicle to vehicle. They could have tested a second vehicle and found it's also 3. And then you start to build some confidence that maybe it is 3 across every vehicle. But with only testing one and not testing the subject vehicle, it is difficult to say with absolute certainty it would be 3 seconds.
What is your opinion about?
So they tested the exemplar vehicle, Burgess and Welcher, but they never tested Karen's vehicle? Okay. Makes no sense, but okay. What is your opinion about best practices?
With absolute certainty, it
Wait, here
the
they
subject vehicle be across every vehicle. But with only testing one and not testing the subject vehicle, it is difficult to say with absolute certainty it would be 3 seconds.
What is your opinion about best practices with regard to trying to create this gap for purposes of coming to an opinion or an analysis?
So because we don't know whether or not this specifically would apply to Ms. Reed's vehicle, the best way to conduct that analysis would be to do the entire thing with the key switch adjustment at 3 seconds. Because if we're going to use a value, 3 is the most reasonable one because that's the one shown in testing. But we should also do the entire analysis without it in case we feel that that's the most appropriate. So in fact, that's what I do and will show is I ran the analysis both ways, with and without, to be as conservative as possible.
Did your review of Mr. Burgess's report indicate that he ran the analysis both ways?
He did not.
Let's go to slide 7.
Because he had confirmation bias. They all did. They were all told what conclusion to come to. Why
What are
would
we
you run
looking at
multiple
here?
experiments?
This is an excerpt from Mr. Burgess's original report. His page 28 and his page, there's a screenshot also from his page 30 at the bottom. And this is where he states in that report that when they were doing the testing with the exemplar, they observed across 4 different key-on cycles this 3-second difference. So what I mean by that is they had a video camera in the car that had a timer on it. And so in the video, you can see the button pressed. So in their testing, for example, they pressed the button at 21:48:05, and that's sort of nailed down. When they went back and downloaded the data from the infotainment, the key-on was logged in the infotainment as 21:48:08. So there's the 3 seconds. That's where they're getting that from. And that's what he states highlighted in red there. It's a little hard to read, but it basically says the average across 4 runs was 3 seconds.
The 3-second delay, was that actually in his report?
This is the only point in the report it's mentioned. He
And I guess what I'm asking, it was an artful question. The portion to the left, is that his report or your report?
That is his report. Everything on the left-hand side of this slide comes from Mr. Burgess's report.
So the
Okay.
3-second delay,
And if you just look at this is when my kids were in third grade, they made better PowerPoints than this to try and convince me to buy them MacBooks or iMacs. I have one daughter who made me like 3 PowerPoint presentations on why I deserve a Mac. The font is so small you can't read it. It's completely jumbled. It's not easy to read or easy to follow. And it's fakakta. But, you know, this, yeah, maybe you get what I don't know, maybe you get what you pay for, but not for 400 grand.
was noted in his report.
Hold on.
Comes from Mr. Burgess's report.
So the 3-second delay was noted in his report.
It was noted.
Did he apply the 3 seconds in his analysis?
He did not.
Did he indicate in his report why he ignored that 3-second delay?
He did not.
Sustained as to that question.
I'll rephrase it.
Strike the answer.
Did he indicate in his report the reason that he did not apply the 3-second correction?
He ignored
He
it.
did not.
When you do apply the 3-second correction, what do you come up with as it relates to the 26 seconds from the end of the recording?
So the positive 26-second window, if we only apply the 3-second key on, grows to positive 29 seconds.
If you applied the same 3 seconds to the trigger event time, now what does the gap?
That gap would grow to a positive 34 seconds.
Between the trigger event and what?
The phone lock.
Happy birthday, JJ. Another birthday today. Happy birthday, JJ.
In your opinion, was it best practice to not account for that 3-second delay between the on switch and the data coming on?
Sustained, ask you to.
What, in your opinion, would be the best practice in terms of this 3 seconds that was noted in the exemplar vehicle?
The best practice would be to run the analysis with that adjustment included and without that adjustment included. Because like I stated, without testing of an additional vehicle, we really don't know if the 3 seconds is just a specific behavior of that exemplar or if it's representative of all Lexuses of this type.
Let's go to slide 8, please.
Thank you, Wim, for gifting 10
Tell us
memberships
what
and
we're looking at on
welcome.
this slide.
10 new members.
So now
welcome.
we're going to get into the next adjustments. That first adjustment we just talked about was really a vehicle-to-vehicle adjustment. We haven't talked about the phone yet. We're going to get into the phone now and talk about aligning that. But we had to get through the internal adjustment that has to get done first. Now we're going to look on the subsequent slides here at all of the different ways the Aperture reports compared the vehicle to Mr. O'Keefe's phone.
Is there any additional adjustment that you believe should be made?
The Aperture reports lay out 2 methodologies for adjusting. There is a methodology based on phone calls, and there's a methodology based on the 3-point turn
And where did you get that information
from the Aperture reports.
In Mr. Burgess's original report, I'm differentiating, the January report, which did he use to determine his determination of the clock skew?
In his initial January report, he never actually takes the calculation to the end by applying the differences in times to the calculated time for 1162-2, but he does do the math, which I'll show, for the differences on these phone calls.
In terms of Dr. Welcher's report, did he identify a GPS point of 154 at all?
Yes.
How did he describe that GPS data point?
He describes in his initial PowerPoint slides as 0.154 aligning with the end of vehicle event 1162-1, talking about a different event now. This is the 3-point turn event. So he uses that as an anchor point.
And that anchor point you said was the end of the text stream event, or the end of the recording of that text stream event.
Correct. The aperture reports consistently reference everything from the end of the events.
Let's go to slide 9, please.
He doesn't finish the calculation.
What are we
He
looking
didn't
at here?
finish it.
On the left is an excerpt of page 33 from Mr. Burgess's initial report. And what he shows here is he has identified 7 call logs that exist both in the infotainment from Ms. Reed's Lexus and in Mr. O'Keefe's phone. He puts them in a table form. Then he actually goes on and calculates the difference between those 2 times. So that's what I meant by he sort of does the math. He makes my job a little easier, and the numbers are already there. He just never applies these to any of the times. So that's where I step in and say, if I take that 3rd column that he lays out, those are in seconds. If I apply those seconds, that adjustment to 12:31:43, where do we end up with John's interaction window in those times?
What did you conclude in terms of finishing the work?
Sure, I did all of them. And so I highlight on this particular slide, I just highlighted the very first one he has in here. In that case, he identified that Mr. O'Keefe's phone was 2 seconds slow relative to the infotainment system. So if we apply only that adjustment, then John's interaction window becomes positive 28 seconds.
Did Mr. Burgess apply all of the potential offsets?
He didn't apply any of the offsets. He calculated all of them, but he didn't apply any of them.
Did you ultimately apply all of the offsets?
Yes, I did.
And what did you determine?
Regardless of which offset you apply, John's interaction window remains positive. The number changes, but it remains positive.
Let's take a look at those one at a time if we can. Let's have the next slide.
Okay, hold on. So if it remains positive, that means no matter what the calculation is, according to Burgess's data, it always happens after he's dead, essentially, right? Now, can somebody who's really smart explain to me, does this assume that John O'Keefe was connected to the Bluetooth in Karen's car? Because how else are you connecting the 2 times? It says he says in his conclusion, DiSogra, O'Keefe's phone is slow relative to infotainment. Infotainment time should be adjusted back by 2 seconds to align with the phone time. I know we have engineers in the chat, and maybe you can help me with this, which means 12:31:43 a.m. becomes 12:31:41 a.m. Every second counts here. Exactly. Okay, so his phone is connected to the Bluetooth, right? These are calls that were made in the car. Okay. So is the defense now agreeing that the 1162 key cycle is actually at Fairview? This is where I'm lost, because originally Trooper Paul said 1164 was when he tested the car, which would make 1162 in Dighton, which would mean that John's phone was nowhere near that car. Think positive post-event. Okay, thanks, Mirabelle. Okay. Well, why would the passenger's phone be auto-connected to Karen's phone? My kids' phones are all connected. They all connect to my phone, because when you drive someone's car a lot or you're in their car, you connect to the Bluetooth. Maybe you want to run your music. Maybe you want to connect your phone calls. That wouldn't surprise me. Okay, so Larry 70 says, no, I don't think so. I think they're just trying to discredit Aperture. Okay. So I think he is trying to say that in the light most favorable to Aperture, they're still wrong. All right, let's keep going and maybe it'll clarify itself. So it says John's interaction window is plus 28 seconds. So I guess he's agreeing with that. Let's keep going. Some can
So in this
connect.
slide, I just took
two
the
at a
other
time.
end of the spectrum.
Yeah,
There's a
5
large
different
range
phones.
in values in this table. He doesn't actually, Mr. Burgess doesn't show the sign conventions on here, but
What do you
actually
mean sign conventions?
sign conventions, he doesn't show when he calculates the difference, whether it's positive or negative. All the numbers in the table don't have a sign, don't have a plus or minus in front of them, but there's an implication. Some of them are plus, some of them are minus. So the first one that we just looked at showed we had 2 seconds slow. There's another value in here that's on the other end of that. It shows that Mr. O'Keefe's phone is 21 seconds fast now relative to the infotainment. So that's the largest value in the table we could take that would bring John's interaction window down now. And so if we apply just that adjustment, John's interaction window becomes a +5.
Oh, I see what you're saying, Melissa, because Karen was calling him from her car after she left, and Aperture used that information, albeit incorrectly. So the time that Karen called from her car, that would be the car time, and the time that he was receiving those calls would be his phone time. Maybe they got to put this all together for me because I'm lost and I have a law degree. So I don't know.
Take a look at slide 11, if we could, please. What are we looking at here?
So I've shifted now from the phone calls, and now we're going to talk about the 3-point turn alignment. In the 3-point turn alignment is first presented in Dr. Welcher's slide from his presentation here. And in this, he doesn't say it explicitly, but he provides some math on the screen, which is a little hard to read.
By
But
George, I
he
think
puts
I
some
got
math
it.
on the screen that shows he's aligning this 0.154 from Mr. O'Keefe's phone to the end of event 1162-1. This is the prior event.
That's
This is
the
a
3-point turn. Ooh.
And so he aligns, he says this is basically how you align it. And he doesn't do the math. Again, he lays out that he says a 19.2 second difference. I actually just adjusted that to 20, which is the most conservative way to interpret that. I don't think we have the accuracy here to talk about tenths of a second. Nevertheless, I just rounded that up to 20. And when we apply that 20 seconds to our event 1162-2, then John's interaction window becomes +6. That's just applying this. We're not combining anything. We're just applying the difference shown in this slide.
And that positive interaction window, is that calculated based on information directly from Dr. Welcher's report?
Yes.
Let's go to slide 12.
Okay, wait. I'm going to read this. Happy birthday to Jackson's Nickel. That's 3 birthdays today. Happy birthday. This slide says, and this is DiSogra's work, O'Keefe phone 122358 is fast relative to infotainment, which is 122338. So that's a 20-second difference. Infotainment time should be adjusted forward by 20 seconds to align with the phone time. 12:31:43 a.m. becomes 12:32:03 a.m. And here John's interaction window is, what does it say? Something like 6
Welcher's report
seconds.
calculated based
Plus
on
positive 6 seconds. But I don't understand. Is that a set number, or can it keep drifting where the interaction window sometimes is 6 seconds, sometimes is 3 seconds, sometimes is 29 seconds, all in the same night? I'm lost, but hopefully they'll explain it to me.
information directly from Dr. Welcher's report?
Yes.
Let's go to slide 12.
Okay. He's just talking about Burgess's report and how
What
crappy
are we
it is.
looking at here? What is this table?
This is a table I made. We've talked about a lot of different approaches to how these clocks can be aligned and a lot of different variables. So I tried to summarize them in one table, put them all together, because some of them we can combine. We can combine the key on with either a phone call or a 3-point turn, but we can't combine, for example, a 3-point turn and a phone call. That's not valid. So I put all the possible combinations, all of them, with, without key switch, phone calls, and 0.154 on one table. And I calculated John's interaction window for all valid combinations from the Aperture reports. And when we do that, the result is that regardless of what adjustment we make, all of the numbers are positive, meaning regardless of what adjustment we make, the phone lock event always occurs after the end of event 1162-2.
Okay.
Did Mr. Burgess, in your review of his report in January of 2025, did he ever undertake all possible offset calculations?
No,
In his May 2025 report, did he undertake all possible offset calculations?
no.
What is your opinion in terms of best practices regarding calculations of this sort?
I think if there's sufficient data, if there's testing or research or literature that in a specific case supports there is a best path or a best method, then we should use that. In this case, I don't think there is a best practice. There isn't any literature I'm aware of that would specify exactly the best path to align all of these. So in the absence of any external data to support one path, the most valid approach is look at all of them as a whole and then draw the conclusion from the totality of that data rather than cherry picking a single point.
This is why I was going crazy yesterday when they were talking, when Welcher was talking about a path. I had to change the path on my PowerPoint. I had to change the path. What he meant was the route that Karen was driving. And this expert is properly using the term path in his engineering assignment that he was given here. The path to the data, the path to the end of the problem hypothesis. And it makes more sense used in this way than route that they traveled. See the difference?
Can you testify to a reasonable degree of scientific certainty whether all potential offsets that were described in Aperture's original report, January of 2025, result in a positive interaction window?
Yes.
And what is that opinion?
Regardless of what adjustment or combination of adjustments we make from the original reports, John's interaction window remains positive.
Motion
Does
for
the
Chaka.
positive interaction window mean the lock event occurred after or before the text stream event?
It means the lock event occurs after the end of the text stream event, 1162-2.
Which would be 5 seconds after he was allegedly struck. Add that 5 seconds, and then no matter what calculations you use, John O'Keefe would have locked his phone manually by clicking the side button after he was incapacitated and or deceased. Thank you. Chaka is up in the upper right-hand corner because I feel a little bit like we're in the land of the lost right now. Chaka is our mascot. Gen Xers know what I'm talking about. It was a TV show in the 70s.
You've already indicated that you received a second report, May of 2025, correct?
That's correct.
Yes, Tara. Well, hello, everybody. That's what we want him to say right
In that
now.
report, is there the same clock skew alignment or a different clock skew alignment that Mr. Burgess now undertakes?
Mr. Burgess undertakes a different alignment in that report.
Let's go to slide 13.
Oh. More variation.
Describe what we're looking at in this slide.
So what I have here on the left is a screenshot of page 42 from Mr. Burgess's supplemental report. And so now he's done two things new here. He's identified a new method for aligning the data based on the 3-point turn. So now he's kind of following where Dr. Welcher started, but he's approaching it a little differently. And secondly, he is now calculating the actual time. He's doing the difference calculation and he's applying that to the time. So now he's taking the calculation all the way through, which is a little different from the prior reports. And so when he does that, he makes my job really easy because I didn't have to do really any math now. He comes up that there is a range now. So prior to this point, the original report by Mr. Burgess and Dr. Welcher reports all used discrete points in time, right? They sought to find an event that occurs at a singular second and another event at a singular second and a line based on that. This is a little bit of a departure from that approach. Mr. Burgess is now using a range of times, a range of uncertainty. He basically assesses that the 3-point turn data from the phone and the 3-point turn data in 1162-1 cannot be precisely aligned down to a single point. Rather, they overlap in this range of seconds. And so he then says that that range must be applied. So now we have to apply a range. And what we end up with is 9 possible values. So it kind of looks like one conclusion, but really there's 9 conclusions on this slide. And so if we just applying the math he has in the supplemental report, John's interaction window now has a range of 9 possible values. And that range spans from +5 now to -3. So we have 5 positive values. We have 1 value that's 0, and the 0 would mean it's simultaneous. And then we have 3 negative values.
Does Mr. Burgess indicate in his report that any one of those values is more likely than any of the other values?
He does not provide any data or analysis to support 1 point being preferential over the other 8.
And are there more or fewer positive results in his analysis than negative?
There are more positive numbers in that range of 9 than there are negative numbers.
Does Mr. Burgess's new data indicate anything about Dr. Welcher's analysis about the GPS data point 154 being at the end of the 3-point turn?
He opines in that aligning the 3-point turn on a singular point is not, and I'm paraphrasing because I don't know the exact way he states it, but not the preferred method.
Is Mr. Burgess's analysis consistent or inconsistent with Mr. Welcher's determination that GPS point 154 was at the end of the text stream event?
Objection.
Sustained.
Does Mr. Burgess in his report indicate whether he agrees or disagrees with Dr. Welcher's analysis?
I don't remember specifically.
Pierogi Cacciatore says, I believe he's showing how
In
Burgess
your opinion,
Burgess was able to make accurate calculations, but chose not to. Instead, Burgess aligned his data to fit the Commonwealth's theory. That's what everyone's been doing here, reverse engineering to get to the conclusions the Commonwealth wants, in my opinion.
asked you about, in your opinion, I asked you about Mr. Burgess's report. Now I'm going to ask you about your opinion. In your opinion, is this new offset any more likely or reasonable than any other offsets previously proposed by Mr. Burgess?
I don't think it is more or less likely. I think it is a valid approach, certainly. And so I think the results from the additional analysis should be included with the analysis of all of the results so far.
And none of those results are more or less likely than any of the others, correct?
Sustained.
Are any of the results, in your opinion, to a reasonable degree of scientific certainty, are any of the results any more or less likely than any of the others?
It's my opinion they're all equally weighted.
Did Mr. Burgess account for the 3-second offset that we talked about earlier in his May 2025 report, his new report?
I did not see any mention of that in his supplemental report. And certainly the 3 seconds isn't present in his math. I don't see it there.
Let's go on to slide 14, please.
Thank you, Auntie
Describe
Bev's
what we're
Kangaroo
looking at here
Court
in this table.
for gifting 5.
This is very similar to the table we looked at previously, where I look at all possible combinations. Now, however, I just have a lot more data points to show. So I've had to break the table into 2 tables. So we're going to look at this, and then we'll look at slide 15 next, which is the second table. I just couldn't cram 30 lines onto one slide.
Let's move to the next slide then. Is this a
So there's
continuation of
the
the?
second half. So think of these as a singular table. I just had to split them up. If we
Okay.
head back to slide 14, we'll start there. So this slide, I'm not accounting for the key on, and that's the main difference between my two tables. Table 1, I'm not accounting for the 3-second key on. In table 2, I am.
When you
But-
say key on, you're talking about that 3-second delay.
Correct.
Okay, go ahead.
But again, I want to make sure we're thinking about this as a singular table because that's where we'll draw our conclusions from. So the first lines of the table, we've already seen those. Those were in my original table. I haven't changed those. That's the same math that's been there. All I did was I added the 9 points now from Mr. Burgess's supplemental report using the range he shows. And so now we can see if we include that, now we get some positive numbers for John's interaction window. We get that 0. And again, the 0 would imply that the end of event 1162-2 is happening exactly at the same second as the phone lock. So it's kind of not on one side or the other. So I think it should be thought of as separate. And then we have 3 negative values, which would imply that phone lock occurs before the end of 1162-2.
And did you already mention the simultaneous, the one that was simultaneous?
When John's interaction window is 0, correct?
0.
That would imply simultaneity.
All right, is this 14 or 15?
I've got a magic
14,
8 ball
let's move
too.
to 15. Now, this is
Same.
a continuation of that. Mentally, we'll just continue that same table?
Correct.
Okay,
Just a continuation. Imagine in your mind is just rows 16 to 30.
okay.
And it's the same thing, same format, except for now we're just adding in that key on adjustment because again, I think the analysis should be run with and without it. And so now when we run this with the key on adjustment, we get 14 of these 15 are John's interaction window is positive to various degrees. And one of them, it's 0, again, simultaneous. And there are no negative values with this adjustment.
So no matter
The next
what,
Slide 16, please.
no matter what, the lock event occurred after the alleged collision.
What are we looking at here?
This is the summary then of that table, kind of a verbal summary of the giant 30-line table now. And if we look at all of the possibilities from all of the aperture reports collectively, then we can draw some pretty straightforward conclusions. 25 of those 30 possibilities result in interaction with the O'Keefe phone after the end of event 1162-2. Looking at all the possibilities, 2 of the 30 result in interaction where it's simultaneous. That's the zeros. They're present in both tables. And then looking at all 30, 3 of the 30 result in interaction with the phone before the end of event 1162-2.
Do you have an opinion as to which of these particular offsets that you've described, these 30 possibilities, should be applied in this case?
No.
Why is that?
Each of the approaches have their own individual strengths, and each of them have their own individual weaknesses. And there is not really any published literature, any research, or any testing done that I'm aware of that would suggest one really stands head and shoulders above another one of the methods. So I think the most fair way to present it is to look at, again, if we combine everything together, then we can draw some conclusions like this in terms of how many of the total result in one outcome or another.
Is every data point that we're looking at and that you've been talking about, are these all drawn directly from Aperture's reports?
That's correct. I have not proposed any methods for aligning the clocks myself. All of the methods that comprise these 30 are from the Aperture reports themselves.
Based on your analysis of the Aperture, or your review of the Aperture analysis, is there any ability to say to a reasonable degree of scientific certainty that the text stream event occurred after the last physical interaction with John O'Keefe's phone?
Yes, there would be three out of the 30 possibilities would result in that.
Is there do you have an opinion to a reasonable degree of scientific certainty that it did happen after the tech stream event?
Sustained.
Of the 30, what's the percentage of possible events that occurred, possible scenarios, I should say, wherein the tech stream event occurred after the last interaction with John's phone? What's the percentage?
That's sustained.
You said it's 3 out of 30, correct?
Yes,
It's 10%.
Is that 10%?
that is 10%.
Yeah, it's sustained and it's stricken.
Why? Because the jury can
What
do their own
percentage
math?
is 3? Just do basic math for me. What is
Who's
the
leading?
percentage between 3 and 30?
Sustained.
Says the key of leading. Says the king of leading,
If I told you
Brennan himself.
hypothetically,
I'm going to see your sidebar for a second.
We're a little bit behind, so we have the ability to scooch. Yay, us. Yay, us. Kimberly Hoffman said she's so outraged at this miscarriage of justice that she's going to apply for law school at 55 years old. I say, go, girl, do it.
following your analysis of the totality of the possible scenarios, did you come to a conclusion that the vast majority, let me rephrase that, did you come to any conclusion about the numbers as they relate to the positive interactions versus the negative? And when I say positive versus negative, I'm talking about the phraseology that you used. John's phone interaction being in the positive side versus John's phone interaction being in the negative side.
Yes.
And what were those?
Of the 30 possibilities, 25 of them, it's a positive. John's interaction window is positive for 25 of them.
And only 3 were negative?
Correct. Only 3 of the 30 were negative.
Okay, we can take that slide down. Is there a data recorder on the Toyota SUV that we've been talking about, that 2021 Toyota SUV 570, that's designed to record impact?
Yes.
Oh, thank you.
What is that? What is that mechanism?
That would be the airbag control module,
The ACM?
ACM.
Did you look at that?
I was provided a copy of the download from the ACM.
What did the data recorder indicate, if anything, related to any impact on January 29th, 2022?
There were no recorded events whatsoever on the ACM.
No impacts.
Did the vehicle control history record whether there was any history of a collision on that car, ever?
No.
Never. So that means not even the one in the driveway would
What does
trigger.
the vehicle control history record specifically?
It records a lot of operational parameters about the vehicle. What I mean by that is it records things like what the driver is doing, for example, steering wheel angle, accelerator pedal position, whether the brake is being pressed. It also records what the vehicle is doing, for example, speed, or the engine RPM, or the accelerations of it.
Traveling
Does the
Mary.
tech stream data event indicate that there's a, and I'm talking about very specifically the tech stream data, does that indicate whether or not there's a collision in the car?
No.
No collision. Oh, it
Does the
doesn't,
tech stream
doesn't
data
record it.
event mean that if you find a tech stream data event or a trigger event, does that mean that the airbags are deployed?
No.
Does it mean that the vehicle impacted with something solid?
No.
Does it mean that the vehicle impacted with a pedestrian?
No.
You reviewed the raw tech stream data associated with the entirety of Ms. Reed's vehicle, did you not?
Yes.
How many tech stream events or triggers were found on Ms. Reed's vehicle during the course of the 8-month period prior to January 29th?
So can you narrow that, Mr. Jackson?
Sure.
Why?
I object to the whole line.
Why?
And I need to see your sidebar.
Traveling Mary says, I don't know how to crochet, so how do I express my rage without throwing stuff in my house? Just when I start to understand Bev and Hank, throw the flow off. I used to tell my kids to punch a pillow. If anybody has any better ideas for the traveling Mary, please put them in the chat. She's not part of the Rage Crochet Club. I too do not know how to crochet, but yeah, let's just hide the evidence. Let's hide everything from the jury because, you know, that's what we do here. That's what it is that you say we do here in Norfolk Superior. We hide everything from the jury, like Trooper Paul's report. There's Tara Kerrigan, former girlfriend of John O'Keefe from like 20 years ago, who wears a necklace with this badge number around her neck, sitting next to Paul O'Keefe in the back row. Erin
Mr. Jackson,
has only been there on select days, including when the children were testifying, and I think for openings. Okay. They're back.
okay. Mr. Jackson, how much longer? I'm just trying to figure out.
I'm wrapping it up, Judge.
Okay.
It's not going to be long. A few more questions.
I'm not curbing you in any way. We just.
Understand. Respectfully, it won't be very much longer.
She keeps saying that. She's not, trying to curb him in any way, but it's not a good look in front of the jury. How much longer do you have? How much longer do you like? She's just annoyed by being there. She wants to give the jury a mid-morning break. That's fair, but come on. You could have asked him that at sidebar when he was just at sidebar. Why couldn't you ask him there? Why do you have to do it in open court in front of the jury? So if they're hungry or they need a smoke break or they have to go to the take a powder, they're mad now. They were literally just a sidebar.
You reviewed the text stream data, otherwise known as the triggers, for the entirety of Ms. Reed's vehicle, correct?
Yes.
How many trigger events did you find in the life of the car?
Not counting 1162-2.
Let's stop there. Right.
Prior to 1162-2, there were 19 prior events.
And 19 total events, correct?
Correct.
And how many collisions were clocked by any recorder on that car?
None of the events were triggered by a collision.
No collisions before 1162? How many after?
And last question, do any of the text stream events or do any of the data that you've reviewed either yourself through Mr. Burgess's report, through Dr. Welch's report, do any of the data indicate that there was a collision on January 29th, 2022 at any time? Objection.
Ask it differently.
What did you find in terms of, I want to narrow this question to January 29th, 2022. What did you find in terms of any data regarding a collision?
Neither of the events that occurred on that date were triggered by a collision.
Thank you. May I have just a moment, Your Honor?
No collision, no collision, no collision. No collision. Thank you, Natasha. Natasha's voting for Delta Data Daddy. I know my car can connect two phones at once, and best gun losing detective says that his or her GMC also lets two phone connects, kids music, my GPS. We have a minute to scooch,
Okay.
and that's it.
Jurors, we're going to take the morning recess. There's some things that we need to do with the lawyers. We'll have you come back at 12. Save us some time, please.
Okay, they're on break, and
I see counsel at sidebar to save us some time, please.
It's all about saving time. Yannetti had a motion this morning, remember? She said we'll deal with that later. We have room to scooch. Hey, Eugenia, what's up, girl? Court Officer Eugenia. Chaka is still our mascot in the upper right-hand corner from the Land of the Lost. Land of the Lost. Remember that theme song? Lost in Space is also a good one. How long of a break is she going to give him? Well, this gives Mr. Brennan, or Brennan, whatever you prefer to call him, some extra time to go in the men's room and prep. Oh, look at us, we're in real time now. Yay. I prefer to stop the stream and talk about things as they happen in real time. There are other streamers who talk over the stream. I try and pause it. There are other streamers who wait until the end of the day to recap everything and they stay on the air for an additional 3 hours. I find that doing it in real time gives us a better chance to understand what's happening next. And that's the way I do it. If you are not happy with that, you might find someone else who is more to your liking. But for those of you who choose to stay here with me and enjoy the way that I do it, I love you with all of my heart. Love you with all of my heart. Everyone's got a different style. It's not a competition. Electron Ash says AFAIK. It was mainly that John's phone logged GPS during the 3-point turn. Through Waze, Aperture used the 3-point turn to sync the Lexus time with the GPS time. It seems like that's what they did to me, but we also learned through other testimony that the Waze clock is off because they don't sync to monatomic time. I don't know. Was that even brought in this trial? I don't know. Lone Wolf says this is how you show there is no confirmation bias. That correct, 100%. In my opinion, I agree with you. Happy Friday, Heidi. Uncertain to what subscribing means. It just means hit that little subscribe button. It's free. I don't know where you find it because I'm on my phone. The subscribe button is free. That's all it means. It's free. It means that I have a certain number of subscribers. And the more subscribers you have, the more YouTube pushes your videos out and tells people where to find us. It's like bookmarking a YouTube channel. Yes. So if you haven't subscribed, oh, you're explaining it to other people. Sorry. She says uncertain to what subscribing means. It's like bookmarking a YouTube channel. So if you haven't subscribed for Melanie, let's do it now. Free Karen Read, Crash Daddies. Yes. And also the notification bell is an important part of that. If you want to always be notified every single time I go live, set your notification bell to all because YouTube will automatically, Jill, I was just going to say that. YouTube will automatically subscribe you to like personalized notifications or just some notifications. And then when you see I'm live, you come in and you're like, I didn't get a notification. And so there's that. Hannah B says their amended reports are still wrong because they didn't show their work. Their experts can't even pin it on the girl. Right. Swing and a miss again. However, he did say that 10% of the times, 3 out of 30 times, the data would have lined up with his lock event occurring before the trigger event. Right? Right. So he's an honest witness, right? He's not a paid hack. Let me just take a quick look at these filings from this morning in which, oh, here we go. Commonwealth's motion to preclude inadmissible hearsay. The defense noticed, meaning the defense told us, Brennan says, that it intends to call 4 individuals who have phone numbers associated with a federally protected and confidential series of text messages from Michael Proctor's personal cell phones. We looked at that the other day. They've added 4 witnesses to their list who were Proctor's buddies from his elementary school or preschool text messaging group. Footnote 1, let me put this on the screen because we like receipts here and they're still on break and who knows how long they're going to be. And you guys like to read along. So let's do this the right way. This is filed this morning. And it is docket number 700. It was filed this morning at 8:39 a.m. Commonwealth's notice to preclude inadmissible hearsay. The defense noticed that it intends to call 4 individuals who have phone numbers associated with a federally protected and confidential series of text messages from Michael Proctor's personal cell phone. Footnote 1. While portions of federally protected text messages were revealed during Michael Proctor's testimony during the first trial, the records remain subject to protective orders of the Norfolk Superior Court and the U.S. District Court for the District of Massachusetts. Oh, he really wants to keep those text messages out, calling Karen Read a whack job C-word among some other class act names about her personal medical conditions. The defense intends to offer the communications of 9 individuals, only 3 of whom had partial contact names saved within Michael Proctor's personal cell phone for the substantive truth of those statements. Of note, The confidential record indicates there were a total of 38,707 text messages exchanged within this group beginning on October 18th, 2021 and ending August 31st, 2022. The defense seeks to include a limited portion of text messages attributed to being exchanged by 9 individuals that occurred over 3 years ago. So, hang on, let me get my red pen. You know how this girl loves her red pen. I disagree. The defense is not going to offer these text messages to prove the truth that Karen Reed is a whack job C word. That would be the substantive truth of those statements. They are merely wanting to prove that Michael Proctor made these text messages to his buddies. Obviously, those are his personal opinions, not truthful in any way, shape, or form, but that he wanted to pin it on the girl and that the homeowner was not going to catch any shit because he's a Boston cop too. All of these are in the text messages. They were involved in the conversations, right? So they're not hearsay. Moving on. 38,000 text messages. Wow, these guys sure do text a lot. That's only like in a 1-year period. Not even a year. 10 months. They exchanged 38,707 messages. They go to Proctor's bias, 100%. Preliminarily, it is the defendant's burden to satisfy the requirement of authenticating these communications by producing sufficient evidence to support a finding that the communication is what the defense claims it to be. Well, that is why, hello, they're calling the people who received those messages. The defense must not only establish that the communication was authored by the witness on the stand, but also the statements of others in the group, including Michael Proctor. This will require the judge to determine relevance and admissibility of each communication, depending on who authored the communication and whether it is sufficient for a reasonable jury to find by a preponderance of the evidence that each and every communication was authored by the individual member of the group. Of note, prior to authentication, no communications should be displayed or read to the jury. Footnote 2. Well, it's almost hilarious to hear Brennan argue about authentication, considering that there's no chain of custody for anything in this case, and that during the last trial, they were admitting screenshots left and right, inverted videos with no metadata that can't be authenticated, and these are text messages. Footnote 2, Bowden, which is the case here, a Bowden defense is showing the jury that the police investigation was so horrible and so egregious and so poorly done that you must find reasonable doubt. Bowden does not permit the defendant to ask questions without proper foundation or questions that are replete with unauthenticated, inadmissible hearsay solely to infect the jury. Well, see generally Commonwealth v. Avila. The more wide-ranging the defendant's attack on the police investigation, the broader the Commonwealth's response may be. Yeah, they don't want any attack on the police investigation, and the judge has already denied the defense from bringing in an expert to show how bad the investigation was. His name is Michael Easter. Furthermore, the text messages contain hearsay upon hearsay, and each statement and text message must conform with an exception to the hearsay rule. There are no applicable exceptions. Michael Proctor is available to testify and could authenticate and perhaps adopt and acknowledge the statement sought to be introduced. Okay, so are you like he's daring the defense to call Michael Proctor because he knows how bad Michael Proctor is for the what is he doing? I don't know. I really think that, I don't know. I have so many questions about his ability as an attorney that it's beyond me. Massachusetts does not recognize a residual exception to the hearsay rule. Yeah, why didn't you call him, Brennan? Hearsay is the basis for the entire case against Karen. Thank you, Amherst Ann, for pointing it out. Hearsay is Jennifer McCabe saying that Karen Reed said, I did it, I hit him, I hit him, I hit him. However, it is a statement against interest, which is an exception to the hearsay rule, but that's the entire case against Karen Reed, in my opinion. While Bowden preserves the defendant's right to attack the adequacy of the police investigation, that attack is still constrained by the rules of evidence. Nothing in the Bowden case authorizes the defendant to introduce otherwise inadmissible hearsay. Goes to bias, in my opinion. Moreover, the statements are inadmissible for the purpose of showing Michael Proctor's state of mind. Moreover, the statements are inadmissible for the purposes of showing Michael Proctor's state of mind, nor the state of police knowledge. Quote, hearsay testimony to explain the reasons for police action, however, carries a high probability of misuse because a witness may relate historical aspects of the case, replete with hearsay statements in the form of complaints and reports, even when not necessary to show state of police knowledge. Therefore, out-of-court statements to a police investigator, in this case attributed to Michael Proctor in his capacity as the case officer assigned, again, he's a case officer now, not the lead investigator, are permitted, one, only through the testimony of a police officer who must testify only on the basis of personal knowledge. Two, is limited to the facts required to establish the officer's state of knowledge. Three, is allowed when the police action or state of police knowledge is relevant to an issue in this case. See Commonwealth v. Sullivan. Right. Classic Clippy. Any defense is not allowed, says Brennan. For gifted membership, somebody was asking how you get one. I think you have to be participating in chat, I think. And I think you also have to be opted into gifted memberships. And YouTube randomly selects the gift or the recipients of the gifts. XOXO, Hank Brennan, Adam Lally, Laura McLaughlin, and Caleb Schillinger, dated today. Because, of course, we don't want Michael Proctor's text messages to come in because it clearly shows bias. And perhaps, maybe, this is what they're going to argue when, if ever, they come back. We will hear some argument on this motion that was just filed this morning. I have another filing here, filing number 701. And since we're here, we might as well look at that because it is very, very short. So let us look at that because they're still on break, mid-morning break. Docket number 701. This was filed this morning by the Commonwealth at 8:39 a.m. Commonwealth's motion for reciprocal discovery. The defense noticed, meaning the defense told us, not that they noticed it as in glanced at something, that it intends to call Kelly, well, it says here Kelly Denver, but we know her name is Kelly Deaver because we pay attention and we were here throughout season 1 and we were here for the entire pre-production on season 1, doing all of the pre-production on the season 1, in addition to post-production on season 1, pre-production on season 2, and we're here for season 2. Her name is Kelly Deaver, not Kelly Denver, but Hank Brennan's paralegal hates him. As a witness in their case. The Commonwealth moves pursuant to Rule 14 for all written communications, including prior inconsistent statements and a summary of all oral communications made to any member of the defense team. Oh, so they want all conversations with Kelly Deaver. Her name is not Denver. Remind me in chat because we're so collaborative here. Kelly Deaver, I believe, was with Canton PD, I believe. You can refresh my recollection. Kelly Deaver, I think, may have been in some of the Sallyport video in and around the alleged murder weapon. She's been on the witness list, yes. She was on the first witness list as well, but she never was called to testify. Further confirmation that Hank Brennan's paralegal hates him, in addition to the fact that in one of the motions, she actually called him Hank Brennan. And that is why we have a name tag now in the upper right-hand corner that says, "Hello, my name is Hank Brennan." She worked with Canton PD. She's now with Boston PD. What's her relevance here? She was in the Sallyport. Did she also answer a phone call at some time from someone in this case? Kelly Deaver? Oh, look at this. Jamie finally understands rage cleaning. Says, my house thanks you for that, for all of you that paved the way. I wish I could rage clean, but some people love cleaning. I'm just not one of them. Just not one of them. Still on break. She took over the dispatch desk for Sergeant Good. Thank you, Mama Bug 107. Right. So she would have been there after Sergeant Good left to go to the scene, shot home, got his leaf blower, shot back with his leaf blower, gave the leaf blower to Gallagher, who did some leaf blowing, snow blowing with the leaf blower to reveal the base of the cocktail glass and or some shards of glass, but could not find dinner plate size pieces of red taillight. And so she took over. Wait. I think she was working dispatch. Mike says she's the one that told Gallagher that it was 32 Fairview. And he responded, oh, that's not even his house. Oh, they want to get that recording in. Miranda says, was she the one that answered the call that one of the troopers called about when the neighbor called in to see what happened? No, but I guess she took over the dispatch desk when Good was busy going or shooting back to his house, get the leaf blower shooting back. Excellent. Excellent. They want to know what Kelly Deaver is going to say. You know what? Here's the thing. She's been on the witness list since the beginning. She was on the witness list at the first trial. You know who she is. She used to work for Canton PD. You have the ability to call her and talk to her. You can talk to her as much as you want, but apparently maybe she has refused to speak with them. Right? Interesting that Kelly Deaver does not want to talk to the prosecution. What does that indicate to you? 18 Wheels of Outrage is here, gifting 5 memberships. Hope you're not driving mad today. No road rage today. We have a lot of truckers who listen to us, a lot of construction crews. Shout out to all the mail carriers out there, everyone in a salon or a nail salon or a hair salon watching on the TV. Trying to curb the outrage today. It's not always easy, but we always have fun here. Lisa Perez, thanks for your 20. Listening to you while going to my own lawyer. Why am I more concerned about this case than my own? Free Karen Reed. Here's a tip. I don't give legal advice on the channel, but I'll give you a tip. When you're going to visit your lawyer, make out a list of questions before you go, especially if your lawyer bills by the hour. That way, you're not wasting time trying to think of your questions. You have all of your questions in a list, and you can minimize their hourly rate. Thanks. I'm here to help. Thank you, Lisa. Appreciate you so. My nurse Cal says Proctor was fired for his conduct in this case. Qualified immunity would be revoked. Therefore, making his opinion in text messages inadmissible. Making his opinion in text messages admissible. I don't know if that would be an exception to the hearsay rule, which is what Brennan is arguing. But we will hear from someone on the other side who will argue the opposite way. I don't know if that would be an exception to the hearsay of the text messages. I need to digest it and think about it a little more. That was a cold read for me. But I don't see why the recipients of those text messages could not authenticate them. If there are 38,000 text messages in that chain between Chippy Bear Proctor and these other boys who are now men, they've been communicating for 8 months. They know that's Chippy Bear Proctor's phone number. They know those are his messages. I don't see what the problem is. They're going to authenticate him. Say, I got him from his number. I'm on the text chain. Here's what I said. Here's what he said. I received him. What's the problem? They're not offered for the truth of Karen being a whack job C word with a weird Fall River accent and a flat butt. They're not offered to prove the truth of that, just that he did in fact say that, which is causing the long bias. I don't know why they're taking such a long break. I'm not in the courtroom. I'm here with you. I don't know. We don't question. We just do. Chloe Albert's Revenge says, I don't even think Hanky Fudd uses the paralegal. He types these motion with ChatGPT in his feet. No, he actually does. She wears a pencil skirt. She's been in court every day, as far as I know. And Nurse Kim has some theories about the paralegal and Mr. Brennan, which I'm not going to repeat here, and neither are you, because we don't talk about rumor, gossip, innuendo, but we do love Nurse Kim. And I think she was in court and saw it, right? Right, exactly. She gives an instruction to the jury, like you have to, in order to, take these text messages into consideration, you have to believe that the person sending them is really the person sending them, the person receiving. Yeah, she's given all of these instructions for other texts. Garina was the one who read the text messages into evidence between Higgy and Karen. Higgy got no game. You're hot. How long have you thought that? Where is this relationship going? Total simp in his 2-week relationship of text messaging. He was ghosted and mad about it. But he's arguing, I guess, because these are federally protected. They can't come in. They came in last trial. Proctor read them in there. And when he said C word on the stand, the judge said, "Are those your words?" And he said, "Yes." And she said, "Then I need you to say the real word." And he had to say it, and he was publicly shamed. Marilee is from South Africa. South Africa's here. Detective in another country, shocking case. If defense calls witness and asks one question, "Did you see a body?" It would restrict cross to only that. Yet, right? Yes. Yes, it's supposed to. It's supposed to. And that's why yesterday's redirect for Judd the Dud Welcher, thank you, girl with the sunglasses, when he asked about the Signal app, whether they used the Signal app that was intentionally encrypted to hide their messages, and he said no. Maybe Alessi opened the door when he was asking about communications between Burgess and Brennan and getting picked up at the airport by Tully. Maybe. I guess you could make that argument. But now he's going to go back and point out that using Signal is so nefarious. So nefarious. That's how he pronounces it. We say nefarious. He says nefarious. Thank you for asking. Omasinski Fine Art on Insta. Aiden Carney is in the courtroom today. Yay. AKA Turtle Boy. He was reporting on the jury reactions. And going back to an hour ago, he says, "I will be tweeting the rest of the day" in John DePetro's voice. An hour ago, he says, Aiden, "Alan Jackson has a mastery of the courtroom. Jury is eating out of the palm of his hands. Looks like they're wanting more from him. Jurors attentively taking notes. Seem very impressed with this witness." That was DiSogra. "Hank Brennan looks defeated, like he knows it's over." And then he keeps tagging John DePetro in his tweets, and he's probably sitting a couple seats away from him in the courtroom. I hope they don't come to blows during the break. I hope that's not why this is delayed. I am not reporting that. That was a joke. It was a joke. Please do not report my jokes as fact when you go on other channels and say, "Melanie reported this, that, and the other." Not true. Then he said, "Wow." This is Aiden Carney. "Matthew DiSogra found out that John's phone was actually 20 seconds faster, not slower than Karen Reed's Lexus data. Hank Brennan looks to be on the verge of tears. Lally seems completely checked out. Not good for Commonwealth." Jury seems enthralled by these slides showing that man Shannon completely effed up the data. Many of them seem to be thinking, quote, "This is much more compelling than painting yourself blue," end quote. "Hard to come back from this for Hank Brennan." Tagging DePetro. Jurors looking aghast, like they are just realizing they've been lied to this whole time by Hank Brennan. Okay. All the blue is very bright and the camera's putting a blue tint on my teeth too. Thank you for your I don't know, is that a criticism? I don't know. I don't have any blue filter on. This is my real eye color, but if my teeth look blue, it's because of whatever. I don't have time for that. Covering a trial. Please, for the love of the traveling Mary, get a grip. Jurors alert and on the edge of their seats after Matthew DiSogra testifies that it's most likely that John's phone was interacted with after man Shannon claims he was hit by a car. One of them seems to mouth, "Feed me more PowerPoints, Daddy Jackson." Wow. No, they don't look blue. Thank you. Maybe it's your device. Maybe your device needs to, maybe you need to adjust the color on your television. Next, Aiden tweeted 45 minutes ago. This is not a short break, by the way. Auntie Bev and Hank Brennan do not want jurors to know that 3 out of 30 is 10%. Thank you for tweeting what I was thinking. Many jurors seem disturbed by this and have begun to do math on their own. Many are younger and maybe using Common Core, so it will take longer. It's on fire today. Aiden Carney and Fuego. Jurors take notes as Matthew DiSogra testifies that the text stream data does not show that a collision occurred. This is over, folks. Female jurors look relieved that they no longer have to stare at Paul O'Keefe's crotch shots. Many of them last time were visibly disturbed by that. Please don't run with that in the chat. I was demonetized, by the way, on Wednesday's stream as not friendly to advertisers, I think due to the graphic content of the dead body, because I minimized those slides. I took them off the screen immediately. I appealed it. Apparently it was confirmed on manual review, and I'm wondering if every creator from Wednesday was demonetized because of those graphic photos. My eyes look wild. Yeah, maybe I'm possessed like Chaka. Do we need Chaka back in the corner? That was from the episode Possessed. During sidebar, I glanced at John DePetro, who seemed to whisper to me, "Listen, Turtle, Hank is in big trouble." These are jokes. Aiden says, 35 minutes ago, "Okay, fine. When I am giving you actual jury reactions, I will not tag John DePetro. That way you can differentiate between the two." Oh, so I guess some people were thinking that he was saying, okay, got it. Aiden then says, "Call me crazy, but when the Lexus text stream data shows that no collision occurred in Karen Reed's vehicle on January 29th, it seems like that means case closed." Don't remember any testimony like this from the defense in the first trial. No, they didn't have DiSogra during the first trial, right? And apparently, according to that witness, Matthew DiSogra, whose expertise is in specifically Toyota text stream data, there is a way, and I forget exactly what it is, that the text stream data or this EDR will record a collision. No collision was ever recorded in Karen's vehicle from the time she bought it up until key cycle 1162, or I think he said at any time thereafter. Right. So thank you for asking. We will keep up with Aiden's tweets as we can. Octopoppet says no responsive documents exist. Easy answer. Right. We don't have any statements from Kelly Deaver, if that's what you were referring to. Alley Cat, shout out to my dad, Diesel Dave, who's new to your channel. Hey, Diesel Dave, what up? Watching from Rehoboth. And we are outraged. Love you, Dad. Okay. I know there's a Rehoboth, Delaware. I guess there's a Rehoboth, Mass. Am I pronouncing it right? Because the other day when I tried to pronounce Peabody, which you guys are telling me is Peabody and not Peabody. Peabody, the chat, is it Peabody? Are we putting the accent on the D? Peabody? And is it Rehoboth? Welcome to Mr. Diesel Dave and his daughter Alley Cat. She's got good taste, your daughter. Man Shannon can bite me with a BYTE is awesome. Yes. And it's Peabody. All right. I'm getting it, you guys. Look, I got Worcester, like Quincy. It's next to Dighton. Canton. I know Canton. You don't pronounce the T. It's just Canton. Yeah, 40-minute break. You know, maybe she's making some phone calls back there. Who knows? So happy I have the day off from work. I can keep my language under control listening to Brennan. Thanks, Melanie, for keeping us semi-sane. That's why we like to keep the language clean too, because like I said, we're on the wall in many a hair salon, nail salon, construction workplace, on Bluetooth speaker, and we don't want anybody falling off the scaffolding. Or if customers are there, we need to, keep it classy. Elizabeth Ann, oh, thank you so much for your compliments. Says she wouldn't be anywhere else. Thanks for keeping your channel classy and the mods for blocking the trolls. Yeah, here's the thing. Has anybody trolls aren't here, so they won't be able to answer this. But has anybody been sent to Block Island today? Because the New York Post has breaking news. And so usually what I like to say is we have a one-way passes to Block Island, boarding passes. We even have an emoji for Block Island. Block Island is a real place. It is in between Long Island and Massachusetts or Rhode Island. You have to take a ferry there. You can't bring your car. I don't think maybe one ferry you can bring your car, but whatever. Not the point of my story. It's a lovely place. It's like Stephen King Town from Hell. There's like no newspapers, no TVs, kind of like that. Anyway, it used to be. It is lovely. It's a lovely island in between. You can take a ferry, I think, from Rhode Island, Massachusetts, or Orient Point, no, or Montauk. I think it goes from Montauk. Look what's going on right now on Block Island. A 20-foot shark is trailing behind a tiny boat on Block Island, sparking Jaws comparison. There's a shark in the pond. So if anybody has been sent to Block Island today, look out. Says Rhode Island diners got to feast on. Look at the New York Post for breaking all the news and for my family group chat for sending this to me. You don't want to go to Block Island today. Got to feast their eyes on a massive 20-foot shark lurking dangerously close to a small boat in a pond on Block Island, according to authority. In a pond? Local Jen Seebeck recorded the humongous dorsal and tail fins of the blood sniffer cutting through the water on Memorial Day while chowing down at a local eatery, Dead-Eye Dick's. I mean, where else would you find a place called Dead-Eye Dick's other than Block Island? Located on the Great Salt Pond, the Atlantic Shark Institute reported. Okay, here's some fin photos. Is this a video from the actual boat? I don't know. They're still on break. Not my fault. Fan is still up. The sight of the toothy predator in the small body of water brought to mind the classic film Jaws, which is celebrating its 50th anniversary. There's a shark in the pond, one person could be heard shouting in the video, a reference to a line in the Steven Spielberg classic. Videos showed one small boat motoring in the opposite direction of the quick-moving shark that was of an unknown species, according to the Institute. It appeared to be about 20 feet long, according to bostongot.com. So let's see. Oh, here's the video. Let's play it.
Oh, there it is.
That looks like a big-ass shark. It's a basking shark. Somebody said it's a basking shark. It's a basking shark. I don't know what a basking shark is, but guess it was on Memorial Day. Crazy, right? Sharks are arriving in Rhode Island daily as water temperatures continue to rise and more species of shark find them suitable to their liking, the Atlantic Shark Institute wrote in their post. Hopefully this shark will find its way out of Great Salt Pond soon and continue on its way, the Institute added. Block Island was recently named one of the 10 best summer destinations in the U.S., according to USA Today. Warmer waters off the coast of Long Island are also drawing in the man-eating fish. Fan is still up. A monster great white shark was spotted along the shores of Montauk, which is a popular feeding ground for the toothsome predators, earlier this month. Drone footage showed. Experts said the sighting, though a bit early in the season, was normal for this time of year. As summer draws more fish to the shores, experts say sharks will follow, but chances of an unwanted encounter are low. How many of you refused to go in the ocean after seeing Jaws when you were a kid? Or however old you were at the time that Jaws came out? We're going to need a bigger boat. Yeah, so we send the trolls to Block Island, and that's where they go. I don't know how many have been there today. It's a big one. Basking shark is a big one. Wow. All right, look at all the things we learn here. It's not just trials. It's not just law. It's not just comedy. Sometimes we actually learn a thing or two. I don't know. Should we put Michael Proctor up here in the right-hand corner for a little while? Here we go. Formerly dishonorably discharged, disgraced Trooper Proctor. I guess Hank Brennan really wants the defense to call Michael Proctor. Why would Hank Brennan want the defense to call Michael Proctor? Why would he object to Chippy Bear's friends being called in to authenticate the text messages showing the bias of Proctor? How about do it all? Do it all. Call all his friends in to talk about what a jerk Proctor is. Maybe there's some other biased investigative texts, and maybe he's been texting to his friends for a long time about investigations. Maybe he looks for nudes in a lot of girls' phones. They're back. Well, I'm on real time here. I think. Court TV might be a second or two behind on the computer than on the TV, but send Proctor to Block Island to swim with the shark. I'll allow it. Here's Leanne. Welcome, Leanne Lee here. It's the first time watching this trial, and so glad she's watching with us all. This is terrible. Poor Karen and Officer John O'Keefe. Today's not a half day. We're going to have a full day today. But you know they like to go to lunch at 1, and it's 12:05. Oh, thank you, Chrissy Mel. We have financial advisors to our list of listeners in Boston. Your show is always a topic. Love that. Yay, financial advisors. Thanks for watching. Big Boy says I'm nailing the pronunciation of Peabody now. Thank you.
Back in session, you may be seated.
All right, Mr. Brennan.
Uh-oh.
And Mr. DiSogra, I'm going to ask that you keep your voice up because we're going to try and keep the air conditioning on. And the fans, it's a little stuffy in here. So if you just speak directly into the microphone, that would be great.
Already threatening about the air conditioning. First time this trial.
May I proceed?
Please.
Good morning, sir. Good morning, sir. Sir, are you trying to offer an opinion suggesting that Ms. Reed's Lexus never hit John O'Keefe on January 29, 2022? Objection.
I'll allow it. Is that what you're doing?
Is that your opinion?
No, sir.
Are you offering an opinion that Ms. Reed's Lexus?
I'm sorry. Those are two different questions. Are you offering an opinion that he was not hit by a car? And she said she would allow it. And then he said, is it your opinion that he was hit by? You got it. The difference is very subtle, but it's very, very, very important. Okay? Listen to how he changes his question.
Good morning, sir. Good morning, sir. Sir, are you trying to offer an opinion suggesting that Ms. Reed's Lexus never hit John O'Keefe on January 29, 2022? Objection.
I'll allow it. Is that what you're doing?
Is that your opinion?
No, sir.
Are you offering an opinion that Ms.
Is that your opinion? And then he says, no, sir, as if, no, I don't think he was hit by a car. No, that's BS. Do you see the difference? Not, is that your opinion? Are you trying to offer that opinion? Did you even opine on that? Was it part of your analysis? This has to be cleaned up on on redirect. I'm getting so confused about which party is which here because the prosecution is playing defense.
Reed's Lexus never got in. Is that your opinion?
No, sir.
Are you offering an opinion that Ms. Reed's Lexus never got in a collision before?
The way I stated it was none of the prior events were triggered by a collision.
What I'm asking you, are you offering an opinion that Ms. Reed's Lexus never got into a collision before January 29, 2022 or on that day?
No.
So when you were talking about collisions to the jury, you weren't making any suggestion that that Lexus was not in a collision, were you?
I think you threw a double negative in there. Can you just clarify?
He does
I think you
that.
meant, yeah.
You are not suggesting to this jury that Ms. Reed's Lexus did not ever get in a collision before?
No.
Okay. You're just saying that there's no data on the text string to suggest a collision.
Specifically, none of the events were triggered by a collision. That's
Prior to
Text stream data can
1162.
be triggered by a number of different things other than a collision. Isn't that true?
correct.
And in fact, when you talk about text stream data, you know that text stream data does not record a collision. You know that.
A collision is not one of the triggers. That's correct.
Right. So when you were saying it wasn't triggered by a collision, it's never going to be triggered by a collision ever on text stream data.
Not the collision in and of itself, correct?
Right.
It's on other
So
data.
there's other things that will trigger text stream data,
Correct.
like sudden acceleration,
only acceleration trigger that I'm aware of on TechStream is if there's a large acceleration during what Lexus calls a PCS, or a pre-collision safety event. But a large acceleration on its own, I do not believe is one of the triggers.
Are you sure you know a lot about TechStream data?
Yes.
Sustained.
Are you sure you know a lot about TechStream data? You got to hear that again. He's got nothing. He's desperate. He's grasping at wet paper straws, Mr. Brennan, and so he's going to be a dick.
Are you sure you know a lot about TechStream data?
Yes.
Sustained.
Do you know a lot about TechStream data?
Yes.
And you're saying that if a car accelerates over 30%, in and of itself wouldn't initiate a trigger?
I'm not sure I understand.
You just said pre-collision is the only time sudden acceleration, from your perspective, would cause a triggering event. Now, I'm asking you,
I'm allowing this.
if someone accelerated Ms. Reed's Lexus at over 30% acceleration, would that cause a triggering event?
I am not sure what you mean by 30% acceleration.
Accelerator, 30%.
Accelerator pedal.
Yes.
Oh, yeah, there's a lot of triggers.
Gas pedal.
There's a number of ways that these VCH events can be triggered based on the accelerator pedal angle. I think, is that, yeah.
And what is the percentage from your experience that would create a triggering event?
There's various. Toyota, Lexus calls it high, medium to high is what they put it.
Do you have a number? Do you know the actual data on what percent of pressing the accelerator on the same Lexus as Ms. Reed's would create a triggering event? Do you know?
Off the top of my head, I don't know the exact percentage down to this percentage point, no.
There is something different than the TechStream data. That's the EDR data, correct?
Yes.
You would not expect, it would be abnormal for the EDR to register data based on a side swipe between a 6,000-pound Lexus and a 216-pound person, wouldn't it? Objection.
I'll allow it.
That would be abnormal to register that data in the EDR, wouldn't it?
I don't know.
What about a 115-pound person? Hold on. He's so confusing. Based on the side swipe? Hold on.
Not expect, it would be abnormal for the EDR to register data based on a side swipe between a 6,000-pound Lexus and a 216-pound person, wouldn't it?
216-pound person.
I'll allow it.
That would be abnormal to register that data in the EDR, wouldn't it?
I don't know if I would use the word abnormal, but I would state it that there's a minimum threshold to record in the EDR, and a pedestrian impact generally wouldn't meet that.
I'm sorry.
A pedestrian impact generally wouldn't meet that, but I don't want to make a blanket statement as if it's always the case.
You're saying it would meet that?
Would not.
Would not. Okay. And a side swipe or a clip has less force and impact than a head-on collision, depending on the speed, correct?
Generally, yes.
When you are discussing the triggering event, that is the moment that something registers to the car to capture data in the text string, correct?
Correct.
So if I was to suggest 30% of depressing the accelerator pedal would cause a triggering event, would the triggering event be when it reaches 30%?
Yes.
The event data captures potentially part of an event, doesn't it?
I think we're into semantics a little bit, and I think it depends on what you mean by event.
Exactly.
Because previously we'd been talking about an event as the data, but event can mean a lot of other things.
If an event's only 3 seconds long and 10 seconds of data is captured, then the data will capture more than the event, correct?
Correct.
If the event is longer, 15 seconds, 20, 25 seconds, and the data is only captured for 10, the text stream data only captures part of the event.
Correct.
Fair to say?
Very fair.
So when you're looking at the data, it doesn't tell you about the entire event, correct?
The data only tells us about the window of time the data captures. There's no way to know beyond that from the data.
All of your equations and pluses and minuses and graphs you're talking about deal with the 10-second text stream data that was captured, correct?
They deal with event 1162.2, right, and the 10 seconds it's comprised of. Actually, they really just deal with the end of the event. That's what everything in the Aperture reports referenced.
Fair enough. But it doesn't deal with anything that could potentially happen after those 10 seconds, does it?
No.
Or anything before?
No, it does not.
The triggering event is spot in the middle, captures 5 seconds before, 5 seconds after.
Approximately 5 seconds. It's not exact.
And you would have to look elsewhere for evidence to know what might have happened before. Yes?
Correct.
And you'd have to look elsewhere for evidence to see or determine what happened after.
Yes.
Do you know at the end of this triggering event, that 10-second window of data, do you know what happened with the defendant's Lexus after that 10-second of data?
No.
You have no idea, right?
I don't.
Okay.
Okay.
I want to just ask you some questions about your background and then leading into this case, if I could.
Did you use Signal to communicate with the defense?
You have a bachelor's degree and a master's degree.
That's correct.
You've worked for your company for some time.
Coming up on 13 years next month. Correct.
You've advanced through the company.
Yes.
You presently are the director of engineering.
Yes.
Are you ACTAR certified?
No.
What is ACTAR?
ACTAR is a body that basically offers a certification in accident reconstruction.
Do you offer services as an accident reconstructionist?
Sometimes.
And you have been hired and come into court and offer opinions as an accident reconstructionist?
In the singular time I've testified in court, it was not specifically for accident reconstruction. It was data analysis.
Okay. You continue your education and you go to a number of different trainings and seminars as well as teach, correct?
Regularly.
And when you regularly go to continuing education, you have quite a bit of continuing education that you've been through, haven't you?
Sorry?
You've been through quite a bit of continuing education.
Yes.
You focus as part of your specialty on EDRs, don't you?
That's correct.
Event data recorders.
Correct.
In fact, when you promote your services, that's one of your real specialty, isn't it?
Correct.
And it's something that not only are you schooled on and you go through continuing education, you're well published, aren't you?
That's correct.
And in your publications, you speak primarily about EDR type information.
Yes.
And that's something you are well skilled in, isn't it?
Yes.
Now, forensics or data forensics is a wide field, isn't it?
It is.
And you can do some things or many things in it. But oftentimes people specialize in parts of data forensics, don't they?
Generally, yes.
Well, speaking of you, you specialize in EDRs, true?
Yes.
There is a difference in different subspecialties, isn't there?
In general,
Oh, yes.
yes.
Stupid
Okay.
question.
Now, are cell phones, is that a subspecialty in digital forensics?
Yes.
Is that something you're a specialist in?
No.
iPhones, are you a specialist in iPhones?
No.
Have you ever taken any specific training on mobile forensics?
No.
Have you ever written any papers on mobile forensics?
No.
Hey, have you ever promoted yourself of having any type of subspecialty as an expert in mobile forensics?
Never.
In any of your continuing education, and you have a vast amount, have you ever taken any classes or seminars in mobile forensics?
No.
He didn't analyze the phone.
have you ever taken any class or study about variances between infotainment systems and mobile forensics?
Classes? No.
Have you ever attended any seminars on variances relative to mobile forensics?
No.
Have you ever testified about variances in mobile forensics before you testified in this court today?
No.
He's not testifying about
Have you
mobile
ever
forensics
published
now.
anything to do with variances in mobile forensics?
No.
In this case, you had an opportunity to review a number of reports from Dr. Judd Welcher. Yes?
Yes.
And
Breaking nudes. Michael Proctor on the brain. Breaking news. Aiden Carney is reporting that Lucky Lochran is in the building. Lucky Lochran is in the building. Take that for what it's worth, but perhaps we'll hear from Lucky today. I'm up all night to get lucky. He's the plow driver. For those of you who don't know, he did not see the body on the lawn. Can't wait to see how Brennan treats him if he's there, if he's testifying today. Yay, Lucky. We love Lucky so much. This is only the second time DiSogra has ever testified in court. And I think he's doing a great job for someone who has only testified one time before this. So maybe we have Lucky to look forward to after this.
Mr. Shannon Burgess,
Correct.
in reviewing those reports, you've offered your opinions and analysis. Did you ever engage in actually any efforts or study in this case to obtain data?
Could you maybe clarify what specifically you're asking?
Yes. Did you ever yourself, not watch someone else do it, did you ever download or obtain data in this case?
No.
Did you ever test Miss Reed's car?
No.
Did you ever get an exemplar vehicle to run any tests?
I did not.
He's relying on your experts.
Did you ever do any
You should appreciate that.
actual testing in this case?
No.
And so your role is to look at other people's work and offer opinions and criticisms, basically.
And provide some clarity to the work, but generally, yes.
Clarity for who? Who asked you to provide clarity?
Duh.
My clients in this case,
You what?
Mr. Jackson, my client.
You're what?
Did you ever speak to me?
No.
As an expert, when you analyze data, whether you actively got it yourself or not, do you ever give an opinion in paper called a report? You ever write a report?
Yes.
And you've seen reports in this case that you've looked at, correct?
Correct.
A number of reports by Mr. Burgess,
Correct.
report by Dr. Welcher,
Also correct.
reports that you're critiquing, right?
Correct.
Did you see Ian Whiffin's reports?
I did not.
How about Jessica Hyde? Did you see her reports?
I did not.
You were asked to consider information from Mr. Whiffin's report.
No.
Well, you were asked to assume that the last user interaction on John O'Keefe's cell phone was 12/32/09.
That was stated in Dr. Welcher's report, so I started my analysis at that level.
So none of the information did you actually personally go and vet or analyze or make any determinations about? You're just critiquing written reports.
Correct.
Well, as an expert coming into court and testifying and having opinions, you put together a PowerPoint, didn't you?
Yes.
Why didn't you ever put together a report to share the basis of your opinions and the process you went through to arrive at your opinions before you came into court?
Primarily, I wasn't asked to, so I didn't do it. I wouldn't commission work without being asked to do it.
It's expensive.
And number two, the extent of my work beyond building the PowerPoint was just basic addition, just adding numbers together that already existed in the Aperture reports. So there wasn't a tremendous amount of complexity to what I engaged in.
What about your work product and your calculations? Did you do all this in your head, or did you type it out and go through a computer program? How did you do it?
I used a calculator for most of it, and the tables in my PowerPoint were generated in Excel, which has some calculation capabilities.
Were you ever asked not to write a report?
No.
You had provided an initial PowerPoint,
Yes.
and then you received information from Mr. Burgess,
Yes.
and then you added new slides to your PowerPoint.
That's correct.
Mr. Burgess's report was May 8th.
Yes.
You provided your PowerPoint on May 25th.
Correct.
We saw the
Did it
date.
take you that long for the calculations between when you got the report and May 25th to put together the new presentation?
And
No, it didn't.
Why did you wait until May 25th to provide the new information?
we had other
That's when I was asked to do it.
What do you mean by that? I just want to see what the date is today. Today's the 30th. When you finished your PowerPoint on May 25th, did you send it to the defense on May 25th?
Yes, I did.
But they had a copy of your PowerPoint on May 25th. Don't be shy.
No, I'm pretty
Don't
sure.
be
it was the
shy.
25th.
Don't be a dick. How about don't be a dick? You turn it over in the middle of trial. You think maybe he has other clients? Maybe he's got other things going on. Maybe this isn't his only case. And you're going to whine now that it's trial by ambush because you don't understand that he now just destroyed your witnesses and all he used was their data. He took their data as true. Listen to that again.
Your PowerPoint on May 25th. Don't be shy.
No, I'm pretty sure it was the 25th.
So sustained.
Don't be shy.
Yeah, if it wasn't the 25th, it would have been maybe the day after, but it's dated the 25th. I'm almost positive I provided it on the 25th.
There's
Yeah.
no reason for you to hold on to it for a couple of days.
No, I think it was the 25th.
Do you know when it was provided to the Commonwealth, that report?
No, I don't.
In the 25th, the report
How would he?
you provided to the defense on the 25th. It had new information, new improvements in it, didn't it?
It had the information from Mr. Burgess's supplemental report. That was the additions.
Why did you wait until the 25th to put it together?
That's when I was asked to do it.
Who asked you?
My clients, Mr. Jackson,
He said, please have this on the 25th.
we had a phone call on the 25th and discussed Mr. Burgess's supplemental report. During that phone call, he asked me to update the presentation, and I did so, and then provided it.
How did the date of the 25th come about? Why the 25th was the date you provided?
That's when he requested it. I think it was a Sunday, actually.
Apparently basking sharks are harmless, two people have said in the chat.
When you first got involved in this case, it was
They eat
last fall.
plankton.
Correct.
And at that time, you received some information that Mr. Burgess wanted to look at the text stream data or the different modules on what you later learned was the defendant's Lexus, correct?
Correct.
There was a proposal from Mr. Burgess. Mr. Burgess wanted to go back to the car and look at the modules to try to download more information from them, correct?
Correct.
And you then got involved to look at what his request was, the procedure that you wanted to follow.
Yes.
When you did that, were you given any materials about what had happened before you and Mr. Burgess both got involved?
I don't recall specifically, and I don't think so. I think I was just provided the notice of testing that was to be done.
Well, you ended up drafting an affidavit.
I did.
And in drafting an affidavit, you pointed out some oversights of Mr. Burgess, didn't you?
I did.
Determining the oversights required some study of actually the data and the information that was available, wouldn't it?
It would.
So can we presume that before you wrote the affidavit pointing out the oversights, you had looked at other materials?
If I recall correctly, the notice of additional testing from Mr. Burgess contained attached to it a whole report by him documenting why he thought there was an inadequate initial acquisition, why he thought the sizes were wrong. So I don't remember referencing anything beyond all the information that was contained in that. And whether that was combined by somebody else or not, I don't know. That's how it was provided.
Did you end up looking at the report of Ms. Gaffney and what had happened in the past with the download and search?
He's asking about Gaffney's report, but he needs to find the mic.
If I'm remembering right again, I think Ms. Gaffney's report was also attached to that same singular file.
You learned that the defense expert, Ms. Gaffney, had downloaded data from chips, correct?
Correct.
And Mr. Burgess was asserting that there was information missing and believed that there was missing information from the chips.
Correct.
In that form, it's sustained. It's stricken.
My apologies. The conclusion Mr. Burgess had is that he believed there was missing information from the chips.
He did. He miscalculated the size of the chips.
Did you do any
Bits and
study to
bytes.
see if there was actually information missing from the original download?
No, I looked at the data sheets for the chips and then immediately realized what the error was. The data sheets specify a size in megabits or gigabits. And Mr. Burgess had written his report in the context of megabytes and gigabytes.
Why is Hank Brennan highlighting his own witnesses' incompetence? Why would he do that? Why would he further discredit his own expert, Shannon with one hand man Burgess? Why would he do that? That is so stupid. That is so stupid. Listen to this again. Why doesn't he talk into a mic? You notice he only screams into the mic when he thinks he's right about something. And then as he realizes that his case sucks, he moves further and further away from the mic. His distance from the mic is directly correlated to his level of confidence. That's my opinion.
It's stricken.
My
I want
apologies.
to hear what was stricken again. Let's go back.
Missing information from, there was information missing, correct?
Correct.
And Mr. Burgess was asserting that there was information missing and believed that there was missing information from the chips.
Correct.
In that form, it's sustained. It's stricken.
Because he can't testify about what Shannon Burgess knew or didn't know.
The conclusion Mr. Burgess had is that he believed there was missing information from the chips.
He did. He miscalculated the size of the chips.
Did you do any study to see if there was actually information missing from the original download?
No, I looked at the data sheets for the chips and then immediately realized what the error was. The data sheets specify a size in megabits or gigabits.
Makes
And
no
Mr.
sense.
Burgess had written his report in the context of megabytes and gigabytes.
And then you asserted, or you took the position in your affidavit, that there should be no further chip off, no further study of those chips, other than to ensure the amount of memory was sufficient.
It's not how I recall specifically what I said.
Well, let me read it because I don't want to try to.
No, don't read it. Show him
Please.
his report.
Mr.
Objection.
Burgess proposed protocol labeled
Burgess's
chip
report.
off acquisition is unnecessary because the file size of the acquisition performed by Ms. Gaffney already matches the expected memory storage capacity of the components.
That sounds accurate.
If you want to see this, I don't want to read from the document. If you need to see it for action, just let me know.
That's fine. I trust your reading.
However, an acquisition may be conducted for the sole purposes of ensuring the contents of the memory chips have not been altered since the last testing by recording the checksum.
Yes.
Did it cross your mind at that point that there was important data in those modules that was not seen or recovered or obtained by Ms. Gaffney?
No.
Did you want to know when Mr. Burgess was looking for more data, more information, what he thought was missing?
He stated, I think in his report or affidavit, I'm not sure what it was, but he stated what he thought was missing was there was a physical size difference. So he thought there was not corrupt data, but just missing chunks of data.
Log on information, you've heard of that. Ignition on, ignition off information
Yes.
in an infotainment system. That's important information when you're reconstructing an accident, isn't it?
It could be.
Well, you read information in this case, pretty important in this case, wouldn't you say?
Yes.
And so you would not want to engage in that process without this pretty important information, would you?
Which process?
Of an accident reconstruction?
He's not there to do accident reconstruction.
Sorry. So can you restate it, the whole question?
I'll
Yeah.
ask it again.
Yeah.
You said you have some experiences with accident reconstructions.
Yes.
Don't you want all the data available? More data, the better?
Generally, yes.
You wouldn't want to ignore data on purpose, would you?
No.
I mean, as a data analyst, the more data, the more you get to look at.
Yes.
And so the power log on information that actually has date and time, that's critical in an accident reconstruction, isn't it?
In some accident reconstructions, in some, there's no debate about when a vehicle was on or off, but if there is, then yes.
Not just on and off. The power log on and off gives you the date and the time that you can match with the text stream data, correct?
Yes, it does.
Because you know text stream data itself doesn't have date and time.
It can, this vehicle didn't. It can, but this vehicle did not.
This had a running time instead, like
That's
a stopwatch.
Correct.
So this data that was not found.
I'm sorry, I have to go back a question because I can barely hear him and I know you can't, but that sounded like an important question. So I want to repeat it to you because a lot of you are saying that you cannot hear him.
Off gives you the date and the time.
In some, there's no debate about when a vehicle was on or off, but if there is, then yes.
Not just on and off. The power log on and off gives you the date and the time that you can match with the text stream data, correct?
Yes, it
Because
does.
you know text stream data itself doesn't have date and time.
Text stream data itself does not have date and time in it, but apparently there's a power on, power off that does have a date and time.
It can, this vehicle didn't. It can, but this vehicle did not.
This had a running time instead, like
That's
a stopwatch.
Correct.
So this data that was not found during the initial process, that was critical data at the time.
I don't think prior to the process, anyone knew that this particular Lexus infotainment system stored those key on and key off times.
Right, the only person that found this out was Shannon Burgess.
He found it in the process, but I don't think anybody knew in advance of this case. There was nothing out there about it. So to my knowledge, this is the first time that this specific data has ever been released into the wild.
Into the
But
wild.
it's on the board there, someone who was
It is the wild.
or got creative, they could maybe find it.
Yes, more so to your if got creative, because I don't think anyone would have been able to have the foreknowledge that there would have definitely been that.
Shannon Burgess did.
Assisting.
Shannon Burgess did. He's wicked smart. He's trying to rehabilitate Shannon Burgess through this witness. Let me know if you think it's working. To be clear, no one is impressed by Shannon Burgess, said Turtle Boy on Twitter. Just now, somebody said.
I don't think anyone would have been able to have the foreknowledge that there would have definitely been that.
Shannon Burgess did.
Assisting. I'll strike it.
Move
And
to
when
strike
Shannon
it.
Burgess went to obtain that data that everybody else overlooked or didn't know about, you went with him.
Yes,
So you had a process where he was going to now control the data and take the information that was left behind and remove it from the infotainment board, correct?
he actually never specified anything about the SD card in that initial notice. So it was a departure from his protocol, and it was a little surprising to me when I got there
Interesting.
that the protocol was written with a specific focus on a number of other chips. And it became very apparent to me very quickly that the focus was not on those chips, and the focus was on this SD card that had previously been unmentioned. There was
Ah.
nothing in there about that prior to that.
Did it offend you, or were you impressed?
The old bait and switch. The old bait and switch. Oh, did it offend you? Hold on.
Had previously been unmentioned. There was nothing in there about that prior to that.
Did it offend you, or were you impressed that he had found that?
I was a little confused because I went into it with an expectation. Generally, if we write a protocol, we adhere to the protocol. If we're going to deviate, we have a discussion about deviations. So I was just surprised. It's not customary to sort of shift out of nowhere. But other than that, I did not know what to think of it because I'd never heard of that.
Did you give any input? Did you have any knowledge about the SD card and how it worked?
No,
So when you watched Mr. Burgess remove the SD card, did you appreciate he'd have to engage in what you call reverse engineering?
he did not elaborate to me exactly what his whole process was at first. It sort of came out as time progressed through the first day in his office in Texas. And then I learned more as we moved to the second testing in Massachusetts. But he didn't explain it to me in one go.
Kind of like this whole entire case. They keep changing their theory. It's bait and switch. Nobody knows what anybody's doing here, including us. We still don't know how the taillight broke or that John O'Keefe was hit by a car or where any of the evidence is. Sir, you are not the only confused person here.
Massachusetts. But he didn't explain it to me in one go.
Did you, at that point, understand or appreciate the relevance of the SD card relative to the infotainment system and what it could do as far as the amount of information that could then be available?
He never spoke throughout the 3 days at all about what kind of data he expected from the card or would be on the card or could be. He made no mention of the data.
He didn't speak to him for 3 days.
Given your expertise, did it ever dawn on you the significance or importance of this SD card that was sitting in plain sight?
Objection. Sustained, you can ask it to.
Did it ever dawn on you, as Mr. Burgess was recovering this information left behind, that there was something important or significant about it?
At the time, I thought it was a possibility. If you reference the initial work, a number of different memory components were identified in this infotainment. There isn't a singular memory chip. So if we're looking for data, it could be in any of them. So we found a new source of data storage, and there could be something there. There could be nothing there. It was unknown to me.
But it turned out there was.
There was.
Now, when you were watching Mr. Burgess work as an expert, if you felt like there was something inappropriate or he had some great oversight, you could write a report about that, couldn't you?
I could.
Did you ever write any report in this case?
No.
So you never wrote a report for your preparation of coming in and your data in the PowerPoint presentation, right?
Correct.
You never wrote a report regarding any of your observations of Mr. Burgess.
Correct.
You said that he didn't say anything. He spoke to you quite a bit during the process, didn't he?
He did.
He showed you what he was doing.
He did.
He explained to you what he was doing.
He explained the process. I think you had asked me earlier about whether he explained the data, and he didn't.
He demonstrated great proficiency, wouldn't you say?
No. No.
He ended up with a successful acquisition of the card at the end of the process.
Not proficient.
When you are considering all your equations, did you consider the timing information taken from the SD card that Mr. Burgess found regarding power on and power off of that car?
Yes, to the extent that he considered it in his own report. Again, I'm referencing his report.
But how about you? You're coming in here giving an opinion saying what's better or best practice or right. How about you?
How about you?
Consider, you personally, the one who's giving the opinions, did you consider the significance of the power on, power off data as it relates to all these times?
Yes.
Yes? Are you sure?
Yeah.
Okay.
I mean, I considered it. If that's the question is, did I consider it? I considered it.
Did you do any study yourself?
No.
Julie is betting
Now,
the card came
we
from the
agree,
exemplar
or you
vehicle.
agree
He
that
was
there
there
are
for it.
variances between different devices.
Yes.
So a Lexus clock that comes from the infotainment system is very common that it would be different than a different device like an iPhone.
Specifically, this Lexus, I don't know if we can make the statement that it's common or not, because again, this is the only time that I know of that this specific data has been analyzed. So I don't know the answer to that question.
Did you say on direct examination that variances between devices are common?
Variance between devices are common.
In a variance of 45 seconds, that wouldn't be remarkable on
No.
different devices. It's
Remarkable.
common in the industry.
Correct.
And in your business, that's an accepted amount.
I'm not sure what you mean by accepted. The amounts are what they are, and we have to correct for them. I've done analyses of clocks that are anywhere from completely correct, 1 second off. I've done analyses of clocks that are 25 years apart. So it's a wide range of
I
possibilities.
understand your point.
Yeah.
If you see as an analyst a 45-second variance or 30-second variance, that wouldn't shock you, would it?
No amount of variance would shock me, is the answer.
I
Interesting.
want to ask you questions and go through your PowerPoint. And I want to ask you your specific opinions and how you arrived at certain claims that you've made.
Sure.
Okay? If we could put up Mr. DiSogra's new PowerPoint, 52525. You've made a modification to your PowerPoint.
Yes.
You've made an amendment to your PowerPoint.
Yes.
So there is something that happened, you received new information or new data, and you updated or changed your PowerPoint.
I did.
And that's an appropriate thing to do when you receive new information, isn't it?
Yes.
If you have new data, you don't want to leave it behind. You want to make the best presentation with the best data you can.
I'd want my presentation of the data to be as accurate as possible. So I included all the data.
And you would expect that from any expert, wouldn't you? If they received new information or analyzed new data and it was important, it would be an appropriate best practice to update the PowerPoint or information they're providing, wouldn't it?
I'm going to allow that.
I don't know if I would tell other experts what their best practices are. I would say generally as experts, we do work that our clients ask us to do. So if we're asked to do it, we do it. If our clients say, hey, don't do that, then we don't do it.
Well, you like the phrase best practice.
It is not uncommon to not write a report. Somebody asked that in the chat. It is not uncommon for an expert to not write a report. You can talk to the expert. You can get their opinions from them. You can say, why don't you just do a PowerPoint on it? Reports cost money. Everything costs money. So no, it's not bad that he didn't write a report. It's not uncommon. Hank is going to try and make it look like it's bad. Like, oh, your opinion wasn't worth anything, so they didn't tell you to write a report. He also wasn't paid $400,000, I'm sure. You think Brennan's going to ask him how much he was paid? I'm curious now. I want to know.
Practice on direct. So I'm just wondering if
And say, hey, don't do that. Work that our clients ask us to do. So if we're asked to do it, we do it. If our clients say, hey, don't do that, then we don't do it.
well, you like the phrase best practice on direct. So I'm just wondering if I can borrow that phrase.
Sustain.
So argumentative.
Okay. Would you turn to page 2? Now, this is taken from Dr. Welcher's report.
Yes.
And again, you did no testing whatsoever. You just
I
read
did not.
reports. Did you read all of Dr. Welcher's data, the gigabytes and gigabytes of data? Did you go through it all?
Not every slide. No.
Not just the PowerPoint. I mean the actual massive amount of data in his study. Did you go through the data?
Oh, no, I didn't look at any of the data.
Did you ever speak to Dr. Welcher?
No.
And so when you are making assumptions on what he
You wouldn't
thought
speak
or
to
how
him.
he analyzed, you're
Stupid
just
question.
guessing.
Do you think that your expert is going to take a call from the defense's expert? Did you ever speak to Dr. Welcher? What a stupid question. We're in the land of the lost again. Where's Chaka?
Thought or how he analyzed, you're just guessing.
I am looking at what Dr. Welcher put in his trial presentation, and my assumption that's baked in there is that he's going to stand behind the things he says in a presentation. So I'm taking them at face value, but as being correct.
It's not a matter
I'm
of
not guessing.
It's not a matter if he's going to stand behind it. You don't know why he put something in here. You just see it on the paper. You don't know what his thought process was, did you?
To an extent, yes, because I understand how the exemplar testing by Aperture laid the foundation to align the key-on events in the infotainment to the Lexus VCH events.
When Dr. Welcher made his PowerPoint, do you know whether or not he was relying on 154 on Mr. O'Keefe's phone, stamp 154, as the end of the event as opposed to the beginning of the three-point turn, 1162-1?
Based on the math he uses, that's the implication. He puts a number on the screen that the only way you could reach that number is by making that assumption. So when I looked at the math, yes, that assumption seems baked into the math he did.
So this seems like it's baked in that he was assuming 154 on John O'Keefe's phone was the end of the three-point turn.
Not on this slide, on a later slide, but yes.
Okay.
Land shark,
And you said that variances, 30 seconds, 45 seconds,
Candygram.
they're very common when you're comparing two different devices, right?
Yes.
Okay. Turn to the next page, please. You point out 2 times for the jury, the Lexus event 1162-2 ends 12:31:43, right?
Yes.
And that's based on the clock in the infotainment system.
It's that time is based on 2 things: the clock in the infotainment unit and the cumulative key-on timer in the text stream data. So it's a combination of 2 values.
Which is the running clock.
Correct.
Right. And that is compared or contrasted or coordinated with the log on off time that was found on the SD card. Yes?
Yes,
And without that SD card, we wouldn't have that time now, would we?
correct.
Oh, so Shannon Burgess is a
123209
genius.
isn't something you analyzed, but you just read in the report that that is information from Ian Whiffen suggesting or taking the position that was the last user interaction John O'Keefe had with his cell phone, 123209.
That's how I understand it. There was a phone lock at 12:32:09. I did not look into the underlying reports from where that came.
And you know those are two different devices, two different clocks that will have a variance.
Yes.
That's the entire sum and substance
You
of his
mentioned
testimony.
trigger event, and you said that your preference is to, when you're doing times, to point it from the actual trigger event, and there was a little slap for emphasis to target you on that, right? The trigger event.
Little
That's
slap.
not a standard practice or a protocol that is supported by any type of literature, is it?
It's the methodology I teach, especially in the class I teach on the analysis of heavy vehicle data. We have the exact same problem with heavy vehicles. They all have clocks on them. And so in fact, I do a lot of clock adjustment on heavy vehicles relative to other sources. And the way I teach it, I'm not the only instructor. Collectively, the way we all teach it is we generally start the analysis at the trigger, which is not to suggest you have to do that. It's not wrong to do it a different way, but that would be let's call it the default methodology.
The default methodology, do you have any professional literature that says that is the best time to start the analysis?
Not literature. I mean, that's sort of my opinion, because that introduces the least amount of variables. Once you start trying to align events off of subsequent times, you just introduce more addition and subtraction or math you have to do. So it's easiest to do T0 and align everything from there.
If you're lining up the end of one event with the end of another event, it's more coordinated than if you take it from different spots, isn't it?
That could be a scenario where then you wouldn't use it. Right. Like I said, it's not the only way, but it's the default way.
I don't disrespect your method, but there are other ways to do it that are just as legitimate as the trigger knot.
Absolutely. And that's why I didn't change the convention here. I used their convention,
So you're not
apertures.
suggesting that Mr. Burgess was being misleading by choosing the endpoint when he pronounced that's exactly the point he was considering, are you?
No.
And so the word cherry picking, you're not saying he was cherry picking, are you?
I don't remember the context in which I used the word cherry picking, but I don't think it was with respect to a trigger alignment.
So there's no legitimate professional basis of suggesting your way is better or worse than going from the front or the end of the event?
No.
Real-time juror reaction as of 2 minutes ago. Aiden Carney, who is in the courtroom today, said one juror has her head in her hands and looks like she's had enough of this BS. She frequently took notes while Jackson was asking questions. Not sure what Spanky thinks he's accomplishing here.
You're not offering criticism on that, so just so I understand it.
Not criticism. I pointed out that it's not typical, and I pointed out not even to say specifically that it's not typical, because even that, to your point, might sound critical. I just want to be clear that I adopted their convention. It's not the way I would have done it, but I kept that convention consistent in my analysis. So I wasn't changing in the middle, trying to obfuscate what I'm saying.
I appreciate that.
Do you though?
So if someone's looking end to end, you're not going to add 5 seconds. It's if someone went from middle to end.
What?
Could you give me that?
Yeah, you were
A little
suggesting
different.
those questions about, well, since you're looking at the end instead of the middle, then you got to add another 5 seconds on. That's not really an accurate analysis if you're looking at a comparison from end to end. You wouldn't then add the 5 seconds at the time of the trigger because you're starting at the end from both devices. Objection.
I'm going to allow it if you can answer it in that form.
Well, we didn't even hear the question.
It's going to depend on if you're doing an alignment with something that is a range of values, then you have to be consistent on where you're doing it. If you're doing discrete points, then that's just a single point in time. There's no beginning or end. It's just a single second. So the best answer I can kind of give is it depends on what you're doing.
Well, in this case, you're basing it off the end of the event, the end, not trigger, the end, comparing it comparatively to the end of a different device. So you wouldn't just add 5 seconds just for the heck of it.
You would not add 5 seconds for the heck of it.
Well, it's a good thing Hank has that Webster's dictionary so he can look up
You
obfuscate.
see 123209 minus 123143, the middle line, equals 26 seconds. Isn't that in Dr. Welcher's slides before, let me phrase it more cleanly. Before Shannon Burgess analyzed the data more closely on May 8th, in his May 8th report, isn't this the exact difference in time that Dr. Welcher cites in his PowerPoint, 26 seconds?
I'll sustain it in there.
Did you see when you reviewed reports that Dr. Welcher uses this exact number plus 26 seconds in his report?
I got the number from the PowerPoint,
I'm sorry,
not the
PowerPoint.
report, but that is all of the numbers here on this slide are from Dr. Welcher's PowerPoint. And on the previous slide, I show that. So these are all just
And-
copied straight from that.
And you've labeled this John's interaction window.
I did.
Okay. Interaction window. Do you think it might be confusing when you use interaction window to make it seem like the event was limited to 10 seconds?
No, and that's not the implication there at all.
That's not what you're trying to say.
That's not what I'm trying to say.
Fair enough, fair enough.
What
If
are
I
you
can
trying to say?
clarify what I mean by interaction window is that there's
Please do.
a range of times that we end up with when we start running these adjustments. So we never land on a singular point of alignment. We end up, like I showed at the end, with 30 points. That's the window that I'm talking about. That's the window that I mean.
So if we could put up page 33 from Dr. Welcher's PowerPoint, just to illustrate the point you're trying to help us with.
Mr. Brennan, how much longer are you going to be, Mr. Brennan? It's almost lunchtime, sir.
So this represents, you've seen this, right?
It looks familiar, like it's from one of his slides. And if I've seen it, I did not spend a lot of time digging into it.
Does this look like the 10 seconds of data that would be captured from a triggering event in a text stream data? Objection.
I want to see you at sidebar.
She'll ask him at sidebar, Mr. Brennan, how much longer are you going to be, right? She always asks in front of the jury, but it's a defense attorney right after a sidebar. I just want to hear his question again. We have time to scooch.
Do it.
Does this look like the 10 seconds of data that would be captured from a triggering event in a text stream data? Objection.
I want to see you at sidebar.
Does this look like the 10 seconds that would be accurate in the event recorded in the text stream data? Comes the fan, they're at sidebar. She's going to be calling lunch soon because it's almost 1 o'clock here on the East Coast. She's getting hangry, maybe. Let's see. I see Ted Daniel at the high top. I see Sue O'Connell. I think that's Sue O'Connell in the blue shirt to the left of Matt from Core TV. I spy. They're not showing Aiden on camera, I guess. Maybe he's to the left of the high top there. Of course, the camera is focusing on the back of Karen's head.
Make sure that we could give you a nice view for the luncheon break.
Of course.
I took so long here to make sure that we could give you a nice full hour luncheon break. So
Oh, she's going to give him a nice full hour luncheon break.
Please rise for the jury.
But the captions say coal, C-O-A-L, power lunch. She's full-throated lunch for everyone. Full-throated lunch. The full-throated motions. Let's see if she's going to speak. Does she have anything to discuss with them? No. They have crappy elevator music. We have some entertainment. Apparently they'll be on break until 1:45, allegedly, maybe, sort of, kind of. Let's put that up here. And we have a little entertainment because guess who made a new video? Derek Carney made a new video. And it's only 6 minutes long, so we're going to watch it. He sent it to me last night, so I consider that to be his implicit permission to play his video. You guys want to see it? Yes, it's funny, right? I know a lot of people say they'd rather listen to Lally. Miss Macy, thank you for your 20, says we need a gag order on Hank. New username here, Lally's Baby Baskin Shark Hairdo. And I love how you spelled hairdo, D-E-W. I would even suggest hair don't might be better. But you know, you do you, and I love it. Entry required. Watching from Sweden says Hank needs a land shark about now. Remember that? Who remembers that old SNL skit? I think it was, I was going to say Jim Belushi, but John Belushi, when he was like knocking on the door, land shark, candygram, land shark, candygram. You want to rewind to where they say, where he says you wouldn't add 5 seconds to the, maybe I'll do the rewind while I'm showing you Derek Carney's video called Cash, Crash Dummies, and Crazy Calculations. The new dropping by Derek Carney in 1 second. About to premiere for you. Led Zeppelin fan says he thought he was missing data, so he removed the SD card. It was a lucky accident. Also, didn't he ruin the SD card? I don't remember. Did he ruin the SD card? I know that Higgins cracked his SIM card in half and dumped his phone on a military base before getting a new phone number. Was Chevy Chase doing the land shark candygram thing? Thank you. More cowbell, land shark candygram. It was Chevy Chase. Thank you. Love them all. Those original assets. Did anybody watch the movie Saturday Night? It's about the original cast of Saturday Night Live and the movie and the making of it. It's so good. If you haven't watched the movie Saturday Night, highly recommend. Highly recommend. Massachusetts says it doesn't take a neurosurgeon to see the difference between BS artist Welcher and witness with integrity. Bravo, sir. Your intellect and candor. Refreshing. Lexus in Space says, as a prosecutor, Hank is doing a great job for the defense. Sure is, isn't he? Camille sending teething biscuits to Brennan for the sharky toothaches he must be having. Kelly says Brennan got a stylist and a facial cute. We make a report if our clients ask us to. That's right. I'm more of a lessee if our clients ask us to. A lot of times they can just testify with no reports. Massachusetts, you have to give the sum and substance of what your witness is going to testify to. It doesn't have to be in report form. Massachusetts, it's so hard not to swear. Thank you for not, because YouTube has already demonetized Wednesday because of the dead body pictures, and they also scan the chat for foul language, drug use, drug promoting. No dog but a clown in this fight. Edmund says it sounds similar to a hardwire ring camera. Once the ring detects motion, it begins recording 10 seconds prior to motion to capture of every event. Yep. Your ears are blown. Thank you, Edmund. Just a friendly dolphin, man. Yeah. Land shark. Just a friendly dolphin, man. Thank you, LC McJD. All right. Without further ado, I bring to you the new creation by our friend Derek Carney. Cash, Crash Dummies, and Crazy Calculations in the Karen Reed case. I'm going to go off screen to go fill up my drink, but I will be back. Never fear. Melster is here.
Cash, crash dummies, and crazy calculations. Cash, crash dummies, and crazy calculations.
Can you tell us what your purpose is so choosing the attire you currently are in the condition of wearing today?
I thought I would begin today dressed as George Washington because early American lore suggests that our first president could not tell a lie. Thus, I will be more aligned with this sentiment. And may I ask you, Mr. Brennan, why are you in black and white?
Perry Mason, of course. Can you describe yourself, Dr. Welcher?
I am quite obviously the richest and smartest person in the room. The minute I heard about Dr. Wolf's potato cannon, I went on a journey to find the world's largest potato. I planned on launching it out of my bigger, thicker, longer potato cannon. Mine is far superior to any potato cannon ever erected, but the special crane we rented couldn't pick the giant spud up, and much like your case, ultimately it failed. So I decided to launch crash test dummies instead, human crash test dummies.
What, if any, formula did you use to calculate your ridiculous findings when we got together to make sure Karen goes down for this?
5.8341 times velocity cubed integrated dx/dh times time root e sine limit.
Can you tell us about your charts and graphs and the data you came up with and how you founded your calculations for doing new and inventive, highly complicated maths to confuse everyone, including the jury, but especially the defense's so-called experts?
Looking at the provided charts and graphs to analyze the meta-frequency distributionalisms, you'll notice they are complete pseudoscience fallacies, nonsense, really. I had my neighbor's nephew, who had never used Photoshop before, come up with images and lots of arrows and numbers randomly placed to make it look convincing. The CW paid me an outrageous amount for these.
And what about the human crash test dummies?
I decided to launch human crash test dummies.
Wow, that had to cost the Commonwealth a fortune. Pretty impressive stuff. Much more impressive than Dr. Wolf's tiny, flaccid potato cannon. I am very scientifically gifted myself. I needed impressions of Chloe's teeth, so I asked my wife to make me some homemade silly putty. And I used it on a picture of a random canine police dog. I'd like to submit my putty into evidence. Dr. Welcher, can you explain how you chose random numbers and also about time drifts?
If I must. A pit bull helped. I dipped the dog's paws in grease paint and had them walk onto a tarp on the ground with large circles numbered 1,000, 1,000. I'd close my eyes and throw an injured squirrel onto the tarp. I forgot to mention I was dressed as Albert Einstein. Now about time drifts. Clocks lose synchronicity over time. I had Trooper Paul and Jen McCabe watch a wall of clocks for months. When they noticed a clock out of sync, they yelled out, "Time keeps on slipping, slipping, slipping."
Time keeps on slipping, 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 slip, 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 slipping and a slipping, slipping and a flipping, flipping and a flipping, tripping and a tripping, ripping and a ripping, nipping and a nipping, whiffing and a whiffing and a whiffing and a listening and listening and listening, whispering, whispering, flipping and a flipping, time keeps on slipping. Yeah.
Well, that's all.
Shout out to Derek Carney for his newest creation. Well done, sir. Well done. I don't know how you do that crazy AI stuff, but it's well done. Oh, I like how after your video ended, it suggested my video of today's stream. How awesome is that? YouTube is crazy with their analytics. Like YouTube knows everything. Let's take a look at Karen's comments yesterday outside of the courthouse, because we need some things to watch while we're on lunch break, and we try and entertain the whole entire time. Hang on. While I cue that up for you. I've got a piece from WCVB Channel 5. This is her comments yesterday outside the courthouse, followed by a piece that aired about 11 minutes ago. Let me take this down, put this up for you. These are the comments outside the courthouse by Karen yesterday.
Ben, good afternoon. A short time ago, Karen Reed left the courthouse and she told reporters that her defense case will last between 1.5 and 2 weeks. And she said her first witness tomorrow morning will be a phone data analyst. Now, the prosecution's final witness was accident reconstruction Judson Welcher. He spent a total of 3 days on the witness stand and repeatedly stood by his conclusion that Reed's SUV taillight was damaged in a collision and that John O'Keefe's injuries were caused by a vehicle collision. Now, after Welcher left the stand, Special Prosecutor Hank Brennan wasn't done yet. He played one more clip of one of Reed's media interviews from before the first trial, and in it, Reed says at first she had questions about what happened to John O'Keefe.
And then when I hired David Yannetti, I asked him those questions the night of January 29th. Like, David, what if, I don't know, what if I ran his foot over, or what if I clipped him in the knee and he passed out or went to care for himself and he threw up or passed out? And David said, yeah, then you have some element of culpability.
TBD. How long were your
Leaving court, Reed told reporters that she is feeling good. She said her team still hasn't decided if they will call Trooper Michael Proctor to testify. He is the lead investigator who was fired for sending insulting text messages about Reed. The prosecution did not call Proctor during its case. Now, Reed did not testify at her first trial, and she told us this afternoon she has not yet decided if she will testify for this second trial, if she will, in fact, take the stand. Live in Dedham, David Bieniek, WCVB News and All
right, David, I actually have two quick questions for you. Do we have any idea how long the defense side of this could take? And then when they're finished, the prosecution could also call more witnesses. Is that correct?
Yeah, again, the defense, according to Karen Reed, says their case will take about 1.5 to 2 weeks. And you're right. The defense could call more witnesses after the defense's case. For example, they might call a dog expert to come back on the stand for the prosecution if the defense claims that John O'Keefe's injuries were caused by a dog. Those are what are known as rebuttal witnesses, and the prosecution did not use them during the first trial.
All right, David, thank you so much. Always good information that you've been following. And of course, don't forget, David shares live updates on the trial to WCVB.com/Karen Reed. You can watch the trial there as well as on the free streaming app, Very Local.
The live look inside Norfolk Superior Court in Dedham.
Okay, this was posted about, I think this is 11 minutes ago, and this is Boston 10. So this is catching up, or this is what mainstream media is reporting happened today. You and I watched it together. We know. Let's see if they reported accurately.
The live look inside Norfolk Superior Court in Dedham, where the defense has begun calling witnesses in the Karen Reed murder retrial, going over some of the evidence, it looks like, at this particular moment. Thanks for joining us at 11 o'clock. I'm Matt Pritchard. Testimony kicked off with another crash reconstructionist, this time called by Reed's legal team. If you recall, Reed is accused of hitting her boyfriend, Boston police officer John O'Keefe, with her SUV and leaving him to die out in the snow. NBC 10's Minash Kungwari, he's live outside court in Dedham. Minash, catch us up on what's happened so far.
Well, Matt, before court even began, a bit of controversy. The defense requested Judge Beverly Cannoni dismiss this case altogether on the grounds that the prosecution did not prove guilt beyond a reasonable doubt. Judge Beverly Cannoni denied. So court went on as originally planned, and the first person on the stand for the defense, Matt DiSogra.
Matthew DiSogra.
Matt DiSogra, the first witness for the defense.
Analyzing GPS is a regular part of my job.
He's a director of engineering at the North Carolina-based company Delta V.
Have you been qualified in other courts to testify as an expert in the area of accident reconstruction, EDR, data retrieval?
Yes.
How many times?
Once.
Still, he was tasked by the defense with...
Yeah, that's what they choose to show. The fact that he admitted that he's only testified once before. That's what they choose to show. See? Cherry picking. Talk about cherry picking.
Looking into a report that was prepared by two crash experts from the Texas-based company Aperture.
This is a slide from Dr. Welcher's presentation that I was provided.
Is there anything in this slide that you disagree with?
The findings conclude Reed backed her SUV into John O'Keefe at the exact same time his phone stopped recording movement. DiSogra says that may be inaccurate.
Phone interaction always occurs after the end of the vehicle event.
Well, it's uncertain how long DiSogra will be on the stand, but today is expected to be a full day of testimony. We'll, of course, keep you updated on what happens. For right now, we're live here in Dedham. Manoj Kungwari, NBC 10 Boston.
Exactly. Inside Your Bones points out, why are they even calling the Karen Reed, calling it the Karen Reed murder trial? Isn't it innocent until proven guilty? Yeah, it's supposed to be. It should not be allowed. And would you rather a fraud? I think you mean testifying many times or integrity. Yeah. Yeah. I don't know. I need to digest a little bit more what this witness is testifying about and whether I don't think right now, my personal opinion is I do not think this was the best opener for this defense case. I just don't think it was. I just don't think it's strong enough. I would have preferred to see one of the crash daddies come on first. Wolf or Rentschler, either, because they're very, very strong witnesses. They could immediately put the ridiculous defense theories. Again, I think they keep reversing the roles here. They could have immediately headed off at the pass all of the ridiculous theories that the prosecution has laid out. I don't think this witness was the right guy to open with. I just don't. I don't think he's strong enough. He's only testified one time before. He's a nice guy, and he seems to know what he's talking about. And the crux of his testimony so far is that no matter which way you do the math, Shannon Burgess didn't really do the math. In his first report, he didn't finish the math. In his second report, he finished the math, but in only 10% of the times, if you ran the numbers all different ways, only 10% of the time would John O'Keefe's lock phone event have occurred before they're allegedly saying that he died. I am still confused if they are agreeing that the key cycle 1162 actually happened outside of Fairview. And I would have preferred to see a witness come on first to say 1162 was in the Dighton driveway. That's not what happened in front of 34 Fairview. And here's how we know, because Trooper Paul tested the vehicle outside Canton PD at key cycle 1164. That's what he testified to in the first trial. Get that out there first, because if 1162 is not in front of 34 Fairview, none of that makes any difference. Am I overthinking it? And so I just don't find it to be strong enough. Maybe they're saving the best for the end. No, you got to start off strong. I don't know. I'm just not, it's a little too murky for me. But that's my own personal opinion. Mr. Brennan, shut up class is calling, says cupcake collaboration. There's a binky in it for you. Yeah, I'm confused. I think the jury's confused. I think you're confused. And I really wanted them to start off with a bigger bang. Could you please watch BN Trouble 31 proving Welcher's demo is BN? I don't know. How long is the video? He's here. If he allows me to play it, I'll play it. BN Trouble 31, are you here? The problem is the jury's not going to see that. Judson's flawed tests. It's about 20 minutes long. That would give us a chance if he's here. And oh yeah, he says you can play any of them. All right, you guys want to see that? This is BN Trouble 31 is in the chat. He's here. Thank you for doing this 19-minute video because it will give me a chance to go fill up my drink, which I did not do yet. And we have about 30 minutes. So let me just queue up a little big bang for you after that, which is, as you know, hold on, queue. Add this to the queue. One second. One second. All right. I gotta play it, I think, first a little bit. Heidi says, is he trying to get him to say that he changed his information so it was okay for Welcher and Burgess to change their information? I don't know, maybe, Heidi. I don't know what the hell he's talking about. He's trying to show that he's not as experienced as Shannon Burgess, and that Shannon Burgess is like the be all, and that Shannon Burgess, even though he lied about his degree, is really not all that bad. I mean, I guess that's what he's trying to show. It's unclear. You know, he's grasping at the paper straws. McDonald's really needs to step up their game because there's nothing I hate more. Well, there's some things that I hate more than a paper straw, but I really, really, really hate paper straws. They get soggy and they don't do the job. Thank you, Heidi. Deb Frank. Wait, Higgy also changed his phone number? That's not sus. Yeah, he totally changed his phone number, as did Brian Albert. They both did. They got new phones. They destroyed their phones. Lena says, I love this witness. He is not defensive at all. I think he's looking at Hank and thinking this guy's an idiot. Love it. AJ's Beard, can you please wish my future wife, Katie, a happy 18th birthday today? She moves into Boulder August 16th. Scobuffs, Scobuffs. Oh, my future buff. I'm sorry, not my future wife. I'm like, your future wife is just turning 18. I'm sorry, what? Let me start again. AJ's Beard has a future buff. Katie, happy 18th birthday to Katie. She will be attending the University of Colorado in Boulder next year. Scobuffs, I am a proud alum. She's moving to Boulder August 16th. Scobuffs, I don't know where you live, AJ's Beard. Maybe you live in the Massachusetts area, but listen, let me tell you from personal experience, a lot of buffs in my family. I was the first. They go to Boulder. They don't so much always want to come back because who would want to come back? Better than Amherst. I'm sorry. It is the best college town in the U.S. Scobuffs, happy birthday, Katie. You're going to love it. There is nothing to not love about Boulder. If you don't like the weather, wait 5 minutes. Sun shines 360 days a year, 360 days a year. Lena says, I'm waiting for Hank to ask the witness if he knows the defendant said I hit him 3 times. Kaylee C. Paralegal. My husband is an engineer and works in North Slope, Alaska in oil. He just got home and said, the guys have been listening to that girl you always listen to, meaning me. And I was dead picturing all those blue collar workers listening. Good. That's amazing. No, we entertain a lot of construction sites. Thank you to Kaylee's husband. Thank you to the engineers who are working there. You guys are doing the Lord's work in Alaska, and engineers are really, really, really smart. Thank you, Anonymous Nobody, for gifting 5 memberships. You're awesome. Zoe B is keeping stats, and up to the lunch break, she says, objections against the defense, 25, 23 of which are sustained. Thank you for keeping track of this. 2 strike that's, 2 I'll allow it. Objections against Hank, 13, 8 were sustained, 2 strike that, 5 I'll allow it, 5 sidebars, 1 siren heard during Alan Jackson. Thank you, Zoe, for keeping track of all that stuff. Who's better than you? Karen Reed's not guilty verdict says, 1, the jury isn't going to like how rude Brennan is to the witness. 2, so you think maybe OSHA should check out Aperture's use of human test dummies. Love you, Mel. Hey, you know what? Human test dummies is not a great thing. Human crash test dummies. Leanne Wilson, hit the like button if you dislike Brennan. Well done. Well done, Leanne. It's a fun way to get people to hit the like button. Amy Smith, the problem is the defense has no access to the car for any expert to do a thorough investigation with the car's infotainment. It's frustrating. I don't know. They could have. I don't know that that's true. I don't know that they couldn't have any expert examine the car. I don't know that that's true. The problem is that part of that infotainment system was broken when they tried to remove it. There's a lot of issues. Yeah. Teardowns are now 1.4 million in Boulder, says JDH, and that is 100% true. That's why people are moving out to Louisville and Brimfield, and Louisville is a really cute town. Free Karen Reed 2024 says, I hate her. I hate her. I hate her. Thanks for being here for 5 months. Camille, maybe because Delta Daddy's math was easier to understand and brought the jury back from the Charlie Brown mind-numbing courtroom. Free Karen Reed 2024 says he needs to clear and say that's not what I was hired for. When Brennan asked about his own investigation, he was hired to evaluate the aperture reports and provide clarity. That's it. Yeah. It needs to be cleaned up a bit. It's a little messy right now. Netwoman, I'm just happy that I don't have to hear Judd's loads. Yeah, his load on the bed was a little much for me yesterday. Lena, personally, I think it's a bad look for Hank to be a jerk to this expert. The expert's non-combative. Yeah, this is how an expert who has no skin in the game really behaves. Okay. Let's watch BN31 Trouble's new video. I think it was just posted yesterday. It's about 19 minutes. It is called Karen Reed Trial Judson's Flawed Tests. Trouble 31 is in the chat. Be kind. I'm going to go off and fill up my drink. And you guys watch this. Enjoy.
My fingers are too fat.
Thank you.
Okay. So what you're looking at is what I call event 1162. If you see anything in blue on these charts, that's information that I added. I typically put my initial, JBW, Judson Blair Welcher, that's me.
Okay, he's trying to pass this off as Toyota TechStream. It is not Toyota TechStream. This is a Bosch code reader scanner that he had hooked up to the vehicle, pulled the data, and then he made this graph and put the information in himself. Toyota TechStream would have had mileage, it would have had time, date, and not only mileage, it would have had 1/10 of a point mileage, because that's going to be real important here in just a minute.
Key here is the trigger, and there's a point. So this time in the TechStream data, you could think of it as like a stopwatch. It's when it starts when the car turns on and stops when the car turns off. And then if it sees a triggering event, a T, it records that information. So this is when the trigger happened. So that's 1,142.2 seconds. And so I've converted that to minutes and seconds, because most people don't think in seconds. And so what it also does is once it sees a trigger, it's constantly circling.
This is the Toyota TechStream interface. This is not where the event triggers are stored. This is just the first part of the system when you first log into it, and it is on a laptop, and it is connected directly to Toyota. You have to be a Toyota tech to operate it. Nobody else can get it but a Toyota tech. It stores everything about the vehicle, and when it triggers an event, it has the time, date, mileage down to the 1/10 of a mile, because that is going to be real important when I bust apart Judson's presentation, what I'll call it. It's a presentation because it is not facts. It is his opinion. He really doesn't know that much about cars. He thinks he does, but he doesn't. Anyway, this is what the interface looks like. This is the first page you see when you log into real Toyota TechStream, but this is the older version. The new Toyota TechStream is global Toyota TechStream system, which I'll show in just a minute. This is just more of the parameters inside of the older Toyota TechStream. This is like the trouble codes, and like if you're looking for a problem inside the vehicle, you would navigate through here. I'll have to show the actual text stream events in another video. This is just a short one. I want to get it out. So hopefully somebody from the team will see it and they can question what he's doing. I don't think he even knows what he's doing, to be honest with you, with Toyota. This is the new system.
Or that's when the trigger is. Sorry, 10 minutes, 57.4 seconds. Again, the trigger has plus or minus. So that's from 10 minutes, 52.8 plus 10.
What he has done here is take Burgess's information and put it on his own graph. Okay, this is what he's claiming is 1162.1, which is the 3-point turn. He's claiming she was driving down the street at, what, 9 miles per hour to 15 miles per hour, turned in a driveway to do a standard 3-point turn. Mind you, this is in the snow on a street that she's never been down. It's dark. So she pulls in the driveway. He's saying that she pulls in, shifts it into reverse, and guns it 50% throttle backing out of a driveway, turning the steering wheel. Now, if she pulled in a driveway, right here's the 50% throttle. If she turned in a driveway, put it in reverse, and stabbed the throttle to back out while turning, her car would have spun around and probably have done a 180, at least a 90-degree turn, sliding, mind you. There's no way there was somebody pulling in a driveway to do a 3-point turn and use 50% throttle backing out.
Time of 12:36. The text stream data basically turned on, plus or minus a little bit.
When you say the text stream, is that relative to when the car?
Now, if you remember, I said earlier about 1/10 of a mile. He doesn't list the 1/10 of a mile because there isn't one listed.
Okay, so again, we are looking at event 1162.1. The information in blue is speed. It comes out of the text stream in kilometers an hour, converted to miles per hour, feet per second, looked at the total distance traveled, shift position. So in the text stream data, a shift position of 1 indicates you're in drive. A shift position of 2 indicates you're in reverse.
There's no zeros. What would a zero indicate?
0 is usually neutral. And I believe 3 is park. So there's also data on the acceleration of the vehicle. So basically, what is the effect of whatever you're doing in terms of stepping on the gas or not stepping on the gas? And there's also information on the steering of the vehicle. So again, there's trigger 5 seconds before, 5 seconds after. So over here, a positive number equals a leftward steer. So you can see we have in the forward velocity or forward motion in drive, goes forward with leftward steer, stops, shifts into reverse, and then continues with the rightward steer back.
Now, what he has done to be deceptive is leave off the 1/10 of a mile because she had to drive from where she did the 3-point turn to in front of 34 Fairview. From the point they pulled out of the 3-point turn to drive to the Albert's house is several 1/10 of a mile. So the odometer would have been changing. Of course, that didn't happen because the car was stationary in the driveway with only the tires spinning. And that is very deceptive and very dishonest. And we know why he did that, so this would fit the narrative. Furthermore, why would anybody back out of a driveway on a street they don't know, punch the throttle to 50%, which would have shot the car backwards while she was turning, so it probably would have spun around. Just very dishonest. But what do we expect?
When you look at the number 1162-1 as an event, can a key cycle or when a car is turned on, power ignition on until the point it's turned off, whatever amount of time, can it have more than one triggering event?
Yes, you can have lots of triggering events. In this case, it has 2. On a key cycle 1164, there's 11. On 1167, there's 10.
If you could move a little bit to the right on this, is there something you can see on here that caused the triggering event, some of the data?
Yes. So if you look at the triggering, the indication of what this trigger was, what you see is accelerator opening ratio, which is basically, you can think of it as how much you're stepping on the gas pedal. And so if it exceeds, in this case, 30% quicken time after shipping into reverse, that tells the system, hey, we might need to start recording this data. So what you can see, it went into reverse, and then within a very short amount of time, the accelerator pedal went above that 30%. That's what caused the T or the trigger in the text stream data.
The row next to the 31.5, engine RPM data, can you explain to us what that is?
Sure, that's how many revolutions per minute the engine's turning.
The more gas, is it generally the higher the RPM?
Correct. There's going to be a little lag. Your car doesn't move instantaneously. You have to step on the gas, then the RPMs go up, then it starts going faster.
If you could explain to us the total distance and distance travel column.
Brake oil pressure, we have the acceleration data here. And then from that information and using the acceleration data, calculating the speed at which it's backing up. The reason we have slightly different calculations here is we have some evidence that the wheel's slipping on the ground. So we need to use the accelerometer because the wheel speed is simply telling you the speed of the wheel. It's like if you're stationary burning rubber, the speedometer reads a certain speed, but you're not going anywhere. But the accelerometer tells you how much the vehicle's moving. So from all that information, we get information on how far the vehicle's traveled. We've done it in terms of total travel distance. We've done it relative to the start position.
But he didn't put the real mileage down because the tenth of a mile would have changed several tenths because she drove from the 3-point turn to the Albert's house. This was all just smoke and mirrors. He took Burgess's data, made his own little graph or chart here, put some of his information in it, and is trying to put a woman in jail for the rest of her life over faulty data that he knows, he has to know that he's wrong and he's not telling the truth. There's no doubt about it.
3-point turn triggering event. There is a time in red, 12:23:38.
Correct.
Where is that time taken from?
That's coming from the cell phone of Mr. O'Keefe at 0.154.
Okay. And is there another time on there?
I mean, I do the math between those two.
Okay.
In the light above it. So it caused damage to his vehicle. Where it is on the rear of Mr. O'Keefe's Chevrolet, you see it's about 25 and a half inches above ground, 32 and a half inches above ground.
Now, this is where I know he's straight up lying because both vehicles have urethane rubber bumpers. Both bumpers give several inches. So when she backed up against it at that angle, her taillight hangs out so far that it would have hit right where the Chevy emblem is, where that chrome strip is on the back of it. But both bumpers would have deflected, allowing the taillight to hit. And as far as that reflector on the lower bumper, that's in the more of the straight back of the truck. So at the angle that the vehicles collided with each other, that light wouldn't even come into play. Once again, he's being deceptive with the angles. At that angle, this is just a representation. At that angle, the very back lower reflector light will not touch. Furthermore, he's not showing this angle of the truck, showing how far that taillight actually hangs over. There is no doubt in my mind that that taillight collided. Both bumpers on both vehicles are polyurethane or urethane. They're like a rubber. They give several inches, especially with 7,300 pounds hitting 6,500 pounds. It doesn't matter what the speed is. It matters the force of the two vehicles pushing each other. It could be 0 miles an hour. The taillight hangs over far enough with the give of both bumpers that the taillight is going to hit and it is going to break. And that lower reflector, it doesn't matter. The angle that they hit, that wouldn't even come into play. Plus, that's flexible anyway. It's just a reflector. It's not a taillight. How much money are they paying a guy to say stuff that is wrong? How much is he getting paid to put a woman in jail for life for something she didn't do? And this guy has to know she didn't do it. He had to have seen the videos that are all edited and blurred out wherever they show Karen's car.
Where it is on the rear of Mr. O'Keefe's Chevrolet. You see it's about 25 and a half inches above ground, 32 and a half inches above ground. Here's Mr. O'Keefe's vehicle. So these marks are this is the Chevy Traverse words, are approximately right here. Again, I had the opportunity to inspect Mr. O'Keefe's vehicle. There's no damage where these marks are. So sure, it knocked the snow off, but it wasn't sufficient to cause damage to his vehicle.
This guy's a fool. As far as the taillight sticks out, it definitely made contact with John's car. He's not showing the proper angles, and we all know why he's not showing the proper angles. All he had to do was back them up against each other, and we would have seen that they would have touched. But no, he's got to show us pictures of them several inches apart because he is a deceptive man. He is very deceptive. He is not telling the truth whatsoever. You can see the angle right there. They would have made contact. They both have urethane bumpers. Both bumpers give. The taillight would have hit right where the Chevy emblem is. Just look how far the taillights stick out. There is no doubt that that struck John O'Keefe's car and caused it to crack with the two pieces that Karen said she pulled out. There is no doubt about it. That's what happened. And this guy is showing us deceptive pictures. He's not showing us the 1/10 of a miles on the mileage. He's not using real Toyota tech stream. He is lying about everything. In my opinion, he is a fool. Complete fool. He's deceptive. I don't know. I don't see how a person like that sleeps with herself, but it's not for me to figure out. But that bottom reflector wouldn't even come into play at the angle. The vehicles were almost 90 degrees apart. That would not matter. The bumper would have pushed in a little bit. John's bumper would have pushed in a little bit, and the taillight would have made contact. We all know it did. He's trying to lie to the jury and say that it didn't. I don't know what else to say.
Tail light, but yet the lower tail light also was not broken. Here, okay.
His arm. He's got a cracked, broken elbow. His elbow is broken. Those two bones in the forearm are completely in two. That was just from the impact. His wrist is broken. See the bone dislodged right there? That's gone. That knuckle's damaged. His thumb fractured. And these two fingers are broken, along with this knuckle. No, that knuckle's intact, I think. That knuckle, yeah. That finger's broken, though. This finger's broken. Clearly see it sticking outside. This finger's broken. Not completely. Right at the second knuckle, the second joint. Middle finger's fine. But the fractures right here, those are definitely from the impact and the broken elbow.
Be in trouble out there doing the Lord's work, spending all of his own money to do all of these experiments, which hopefully have been helpful to the defense. Shout out to Be in Trouble 31. Go on over to his channel and give him a like, because he's out there. He's doing the Lord's work. So many people giving of themselves, their money, their free time, their lives to be interested in this trial. Try and shed some light on things that are going on here. And nobody has any dog in this fight. We're here for justice. Barbara DeLong, if they try to charge her with DUI, they better charge Higgins, Proctor, Albert, and Jen McCabe. They can't. They can't change the charges at this time. There has never been a standalone DUI charge. She was driving around with Kerry and Karen. Well, she was driving around with Kerry and she who? I'm very confused by this comment, Barbara. I'm sorry. If they try to charge her with DUI, they can't. They better charge Higgins, Proctor, Albert, and Jen McCabe. She was driving around with Kerry and Karen. You mean Jen McCabe? Yeah, but it was not until the next day. Plus, HIPAA is attached for the blood work. Should not have ever been mentioned. No, not necessarily true about the HIPAA and the blood work. However, I have problems with the extrapolation that never in a regular DUI case would have been allowed. I feel like I'm glitching, and I don't know if it's like we're breaking the internet with the content. I mean, not the content, but with everyone watching Karen Read. Maybe I should close some tabs. Maybe I'm not glitching on your end. I don't know. And yeah, I know people say that a lot. Everybody was drunk driving, and yeah, I know, but it's not reason enough to dismiss the case, and it's kind of irrelevant, right? I mean, yeah, it's true, but it's irrelevant. Thank you very much for your super chat. 18 Wheels of Outrage came in and gifted another 5 memberships. You're amazing. AJ's Beard, sadly, I'm in Massachusetts near Canton. I may move to Boulder too, especially after this farce of a case, or at least east out of Massachusetts. Well, Kay Willis is a realtor and she can help you. She's always in here. She's always gifting memberships. She's amazing. Let's take a look into the questions on Venmo. Nancy, thank you very much for your Venmo. Says, just because you're the best. Kathleen, Welcher said there was only one neutral event. Car was being loaded, but Proctor drove it, missed reversed, and forward on the truck. I don't think Proctor drove it onto the tow truck. I think it was the tow truck driver. I don't think that Proctor drove it onto the tow truck, but the tow truck driver is on the list. He's on the witness list. And oh, Larry, you have a surprise next week for me? What? Proctor drove it, missed reverse and forward on truck. Video was shown to Shannon, looked like the taillight was also intact. I don't trust any of the video that's been turned over here. I think a lot of it has been doctored, proctored, altered, and I'm going to tell you another little story for those of you who don't know. It says now they're coming back at 2:00, but I think I have scrolling along the bottom of the screen 1:55. But now they're saying 2:00 on Court TV. So there's that. Cheryl on Venmo says, please wish my brother Paul a happy 60th birthday. Happy birthday, Paul. She says he's watching you today for the first time. Thank you. Well, I hope he's still here, even though it's lunchtime. Thank you, Cheryl, for your Venmo. Leslie is here. This is the difference between truth and BS. Thank you very much, Leslie, for your Venmo. Janet, why is no one using Karen's backup camera? Mine is a $50 cheap one from Amazon that records everything for 30 days. Masshole, not MAGA, wants to know. Well, that's a great question. And I don't know why no one has ever pointed out or shown us any video from the backup camera. I don't know how long it is retained by the system. I have so many questions that are not answered by all of this text stream data. Like, what is the system that would register a collision? Why haven't we heard about that system? Again, right. What about the backup camera? Would it record an event? Many vehicles are designed with a system that has tune in Thursday and I'll see the surprise. Okay, Larry, you got to remind me though, because I won't remember. Many newer vehicles have systems where if you're in an accident, it will call 911 for you. It's like the OnStar system or something, right? Thank you, Larry Foreman. Thank you. I'll do that. I'm Cora, not Chloe. David Reese says backup cameras on most cars don't record, but wouldn't it record the event of the actual collision, the accident? Maybe a lot of cars you have to pay for OnStar, but sometimes you get it free when you buy a new car. I don't know. I just don't. I'm not a fan of this first witness being called first. I mean, he's a good witness, but I don't know. I don't know. I have so many questions. I'm left with more questions than I had coming into it. Heather, and I hope it's cleaned up on redirect. Boston nurses are watching the trial together. The injuries speak for themselves. Case over. Free Karen Reed. Thank you, Heather. Thank you, Heather. And to all the nurses out there who are watching, Free Karen Reed. You know it. I know it. John O'Keefe was not hit by a car. If you guys are working out of a hospital, so many nurses do home duty nowadays. But if you're watching from the hospital and it is Good Sam, I know the nurses from Good Sam do watch. That is where John O'Keefe was taken and Karen Reed was taken on her section on January 29th of 2022. You know it. I know it. He was not hit by a car. There are no bumper marks. There are no injuries that even in any way correlate to a pedestrian accident. You cannot tell me that that spoiler hit him in the eye. And then we find out the guy didn't even account for whether the suspension was 3 inches higher, 2 inches lower. The car could have been on the berm. It could have been on the street. The fact that a woman is on trial for life in prison on murder charges with regard to the lack of evidence here and the lack of an investigation for any person, let alone a fellow brother in blue, should kill you. I mean, should not kill you, but should shock you, should outrage you. Thank you, Jonas, who says, Free Karen Reed, love hanging out with people that are smarter and snarkier than I am. Well, we do have a wicked smart chat here. That's for sure. You guys are wicked smart and you're very collaborative and we help each other and we refresh each other's recollections. And yeah, $400,000 is a hell of a lot of dogs in the fight. Oh, thank you. Good Sam is now called Boston Medical South. Okay, well, if you nurses are at Boston Medical South, then thank you for watching from there or wherever you're watching from. Thank you for watching and for taking interest in this case and for being here because you know that this is wrong on so many levels. This is not what it's supposed to be about. An honorable prosecutor never would have prosecuted this case. There's a prosecutor, the district attorney of Boulder County, speaking of Boulder, his name's Michael Darty. Really nice guy. We watched him try the case for the King Soopers mass shooting, which is horrible, horrible, horrible this year. A guy like him never would have prosecuted this case. Coincidentally, Michael Darty and Mark Betterow know each other from working together in the Manhattan DA's office, which is an interesting fun fact. Baking Mom 14 bought 5 matcha lattes. It says, the data don't lie. People do. Carrie, thanks for the matcha latte. I'm going to need a lot of it to get through the rest of this trial. I don't know how long it's going to take. Karen said in those comments after court yesterday that the defense's case would take something like maybe a week and a half to 2 weeks, right? So let's see. Today's day 1. It's Friday. Say it goes a full week next week. Chitty Chitty Bang Bang Lexus. Somebody changed their name to that. That's amazing. I love it. Is next week a full week of court? Let's see. Let's see what we can glean. So today is the 30th of May. Oh, wow. So tomorrow. So June 2nd begins next week. I don't know if it's a full day of court. Oh, I did decide I'm going to do the thank you guys for encouraging me to do the interview or the radio show on 99.1 WPLR with Chaz and AJ in the morning. I have that scheduled for next Wednesday morning before court. So we have next week of court. There may be one half day in there. I'm not sure. And then the following week, there also may be a half day. a half day. And understand they do that because of some of the jurors have conflicts. So let's say the defense case goes 2 more full weeks, which would be ending on Friday the 13th. Oh my God. So Friday, June 13th is a Friday. June 13th is a Friday on Friday. And then what? Then we go into deliberations the week of the 16th. This case could be over technically, although June 19th is in there. That's Juneteenth. That's a holiday. It's a court holiday. I don't know. Do we see this case going through the end of June? I don't know. I don't know how long the jury's going to take. I mean, remember how long they took last time? Like 4 days, I think it took. Oh, look, Caroline says 99.1 is what we play in my office. So it's a great channel for you to talk with. You know, I did do a deep dive into them, and they've had a lot of people on who do believe that this is a farce. And so I'm glad. If it was like Julie Grant's show, there would be no way I would do it. Although I do like to be the voice of reason for some people who don't understand that John O'Keefe was not hit by a car and a car did not hit John O'Keefe. No matter how much you hate Karen Reed and want to stone her to death in Town Square, like The Handmaid's Tale, before you hang her in a public hanging, John O'Keefe wasn't hit by a car. John didn't get hit by a car, says. Look at that. I think this one won't take as long. We'll see. Where can we hear the radio show? I think they have a website, so you can probably hear it on the website. I'll remind you again on Tuesday night. No, I think you can listen like on the website, like Howie Carr. You can listen on the internet. You don't have to have the radio station. But I don't know if you guys can get 99.1 in Massachusetts. I think we can get it here on Long Island because, you know, it's across the water. Dennis the Menace and Nasher said, my pup wanted to follow this doggy do too. That's awesome. Everyone should hit like and subscribe, or we're going to have to turn off the air conditioning. We might have to turn off the air conditioning. Praise be. Did you guys watch the finale of Handmaid's Tale yet? No spoilers. I've watched it. Somebody told me they're going to do a spinoff and they're going to do another series that is going to take place 15 years after. But it's ironic, don't you think? A little too ironic that Gilead, headquartered in Boston. We have entered Gilead. Maybe this is Gilead. I call it the inside out, upside down matrix of Narnia, Massachusetts. But maybe Gilead is appropriate. It's called the Testaments. It's going to be called. Thanks. Tristan, he said this guy was basically just a neutral witness to say Burgess and Welcher's info is incomplete and changed to fit their narrative. Only confirms no way to be sure equals reasonable doubt. Yeah, I mean, I dig. I just don't know if it was the strongest. We need a Gilead emoji. If it's the strongest way to start, it's not the big bang I was hoping for, but that's just my opinion. You guys may have a difference of opinion. I read it will be Aunt Lydia. Aunt Lydia, 15 years later, she's still alive in 15 years. I don't know. Look, you know, Ann Dowd is not that old, I know, but they try and make her seem elderly and frail in the finale of Handmaid's Tale. Just me, I'm behind. No collision equals no hitting John O'Keefe's traverse. Not necessarily a light tap, they said, wouldn't register a collision, right? And I think this witness even said that a side swipe into a pedestrian would not register a collision. So he's kind of backing up a lot of things that Shannon Burgess and Welcher said, right? And that's why I kind of don't like him as the first witness. You hated the end of The Handmaid's Tale, Canadian Bacon? I know. I wasn't really that, I don't know. There were some good finales in the history of television. I'm not so sure that was really one of them. I'm only 1,000 subscribers away from Vinny Politan, really? He decided to go live in the middle of the trial, and I clicked over. He only had 134 people watching, and so I don't know. Why would you go live in the middle of the trial if you're not like doing live trial coverage? I don't know. Vinny. I do love Vinny. Been a fan. Don't tell the spoilers. No spoilers on Handmaid's Tale, please. MASH had a great finale, says Don. Like Mad Men. Let's talk about the finale of Mad Men, one of my favorite TV shows of all time. Oh, okay. So Murder Mitten says 6 Feet Under, greatest finale of all time. See, sometimes we got to divert from the topic a little bit to regroup. And here's Denise, who's coming in and says, thanks for introducing many new great creators. I'm here for it. I love to shout people out. I'm here to help. I have a platform. Why not use it to help people? Especially women helping other women, which I love. Tony, my way to handle the rage is that I listen with earbuds while I'm taking my morning walk. I close my fitness rings by 9 a.m. California time. That's amazing. I wish I could rage exercise. That would be really great. Rage exercising. Maybe I'll have to take that up. The Goodmans are here and they gifted 5 memberships, and look at their logo. It's the I Went to Cancun with Attorney Melanie Little logo. You too. You too can have one of those sweatshirts if you so desire. The link to the merch is in the chat. Let me see if there's a merch sale going on right now, because merch store, it's a third-party vendor, but sometimes they have sales, and I like to tell you about the sales just in case they having a sale right now. Oh yeah, it's 20% off everything in the merch shop today. I'll link the merch in the chat, and we'll take a look at some of the merch while we're waiting for court to come back. So you too can get your I Went to Cancun with Attorney Melanie Little shirt if you so desire. 20% off everything in the merch shop. It's not Amazon, you guys. It doesn't come in 2 days, but you got to make sure you click the little coupon at the top of the thing and put it in here. And then I got to pin it. It's like a whole procedure. You got to do it on your phone. Then you got to go here. You got to go there. Okay. All right, here we go. So for those of you who would like to partake in the merch, you have to, first thing you got to do, they're still on break. Don't worry, you're not missing anything. Is you got to click this little coupon at the top. It says only 4 days left, 20% off of everything. You got to click it. You got to hit the redeem button up here. Hot pro tip. And then you too can get your merch. If you don't know the lore behind the I Went to Cancun with Attorney Melanie Little, we can thank a Twittiot for asking Alan Jackson if he had fun with me in Cancun when he met him on the courthouse steps. Because I went to Dave Matthews in Cancun and I said, Alan Jackson, pretrial 1 had a bracelet on. I said, oh, that looks like a bracelet I got from the Dave Matthews Cancun shows last week. And then the Twittiot started a Twitter rumor. Melanie Little was in Cancun with Alan Jackson. I'm like, first of all, he doesn't know who I am. Second of all, I don't even know if he likes Dave Matthews. Really? Hank Breenan's faux outrage gifted 10 memberships. Thank you so much. And then Charlie Lynn gifted 5. So right there's 20 new members. You guys are so amazing and so generous. And I love you with all of my heart. So look at this cool apron. Love this apron. Comes in many colors. We have all kinds of things and stuff for people. Some of the stuff says free Karen Read on the front with a logo on the back. But if I could like zoom in on the logo for you, I would. It's so you can just at least see the logo. It's kind of a nod to the Grateful Dead. And also, I Went to Cancun with Attorney Melanie Little, established 2024. There's also stickers. There's also magnets. There's also mugs. And then there's also the best hoodie, in my opinion. I've got 2 of these. This is, it's a Bella and Canvas hoodie. The sizing runs very, very big, but it is super, super, super soft. It's got the free Karen Read on the front. It's got the I Went to Cancun with Attorney Melanie Little on the back. Comes in many colors like navy. Let's see the front of that one. Navy. Bella and Canvas is the highest quality merch that they offer. In my opinion, it's super soft. And I also have this orange color, which I love. It's not a bright orange. It's more of like a burnt orange. And then, we have a little something for everyone. We've got the ones that are pink. Let's go back. These are also awesome. I love these. This is called the oversized hooded sweatshirt. I have it in the oatmeal color. And did they stop making the other blue color that I like? Huh. Maybe. Got a cool baseball t-shirt. I think this is the back. And then the logo's on the front of this one. That's cool. When Karen wins, we got to make up a new t-shirt. We freed Karen Read. Well, you can make that one. Then we've got these, which also come in pink, which is cool. Then we, of course, have other designs like It Strains Credulity, which is something I've been saying for a long time about a lot of this stuff. This one comes in a cool pink also. This one comes in a light pink. Some tie-dyes. We've got the What Say You on the tie-dye, which is cool. That other design did not look right on a tie-dye, so I didn't use it. The It Strains Credulity here with Alice. And then we've got the, where's the Stay Cool, Stay Kind, Stay Classy? When you can't find your stuff in your own merch shop, you got issues. We got Come For Me in the comments. This is fun. I used to say that a lot. I don't say that so much anymore. Come For Me in the comments. And then we have the ones that say, or the ones that say stay cool, stay calm, stay classy. Here it is. All right, so this on the front says free Karen Read, and on the back says we are outraged. Stay cool, stay kind, stay classy, Attorney Melanie Little. It's all 20% off. So, you know, I pinned the link in the chat if you want. Everything's 20% off. So enjoy. Enjoy if you choose to partake. I don't make a lot of money on merch at all. So I won't even tell you what I'm doing with the profits because I'm not one of those people that does things for clout. And so trust me when I tell you that the profits to this merch are going to a very, very, very excellent cause. Thank you, Charlie Lynn. Heads everywhere. Denise, my son, a Toyota store manager, says Lexus have had backup cameras since 2016. Yes, no, we know, but do they record? Do they record? Yes, you may suggest a lightweight zip up, Stephen, in the store. That one that I just pointed out to you, the Bella and Canvas, is a lightweight one. It is a lightweight one. It is not heavy at all. The heaviest one in there is the oversized, I think it's the oversized men's hoodie because I have that one. And it's the one that I pointed out to you, the Bella and Canvas, that is a unisex. And it also is very light and it's super soft. So thank you, Stephen, for emailing me to ask me that question. I will allow it. Does it record the backup events? I don't think it does. Does it record collisions? Look, Teslas do. And I think they were on the cutting edge when they decided to do that. Red's daughter said, I found it very offensive when Welcher said he is sure he has bored these people to death. How unprofessional during a murder trial. Yeah. Yeah, a lot of things he did was unprofessional. Welcher, I agree. I'm with you on that. My pups wanted to Dennis the Menace. We covered that one before. He said, I've never seen an officer's murder trial with at least one officer to represent, but no Boston PD rep. Well, first of all, law enforcement has been prohibited from wearing uniforms in the gallery or when they testify. Second of all, this is a tiny courtroom. There's only 10 seats for the O'Keefe family, 10 seats for the Reed family, and 10 seats for media. That's it. There's no public seating. So unless you get an invite, you're not coming in. Also, Carl Dougal has been there. He was a friend of John O'Keefe's. He is often sitting with the Reed family. He was kicked out of the first trial because he allegedly knocked into Karen Reed in the hallway, allegedly maybe on purpose. But he's the only one that I've seen who happens to be active Boston PD. Is Carl Dougal still 1:55 tomorrow? Yeah, no, they said 2. What time is it now? 2:06. You know, why be on time? Our time is not important. We do ship to the UK, Alicia Joe. Yes, we do. Yes, we do. I think in some countries we even have the merch translated into your language. So that's what I got to say to that, Churicity. Carl Dougal's the only one I've seen there, and I think he's still active, Boston PD, right? He was a friend of John's. His wife is also in the courtroom. Dougal, sit with the I'm sorry, yeah, they sit with the O'Keefe family, not the Reed family. I'm sorry, did I say that wrong? They sit with the O'Keefe family, yeah, near Paul O'Keefe, oftentimes. I'm sorry, I misspoke. Friend of the O'Keefe family, not the Reed yeah, no, but wasn't he a friend of John O'Keefe? Yeah. Okay, if I misspoke, I'm sorry. He's been sitting with the Reed family. I thought he said, no, with the O'Keefe family, near Paul O'Keefe. I could say not enough coffee, but that's not true. I've had like a gallon already of iced coffee today. Thank you, Nancy, for becoming a member. Brenda says, so wrong on so many levels. I've never been so interested in a case. And thanks so much. I love your coverage and personality. Massachusetts residents here. Thank you, Brenda. QG, did you watch trial 1 or are you just here for season 2? So much more interest in this case. Don, could you please refrain from the foul language in the chat? Thank you. Love you. Yeah, are you just here for season 2? Are you here for season 1? So much more interest in the case for season 2. It is worldwide. The world is watching. The world watched during the first trial, but more of the world is watching now because I think a lot of people thought, as I did when I first learned about this case, when it first happened, I remember seeing an article said, drunk woman knocks over and leaves her boyfriend, Boston police officer, die in the snow. Investigators say there's ring camera footage of the incident. And I, like many others, thought, oh, wow, that sucks. It's terrible. There's ring camera footage of it. Guess she's guilty. And I never really thought about it again until somebody else brought it to my attention. I have friends and family from Norfolk County specifically. And I have been told from decades ago how corrupt the police in that that particular county are. So I took great interest in this case, having been told that all the way back decades ago. And I thought, let me see if there's something to this. I didn't read any of Turtle Boy's coverage. I didn't even know about Turtle Boy. Well, here's the thing about being behind on this is that sometimes court TV is behind on your TV. So they're back. Sometimes it comes up quicker on your phone than it does on the TV. So thank you.
Gilman, if we could turn to page about your opinions. PowerPoint.
I could have been behind too, but I think it was the court TV. Okay, here we go. We haven't missed anything.
Mr. Brennan.
Arg, he makes me mad. Melanie's getting upset. Melanie's getting upset. Lucky's in the building, we've heard. I hope Lucky Lochran testifies today.
If we could turn to page 6 of Mr. DiSogra's amended PowerPoint presentation.
Your entire case was amended, Mr. Brannon. Your whole case was amended, and you don't want anybody to know it.
Sir, I want to ask you about your opinions, and inevitably, some of the slides that you've presented to this jury regarding adjusting the clock in a time period of 3 seconds. You have given an opinion that there's a difference that you see in the reports between when the defendant's Lexus is powered on and the infotainment system begins, correct?
Yes.
There's a 3-second difference on the exemplar vehicle between when the power is turned on and then the screen lights up, the ignition, the infotainment system.
The 3 seconds I'm referring to is the timestamp in the data from the SD card. So I'm referring to the timestamp in the SD card. It seems that that's coupled to the screen, but I just want to make it clear I'm referencing the data from the SD card.
The data from the SD card correlates directly to the infotainment system itself.
The date does, yes.
Because the SD card is with the other chips part of the board that makes up the infotainment system.
Yes.
That infotainment system powers the screen that goes on after a user presses the button to start the vehicle.
Yes.
So the time that the infotainment system is registering is when the infotainment system goes on, not the power on event.
Correct.
So that 3 seconds that was tested with the exemplar vehicle between pressing the button to turn the car on and the time the infotainment system turns on, the infotainment system clock does not accommodate that 3 seconds.
Correct.
So when we're talking about time on infotainment system, we're talking about after the 3 seconds when the screen comes on.
Yes.
Okay. Now you've made some slides and you've made some assumptions suggesting that that 3 seconds should be added to your analysis. And I want to ask you about your analysis regarding the 3 seconds. If we could.
I'm going to stick a fork in my eye already. Shout out to Boots on the Ground. Robin says they want me to know that they're listening. I did put up some messages earlier. Shout out to all of you Boots on the Ground. We love you. We love you. You're out there. You're getting it done. You're helping to free our girl. And your dedication does not go unnoticed.
Turn to page 7, please. If you could zoom in on the left side. Sir, you told us that you didn't do any testing or data vetting yourself. You simply relied on reading and reviewing Mr. Burgess's report and Mr. Welch's report.
Correct.
And really, the information you're reviewing is Mr. Burgess's report. There's only a few references in Mr. Welch's report where he cites Mr. Burgess's findings, correct?
Most of it is from Mr. Burgess's reports.
There's really nothing in any of Dr. Welch's reports that you are considering that is not in Mr. Burgess's report.
It's really nothing in
The
either of those reports.
0.154 alignment methodology, I think exclusively is in Dr. Welcher's and is not present in Mr. Burgess's.
Did you read both of Mr. Burgess's reports?
Yes.
You're not aware that Mr. Burgess talks about that timestamp in his reports?
He mentions it in the second report to say that he doesn't think, basically, he doesn't think Dr. Welcher should have aligned it on that.
That is exactly not what he said. Where in the report?
I'm sorry?
Where in his report?
Is Brennan now going to testify? We know he wants to be the judge. Now he also wants to be the witness. That is exactly not what his report said. Where's Big Case Mike when you need him? I hate that. Remember Big Case Mike, you guys? I got to hear this again.
Dr. Welcher's and is not present in Mr. Burgess's.
Did you read both of Mr. Burgess's reports?
Yes.
You're not aware that Mr. Burgess talks about that timestamp in his reports?
He mentions it in the second report to say that he doesn't think, basically, he doesn't think Dr. Welcher should have aligned it on that.
That is exactly not what he said. Where in the report?
State.
Where in his report does he say?
Strike it. It's enough already. Brennan wants to testify because his case sucks.
Not what he said. Where in the report?
State.
Where in his report does he say that Dr. Welcher should not have relied on 154? Where does it say that in his report? I have it here. If you can give me the page, we will take a look at it.
I don't know the page, and I'm paraphrasing. By no means am I conveying that as I'm directly quoting it, but I remember that as something I read in there.
Well, I was careful in your affidavit not to paraphrase you, right?
Sustained.
So,
What a dick. What a dick. I was careful in your affidavit not to paraphrase you. What affidavit are you talking about, you dumbass? Hold on. Did you say affidavit?
But I remember that as something I read in there.
Well, I was careful in your affidavit not to paraphrase you, right?
What?
Sustained.
So,
what affidavit?
When you just made that assumption or that suggestion characterizing Dr. Welcher's state of mind or thought process, is there anywhere in the report you can cite or show me where Dr. Welcher said that?
No.
Okay. When you read Mr. Burgess's report and you learned that he and others obtained an exemplar vehicle and did this testing, you have no other independent information to suggest that the power on, power off event and 3-second delay is inaccurate, do you?
I just want to make sure I heard you. Did you say accurate or inaccurate?
Inaccurate. I'm sorry, the fan's on. I'm trying to
I know
shout.
that's the only reason I couldn't hear that. So can you state it one more time?
I'll rephrase it. When you reviewed Mr. Burgess's report and reviewed the information about his exemplar testing regarding the 3-second difference between turning on the car and the infotainment system going on, you have no other information that you looked at or studied that changes that analysis, do you?
No.
Now, when you are suggesting, could we shrink that and zoom on the right side, please? When you are suggesting that 3 seconds should be added to the time because of that 3-second gap, do you think maybe you made a mistake in considering it that way?
No.
Okay. The time that you're adding 3 seconds to is the infotainment time, the infotainment clock, correct?
Yes.
The infotainment clock begins when the infotainment system goes on. We just spoke about that, correct?
Right.
Which is 3 seconds after the power on event.
Correct.
So you're essentially double dipping. You're adding You're adding 3 seconds.
What happened? Double
that's
dipping.
Already been separated because it isn't reflected on the infotainment system. Isn't that true?
That's incorrect.
You believe that 3 seconds between the power on and the infotainment system going on should be accommodated extra on top of it.
It's not that it's extra. It's because when we're talking about times here, we're pulling a time from the infotainment and we're marrying that with a key on timer from the vehicle control history. Those are separate systems. So if the vehicle control history had its own time, then what you're saying would be correct. We wouldn't account for any delays because then it's already baked into those numbers. But this is a very unique analysis. This is not something I've ever even seen, this type of analysis here where we're comparing a timestamp from an infotainment SD card to a VCH total time. And so the only way to reconcile those two is we have to align them. And the 3 seconds is the alignment between those because the VCH key on timer is going to start as soon as the vehicle is turned on. And that's the 3 seconds.
He's going to glom onto that. Oh, you've never seen that before? Oh, look, what is this device that Bob Alessi has in his hand? It's like a huge tablet that he can write on. I like it. Techies, tell me.
You've never seen this before.
I've never seen the approach taken here in this analysis by Aperture. That's what I meant by this. I'll clarify. I have not seen a timestamp from a key on event in a Lexus infotainment used in addition to the key on timer from that same Lexus.
You know, Mr. Burgess actually looked at the data, not just the timestamp. You looked at the data. You understand that, don't you?
Sure.
You did not, did you?
Which data?
The data for the timestamp on the text stream data.
There is no timestamp on the text stream data, is my point.
Great.
It's a derived value from the key on time, and then added to that is the elapsed time from the text stream. So they're separate.
Did you look at the data to make that determination that you're claiming right now? Did you actually look at the data?
Yes. Yeah.
You looked at the raw data?
I looked at, yes, the raw text stream data.
The raw text stream data from infotainment, did you look at it?
I just don't want to mince it. The text stream data is an independent system from the infotainment, and you said from, so they're not.
Did you look at the infotainment raw data?
I did.
Okay. And did you find a timestamp on the infotainment raw data?
Yes.
Now, when you added 3 seconds.
It's called a remarkable. I've never heard of a remarkable before, but now I need to know. Not an iPad. Thank you. What is remarkable is that I haven't stuck a fork in my eye during Hank Brennan's grating voice, but I'll let him keep talking.
Seconds.
Sorry.
Now, when you added 3 seconds, you were trying to, in addition to the infotainment data, you were adding on the 3 second delay that now you're saying might not even be accurate. Is that fair to say?
I don't think I've ever said it's not accurate. I said that in the exemplar testing, they documented this behavior of a 3 second delay. And that needs to be accounted for if you're going to correct the timestamps. However, the caveat I put on that was only with one exemplar vehicle. So it could be that this behavior, the 3 seconds, is unique to the exemplar and would not apply to other similar vehicles. And so that's why I did either nothing or the 3, because there's nothing to support something in between.
So you disagree that the clock stamp on the infotainment module begins the run. You believe that there's potentially 3 seconds before when the ignition goes on that should be added to that time.
I know from testing other Toyota systems that the key on timer happens almost at the identical time that the vehicle is turned on. That timer starts running basically immediately.
But on this case, you don't know anything firsthand because you didn't do the testing yourself.
I don't know if it would specifically apply to this Lexus. I know that from other Toyota testing, but not this specific Lexus.
I'm sorry, finish.
No, I'm clarifying. I do know that from other Toyota and VCH systems that key on timer is basically simultaneous with the key on. I have not tested it on this, and I don't believe that it was tested by Aperture when they had it either. They didn't document the accuracy of the run timer in their exemplar, so we don't know.
Well, you don't know that they didn't document that.
To be fair, if they did, it was not in their reports.
Right. So in this case, you said cars are different, and that's why you're hesitant to accept the fact that there's a 3 second delay. It's a yes or no question.
I'm saying we don't know. Had Aperture done testing with a separate vehicle, then we could establish, is the 3 seconds the same? or is it unique? We don't know. The answer is we don't know.
And so when you are determining that 3-second variance, you don't have any assurance in your own mind whether or not this car, Miss Reed's Lexus, has a 3-second variance. That's what you're trying to say.
That's correct. And that's why I run my calculations with and without it.
And the way you would determine that is to actually do testing or look at the data.
More testing, I think, is the only way that that would be able to be determined.
Now let's turn to slide 9. As part of your charts, could you enlarge the left, please? As part of your charts, you took this chalk from Attorney Burgess's report and you made some assumptions about this, didn't you?
I'm not sure.
Okay.
I applied the numbers in his third column to the times. So, I mean, that's the extent of the analysis.
When you looked at the first 5 columns, 1:14, 13 a.m., 4:38, 16 a.m., 4:42:06 a.m., 4:45, 12 a.m., and 5:04, 28 a.m. You said on direct examination, oh boy.
Oh boy, Dedham Fire Department out front.
You said on direct examination that was matching infotainment to iPhone.
That's what it says on the chart. So
Okay.
that's probably what I said. I don't remember specifically, but that's what the chart says.
Is that your opinion that those first 5 columns are matching infotainment to iPhone?
The chart says infotainment call timestamp in column 1. It says O'Keefe iPhone call timestamps in column 2, and then it says offset. So I'm taking that at face value.
You're basing your later charts on the predicate that these numbers, the first 5 columns, are infotainment compared to John O'Keefe's iPhone, aren't you?
Based on the chart, yes.
You didn't do any study on your own to determine the genesis of that information, did you?
I'm aware of the fact that these calls, the 5 you mentioned, were placed when the vehicle was in a keyed off state. I'm aware of that.
What I asked you specifically is, on those 5 columns, did you do any research or study to determine whether or not it was infotainment matched to John O'Keefe's iPhone or some other phone matched to John O'Keefe's iPhone? Did you do any independent studies about that?
No.
Because in your ultimate conclusions and all the charts you've given to the jury and shown the jury, it relies on the conclusion that the first 5 columns are a comparison between infotainment clock and John O'Keefe's iPhone. Isn't that fair to say?
That's exactly how the chart presents it, and that's how I present it.
Did you know that at 1:14:13 a.m. the defendant's Lexus was turned off?
Yes.
Did you know at 4:38:16 a.m. that the defendant's Lexus was turned off?
Yes.
And did you know for 4:42:06, 4:45:12, 5:04:28, did you know that her Lexus was turned off?
Yes.
Do you know that when you make phone calls, oh, by the way, do you know on those different times, the first 5 times, where that information is generated from?
Which column?
Left column, 1:14:13, all the way down to 5:04:28. Those 1, 2, 3, 4, 5 calls. Do you know where that information came from?
It came from the SD card from the infotainment.
Do you know where the genesis, the beginning, the source of that information? That matters, right? The source?
It would.
It would. Do you know where it came from?
The assumption, the assumption is if the vehicle has a timestamp and the phone wasn't connected, it would have been synchronized after the fact. But that wasn't tested. And Aperture didn't do any of that testing in their work to look at the behavior of a timestamp in the infotainment when a phone is synchronized after the fact.
Blaming Aperture is not going to get you out of answering the question. Did you know?
Sustained.
I'm sorry. He said something really rude, but I couldn't hear what it was. So let me turn it up on my end.
In their work to look at the behavior of a timestamp in the infotainment when a phone is synchronized after the fact.
Blaming Aperture is not going to get you out of answering the question.
Blaming Aperture is not going to get you out of answering the question. Funny that Genesis is brought into the chat because we are in the land of confusion. One of the songs on the mixtape.
Did you know?
Sustained.
We're not going to get you out of answering the question.
Did you know? Sustained.
Sure.
Can we approach, please? Please end this misery. He's being combative for no reason. He's badgering the witness. His behavior is abominable, but really, did we expect anything better? Oh, see, there's Elizabeth Little's new haircut. You guys are pointing that out to me. She's got some bangs. She's rocking the bangs. She looks like her hair's darker too. It's more ashy now than it was blonde before. Adorbs. She's adorbs. Love those flat clips. They're amazing. I have that exact same one. So you can wear the jaw clip in the car and it won't dig into your head if you.
Do you know?
Let me just say that Kelly Reid is there. Hi, Kelly. You look beautiful today. It's my custom and habit. I do that. Love you, Kelly. Okay.
Do you know the genesis, the source of those 4 numbers?
Definitively no.
Your entire premise for your slides and values and ranges depends on knowing the genesis of those numbers, doesn't it?
I relied on Mr. Burgess's explanation that those times were synchronized after the fact.
Did you know that those are all phone calls from
their
data to Mr. O'Keefe's phone?
Yes.
You did know that.
I know that they're phone calls
From who?
between. Sorry, can you maybe just state it more clearly? Because I'm not sure. I don't want to fumble through an answer if I don't understand the question. So,
You know where those calls came from? The source.
a phone.
Whose?
Miss Reed's phone.
Now, I know you're not an expert on mobile devices, but did you know when it's not a contemporaneous synchronization, you plug your phone in, it's going to register on the entertainment system, but come from the phone? Objection.
Sustained.
Do you know when someone plugs their phone in after they turn the car back on, how it synchronizes on the entertainment system?
I don't know if adjustments are made to those times during a synchronization or not. I think that's something that could be tested, and to my knowledge, was not tested.
If you don't know, then your conclusions and all your opinions to this jury is based on an assumption that you don't even know the predicate for. Isn't that fair to say?
My conclusions are based on all of the data that Mr. Burgess laid out. So he laid these out and went so far as to calculate the offsets himself. So there's something implied in his table by virtue of him calculating these that maybe he would decide to align them. And so, again, to provide the clarity on all the possible alignments, I included them.
But that's not what I asked. If you're making an improper assumption about the predicate, about these calls and the source of them, and you're wrong, that would change your entire analysis and conclusions and charts that we see in your later charts, wouldn't it?
Sure. If there was testing that showed that that is an invalid method on this specific Lexus and SD card, then of the 30 possibilities, some of them would end up being eliminated.
Did you know that?
Shut up. Hey, Dina. Dina said, hey, Melanie, we're streaming you down at the buffer zone. Hey, Dina and friends. Thank you for watching. She's Like Texas jumped in here and gifted 50 memberships. 50 memberships. I don't know what time this was. So congratulations to all 50 new members. That's amazing. You're super generous and kind, and I appreciate you so much. Wouldn't it matter if she had Apple CarPlay on her phone with regard to her phone syncing up with because you can plug in your phone just to charge it, right? It might not do anything. And a lot of cars, like some rental cars that I've had, do not have Apple CarPlay in them. And so I don't know where he's going with all of this Michigas, but She's Like Texas. Thank you. You're amazing. Thank you so much.
When an iPhone is plugged into a car, it downloads downloads the information from the iPhone on the infotainment system? You know that?
I don't know how the clocks are synchronized when you plug an iPhone into a car.
Well, if you don't know, how can you make conclusions based on part of it if you don't even know what it is?
The conclusions are based on the data in Mr. Burgess's report.
I know you're not an expert on mobile devices.
So I'm going to strike that. Go ahead and ask your question.
My apologies.
You're not apologizing.
If you have
It's not genuine.
a Lexus clock, the infotainment system, in an iPhone, you would agree that it's not unexpected to be variances, correct?
Correct.
When you're comparing two iPhones, do you have an opinion, do you agree that you would expect the variance to be very small, iPhone to iPhone?
I don't know.
Have you ever studied that before?
2 iPhones?
Yes.
No.
So as you sit there today, you don't have any expertise, any education, any knowledge about how closely 2 iPhones would sync with each other?
No.
Do you see in the first 5 columns the numbers are small, 22121?
Yes.
Would you agree iPhone to iPhone using the same source of time is generally going to be within 1 or 2 seconds of each other? Objection.
Sustained.
Do you have any opinion about whether iPhones to iPhones will generally be within 1 to 2 seconds of each other? Objection.
You can ask if there's an opinion. Do you have an opinion on that?
No.
Next question.
If the first 5 calls are iPhone to iPhone rather than infotainment to iPhone, you agree all of your assumptions and conclusions are inaccurate.
They're not iPhone to iPhone in the sense that column 1 came from the infotainment. The values were read from the SD card. So there's an assumption baked into what you're saying, that when a phone is synchronized, the infotainment assumes the times of the phone, but we don't know whether the infotainment would adjust those times to its own clock or not.
You're speculating now, aren't you?
We don't know. It wasn't tested. I don't know is the
You
answer.
don't know.
I don't know.
You don't know.
I do not.
Okay. Don't say we don't know. You don't know.
Sustained.
So
Mr. T is here. The Mr. T keychain is here, and he's got something to say to Hank Brennan, and it is this.
Shut up, fool.
Did you hear it? Because I'll play it again.
Shut up, fool. First name, Mr. Middle name, period. Last name, T. Quit your jibber jabber.
Yeah, that's a good one. Quit your jibber jabber.
this is iPhone to iPhone. Then your assumption on the first 5, 12221. If they're iPhone to iPhone and you're wrong about the fact it's infotainment to iPhone, your assumptions and conclusions are inaccurate, aren't they? Objection.
I'll allow this.
If the title of the first column had iPhone in it as well, then I would not have used it in my analysis.
But that's not the question. I appreciate that. My question is, if those first 5 calls were iPhone time to iPhone time, and you mistakenly analyze them as infotainment time to iPhone time, then the rest of your assumptions and charts would be inaccurate, wouldn't they? Objection.
Sustained.
At 5:21:36, do you know whether or not the defendant's Lexus was on?
I don't recall if that one was an on or an off point. I don't want to guess. I don't recall.
And so if you don't know if that was on or off, were you able to do an analysis whether this was phone to phone or infotainment to phone?
No.
5:30:31, do you know if the defendant's car was on?
That one I know the vehicle was on.
That's one timestamp on the infotainment system, 5:30:31, correct?
Correct.
And then in the O'Keefe iPhone call timestamps, there are 2 different numbers, 5:30:15, 5:30:52. Yes?
Yes.
Right. And do you appreciate that that is 2 separate calls, or do you think it's something different?
I'm going to paraphrase again Mr. Birch's report as I recall it, in that he stated during the testing they did with the exemplar calls placed in close succession would not necessarily both be logged in the infotainment. So as I understand this chart, what he's trying to say here is there were 2 calls placed. There were 2 call logs in Mr. O'Keefe's phone, but only 1 timestamp in the infotainment, and he couldn't determine which it corresponded to because of that observed behavior from testing.
I'm asking if you know.
I don't.
Did you ever look at phone records for the defendant or for Mr. O'Keefe to make a determination whether these are 2 separate calls or not? Did you ever do that?
No.
If these are 2 separate calls, can you explain to us why there is 1 timestamp?
Again, as I stated, that was behavior that was observed. The exact behavior was observed during the exemplar testing by Aperture. I don't know why that happens. Why does the infotainment not log every call? I don't. But I know that it was documented that that is a feature of this system.
This information was not taken from the exemplar vehicle, was it?
This table, no.
This information was taken from the infotainment system of the defendant's car. Isn't that true?
Yes.
And the phone calls were taken from Mr. O'Keefe's iPhone. Isn't that true?
Yes.
And so, you know why there would be 2 phone calls and only 1 timestamp?
Beyond the testing, the exemplar testing that showed an exemplar vehicle did that, no, I don't know why it happens.
Do you know that the infotainment system doesn't always capture all of the phone calls and the phone data in the download? Do you know that?
Yes.
Well, if you know that, can you conclude that even though there's 2 calls and only 1 timestamp, that's because how the infotainment system works?
I think that's the most logical assumption, that that's how it works.
So when you look at 530.15, right in the middle, and 530.52, it is impossible to tell which one relates to the 530.31 infotainment on the left. Compare. It's impossible, right?
Yes.
So there's 2 possibilities.
Yes.
One is that you have a difference, a disparity of 16 seconds.
Yes.
And the other one, going the opposite way, is a disparity of 21 seconds.
Correct.
And so when you add those disparities, you have 27 seconds disparity in those. Correct?
I'll allow that.
Is there a 27-second disparity when you compare the 2?
I'm not sure I understand the math.
530.31 is 16 seconds different than 530.15 on Mr. O'Keefe's phone. Yes?
Yes.
530.31 is 21 seconds different than the 530.15 phone call. Yes?
Yes.
And the difference is cut each way, one's minus, one's positive.
Correct.
So when you add those disparities, you get 27 seconds. Don't you? Objection.
I'm going to allow that.
No.
Okay. What do you get?
You're saying if, maybe, so I can be clear what you're asking, if we have a negative 16 and we have a positive 21,
Correct.
How many seconds are in between there?
Exactly.
37?
And so you can see, did you know that the defense car was turned on at 5:07 a.m.? Does that ring a bell?
I don't have any of those key-ons committed to memory.
So you can see between 5:21 and 5:30, the offset is different between them, which shows that variances change. They move.
That seems reasonable, yes.
But when I said it seems reasonable, do you have the experience and the knowledge to agree with me that variances move?
Yes, they do.
Okay. If those first 5 calls were iPhone to iPhone rather than infotainment to iPhone, would you agree they should not have been considered in your analysis?
Yes, with the caveat that because this is a novel analysis with this SD card and this infotainment, that it was demonstrated that that's the behavior. My opinions on things like that are based on testing and research and literature. And so when we have a brand new system with new data, we want to see some testing to prove it works the way we think it works. But under the assumption, then yes.
You would agree?
Yes.
If we turn to 10, please.
Dexter, save us. That was a great comment. I got to make a Dexter thing to put in the corner. We need Dexter.
Given,
Cat.
could you zoom in a little, please, on the left?
Is he going to burn this till the end of the day so Lucky doesn't come on the stand?
Given that these data points come at 5 in the morning, or 1, 4, 4, 4, 5, 5, and 5:30, did you consider whether they would be less reliable than comparing to the triggering event, the 3-point turn at 12:23 the night before? Did you consider that?
Yes.
When you said you reviewed and you're critiquing reports, did you read Mr. Burgess's report on May 8, 2025?
Yes.
Did you read in his report where he explains that this is a less reliable method to, it's a less reliable method because of the time distance between the actual event we're interested in, 1162 at 12:30, 1:43 to 48, than the 3-point turn?
Yes.
Okay. When he explains that the method of using 5:21 and 5:30 on January 29, 2022, he explains about how the information is stored in the infotainment system when it's powered back on, doesn't he?
I'm not sure.
Well, do you remember when you were reviewing his report that he explains the available call log correlation is restricted to a time frame between 5:21 and 5:30 a.m. on January 29, 2022, when the vehicle was powered on. All other calls stored in the infotainment module occurred while the vehicle was powered off, indicating those entries were synced from Miss Reed's iPhone upon reconnecting to the system on the morning of January 29th. You considered that when you decided or formulated your critique, didn't you?
Yes.
This further indicated that the associated timestamps for those calls originated from Miss Reed's iPhone. Did you read that?
Yes.
Relative to those first 5 columns, correct?
Yes.
This behavior was previously documented in the initial report, which is the January 30th report. Yes?
Yes.
You shrugged. I mean, I don't want you just to agree with me. Do you remember it was in the January 30th report?
I don't remember how he phrased it specifically. But I think there was somewhere around there where he noted that some calls were placed while the vehicle was off. I think that's basically what it said in the first one. I don't remember specifically.
Okay. Do you agree generally, or can I give you the report? You can look and remind yourself. I want to get your best memory on this.
Sure.
What would you like me to do?
If you'd like me to look at it, I'll look at it.
Sure. Do you have a copy? Would you like me to bring it
Do you
to
have the reports with you, sir?
Hold
Okay. Do you have an extra copy for him, Mr. Brennan?
Mine is marked. I just want to show the mark. Let me see if I can get a clean copy from the witness.
I don't usually like to call out the trolls, but I'm going to do it. I'm going to do it now. Anybody know somebody by the name of Mark Williams? Anybody know Mark Williams? Please send me an email if you do. Mark Williams just found it's so important to send me an email during this stream that says the following. So let's get this straight. It's okay for Jackson to be an ass, but when Brennan is, then it's a total issue. 2 question marks. Wow, Mel, you're a C word. And he spells out the C word and says, no wonder you're divorced. Anybody know Mark Williams? Mark William 19748. Anybody know who that guy is? Because we'll have his IP address within 5 minutes. First of all, you don't know anything about my marital status, you douchebag. How dare you? How dare, oh, we have an email for that. How dare you? If anybody knows who Mark William is, reach out. Reach out. Because if you think you're going to get away with that, sir, you might want to think again. We'll have your IP address in 5. Don't worry about it. What a jackass. Really, you took the time to like write that email?
I don't have a clean copy. I don't want to show you something that
time, then
It jumps at the same time every day, doesn't it? Hold on. This is what I deal with on a daily basis for reporting on a Karen Reed case, okay? Welcome to my world. I don't know what's wrong with people.
why there would be 2 phone calls and only 1 time stamp?
beyond
Is this where we were?
the testing, the exemplar testing that showed an exemplar vehicle did that. No, I don't know why it happened.
You got to interrupt the whole class, Mark William, so that we screw up at where we are in the stream because you're a dick. The exact behavior was observed. How far behind were we? This is what they do. This is what they do. Okay, so there was a sidebar right here. Were we before or after that?
From Miss Reed's iPhone upon reconnecting to the system
Probably
on the
got
morning
blocked.
of January 29th. You considered that when you decided or formulated your critique, didn't you?
Yes.
This further indicated that the associated timestamps for those calls originated from Miss Reed's iPhone. Did you read that?
Yes.
Relative to those first 5 columns, correct?
Yes.
This behavior was previously documented in the initial report, which is the January 30th report. Yes?
Oh, it's Proctor.
You
No
shrugged.
wonder.
I mean, I don't want you just to agree with me. Do you remember it was in the January 30th report?
I don't remember how he phrased it specifically. But I think there was somewhere around there where he noted that some calls were placed while the vehicle was off. I think that's
He didn't go to
basically what it said in
Cancun
the
with him.
first
But
one.
why is
I
he
don't
watching
remember
my show?
specifically.
Why is he watching my show?
Do you agree generally, or can I give you the report? You can look and remind yourself. I want to get your best memory on this.
Sure.
What would you like me to do?
If you'd like me to look at it, I'll look at it.
Sure. Do you have a copy? Would you like me to bring it
Do you
to
have the reports with you, sir?
not.
Okay. Do you have an extra copy for him, Mr. Brennan?
I have to call them out. I'm not going to let that go.
Let me see if I can get a clean copy.
He's looking for attention.
Okay. Why this is not an effective way of matching the time? Did you consider in his May 8, 2025 report, when he's talking about this method, when he says, as a result, this method yields a single reference point for potential alignment?
Yes.
And when
Call
he
logs
talks-
are discrete points.
I'm sorry?
The call logs are discrete points for alignment. Is that?
As a result, this method yields a single reference point, is referring to the 53031.
I don't know. It sounds like it, but I don't know.
From the 5:21 a.m. to the 5:30 a.m. window, a clock speed of approximately -8 and -16 plus 21 seconds were observed between the Lexus clock and Mr. O'Keefe's iPhone clock. Did you consider that?
Yes.
This offset is measured approximately 5 hours after the time of the collision and cannot be assumed to apply to other time frames stated in the initial report. Objection.
I'm going to allow it unless, do you have, I'll see Councilor Tadmar.
I just bring on parachuting matron saint of Karen Reed. Birthday tomorrow. Please grant my wish that today is left on a positive note for the defense. Today is murky and I'm worried that we're losing the jury. All right, moving forward. Thanks, Marianne. She sent me a memo and said, screw that dirtbag. Here's money for a cocktail. I just, I don't like that people hide behind their fake names and their fake bullshit and then write me emails like that. Like, who do you think you are?
Sir, going back to my question, so you read Mr. Burgess' report, the same report that you're critiquing, and you were aware of this information, weren't you?
Yes.
And so you were aware that Mr. Burgess in his May 8th report was identifying that the section in green was the only contemporaneous information for analysis. Did you know that?
Is that how he states it specifically?
I can read it again. I just read it to you.
If you don't mind.
Okay.
So let's give him
He's being,
I'm sorry, Your Honor?
let's give him a copy. Does he have the clean copy?
he's badgering the witness at this point. Is he driving anybody else crazy? Yeah. You drive me crazy. Is that on the playlist? It should be. Yeah, I hate that C word too. I do too. I think it's the most disgusting word that a man could ever call a woman,
Turn to page 3.
in my opinion. I know that in the UK, it's like a common thing. It's like
What
not
I
that
read
big of
to
a deal.
you is where it says
deal here.
clock sync method 1. Do you see that?
Yes.
And this is, if you look at the second paragraph, I read that to you word for word. Do you see that?
Yes.
The 5:21 a.m. and 5:30 a.m. are the only 2 data points when that car was on January 29, 2022. Is that fair to say?
Yes.
Okay. And if you look at the last paragraph, do you agree or disagree? As a result, this method yields a single reference point for potential alignment. Do you agree with that?
No.
Okay. Because you still are under the mistaken belief that
Sustained.
you still have the opinion
It was
that the
sustained.
first 5 rows are an infotainment to iPhone analysis.
It's presented as that way in his initial report, which is what my initial analysis was based on. And in the supplemental report, there's no further testing to say one way or the other. He just has a new opinion. So I stand by the initial analysis that I had, that those points should be included with all of the other points.
Right, Charlie Lane. Serious question. Does Hank realize he is discrediting his own experts' data and analysis? That's exactly what he's doing here. I don't think he realizes it because I don't think he's really that smart.
But that's not my question. My question is, you are taking the position those first 5 calls are an infotainment to iPhone analysis.
They could be, and so I include them. I'm not saying they definitively are or not, which is why I never say there is one way to do it. That's why I say there's a whole host of ways to do it.
So you're now saying that you're not assuming that's an infotainment to iPhone analysis. Are you now saying that?
It's stated that way, and I think it could be that way, but it might be iPhone to iPhone too, if those times are just copied over.
And if it was iPhone to iPhone, your analysis would be wrong.
Certain lines would go away. So if you want to call the whole analysis wrong because of that, it might be your characterization.
Don't give it to
would
him.
Change the total number of possibilities.
So if we put up chart 12, page 12, please.
I mean, it can't be time for a cupcake break yet because they just got back from lunch at 2 o'clock. It's not even 3.
If you were wrong about the infotainment to iPhone analysis and those first 5 should not be considered, which part of your chart would now be wrong?
What do we have?
I wouldn't adopt the word wrong.
12 lines on the chart?
I'm sorry?
Yeah, we have 12 lines on the chart. If we decided to eliminate the lines that are based on the calls when the vehicle was off, we would be left with 4 lines on the chart.
And if we turn to 14, please.
To me, not about
if you could enlarge, no, I don't think you can enlarge.
Twitter. Congratulating himself.
If your analysis about infotainment to iPhone was wrong, you would agree those first 1, 2, 3, 4, 5, 6 columns should not be there, should they?
No, the positive 16 stays, the negative 21 stays, 1, 2, 8, and 20 would go away. So we'd lose 4 lines from this chart.
And the negative 16 line, that comes from information at 5:30 a.m. the next morning.
Correct.
And you would agree that that distance is not as accurate as queuing it from the 3-point turn event 11:62:1.
The 3-point turn is closer in time than the call at 5:32.
And thus more reliable, wouldn't you say?
Generally.
And the negative 21, that was from 5:30 and some seconds the next morning. Same idea, not as reliable as the 3-point turn information.
There's greater uncertainty the farther in time we get.
So when we turn to the 3-point turn information, you mentioned in Dr. Welcher's report that it was noted that the timestamp 154 was the end of the 3-point turn event, correct?
That's how he states it.
And then more information was provided when Mr. Burgess then broke down that 154 timestamp, correct?
Correct.
And when he broke down the 154 timestamp, he actually wrote a report about it, didn't he?
Yes.
He didn't just have it in his head. He put it on paper for all to see, yes?
Yes.
And in that report, not only does he break down the data, he also shows a visual of the actual data on a map, doesn't he?
He does.
Hey, Vet Girl, thank you so much for the 50. Thanks for tuning in. Hold expert, you got this. He's trying to wear him down. He is. He's trying to wear him down. But he's agreeing with a lot of the stuff that Brendan is saying. But I don't know if it's material really or relevant. All he's doing is trying to discredit Burgess with his report and saying this is how Burgess did the math wrong.
Yes.
Did Aiden have to leave the courtroom? Does anybody know? Because he's not live tweeting anymore. Did he have to make the bus or something? I want to know what the jury's doing, and nobody's. I don't think Sue O'Connell is in there after lunch either.
Okay. Let's start with 192B, please.
Oh, is Jess there?
If you could open that up so we could see it a little better. When you look at the data he actually broke down, do you agree that instead of at the end of the 3-point turn event as timestamp 154, that actually is at the beginning of the 3-point turn? Do you agree with that?
I don't know if the points are numbered on here, so I can't tell which point he's referencing as 154.
Do you see the green circle?
Yes.
Do you see the black line?
Yes.
Does that orient you to the direction the car was traveling?
That appears to be what he's trying to convey with this chart.
And then the yellow is facing a different direction towards Fairview, correct?
It is.
And do you see the green square rectangle?
Yes.
You think that correlates to the green circle?
The green square rectangle.
That seems to be what this graph implies.
Okay. And it notes that.
Oh, okay, I see.
So ask it differently, Mr. Hall.
Heading change.
Does that heading note the start of the 3-point turn of O'Keefe's phone is 12:23:59?
I'm going to allow it.
The document speaks for itself.
That's what Mr. Burgess states in the report.
And do you have any information to suggest that's not spot on accurate?
No, I didn't do an independent analysis of the 3-point turn maneuver.
And then the heading of the change, end of 3-point turn to O'Keefe's home, 12:24:07. Do you have any information to suggest that's not spot on accurate?
I did not analyze the 3-point turn maneuver.
And so when you look at that and break down 154, did you determine or make an analysis that 154 that was generally accepted, because there is variances between items, when you break it down with more specificity, 154 is actually earlier than the 3-point turn conclusion. Did you consider that?
I'm going to allow that, yeah.
Did you consider what now?
I'm not sure I understand the question, if you don't mind.
You mentioned Dr. Welch's report said it relied on 154 as a timestamp for the end of the 3-point turn.
Yes.
Based on Mr. Burgess's May 8th report and based on the data, which you don't contest, you now agree that 154 was not the end of that 3-point turn. It was at the beginning.
Based on how Mr. Burgess presents it, I didn't do an independent analysis. So I'm not on one side with Mr. Burgess or one side with Dr. Welcher. They present independent methods.
Are you suggesting in any way it's inaccurate? Are you suggesting it is in any way inaccurate?
I'm going to allow that.
I don't have any opinions as to the individual accuracy of the methods selected by either Mr. Burgess or Dr. Welcher.
Do you have any information you'd like to add or weigh in on to dispute the accuracy of those times?
Sustained.
And let's turn to the previous exhibit so we can actually see the data that's broken down. You could open that.
Thank you, Azran Fish, who is boots on the ground today.
The 154 timestamp, if you go to the left, please. Do you see that right above the green line?
Yes.
12/23/58. You see that?
Yes.
And then the green goes to the orange, and that's an 8-second difference, isn't it?
Yes.
And when you looked at this, you considered that this was a more detailed study of that timestamp by Mr. Burgess, right?
More detailed is, yes, that's correct.
And do you know why he did a more detailed analysis of this? Why it wasn't in the original PowerPoint?
No, I don't.
Well, you said that variances are generally accepted in the community, right?
Yes.
But then you wrote a report suggesting numbers and additions, and you submitted that report as part of the basis of your testimony, right?
I only submitted a PowerPoint. I have no report.
PowerPoint. And after you submitted the PowerPoint, isn't it fair to say Mr. Burgess then analyzed this data to be more specific after you introduced your PowerPoint?
Yes.
So can you guess why he went through a more detailed analysis?
No.
Sustain. Strike it.
That's what I think too,
And
vet
the
girl.
final exhibit.
Hank doesn't want Lucky to be the last witness of the day. Nothing that's in this case has to do with nothing,
Let's go
right?
back
Nothing
to
in
the
this
data.
has to do with anything.
You said that Mr. Burgess had an 8-second range, 21 to 29 seconds, remember?
Yes.
And you were suggesting that somehow there was some uncertainty. Do you remember that?
Yes.
Okay. Were you guessing about his state of mind, whether he was certain or not? Do you know why he gave an 8-second range? Objection.
So ask it differently, Mr.
Okay. You suggested the reason why there's an 8-second range is that Mr. Burgess was uncertain. Remember saying that to this jury?
Not in those exact words, but that's what uncertainty is. Uncertainty is a range. If we don't know a specific value, we put a range around it. That's uncertainty. That's a
This data from the green, would you agree it indicates the beginning of the three-point turn, and then the orange is at the end of the car is already in motion at 11.2 miles per hour? Objection.
I'm going to allow it. Do you agree with that?
I see speed values there. I see some headings. I can't convert GPS in my head, so I don't know.
You could have analyzed this data yourself, right? Before you came in and gave an opinion.
I could have.
But you didn't.
I did not.
You have any reason to test the accuracy of this data that's converted? No objection.
I'm going to allow that.
No.
And so by giving the range of 8 seconds, you talked about looking at different values to be fair, wide range, right? Even though this analysis depends on the end of the three-point turn, would you agree it's kind of forgiving to give that 8-second range to give the benefit of the doubt by starting at the beginning of the three-point turn all the way to the end of it rather than just giving the end point?
As to that form, ask it differently, Mr. Brown.
Does the 8-second range that is provided by Mr. Burgess coincide with the data and the 8-second range between the green and the orange?
That's where he comes up with the 8-second range, correct?
And so if aperture's position is the matching times at the end of the event, like going back to the beginning, isn't that even more forgiving than the 8 scientific objection?
I'm going to allow it.
I can't even hear the question.
Yeah, I would call it a conservative approach to use a range of values.
Right. The opposite of cherry picking, right?
Sure.
Thank you, Piney Woods.
Do you have an opinion to a reasonable degree of forensic data certainty about whether text stream data provides data reflecting whether a collision actually occurred?
No.
In your opinion, to a reasonable degree of forensic certainty is the text stream data would not reflect the collision, correct?
That's not what I said. I don't have an opinion.
And you know that there can be collisions or touching between vehicle, and it's not going to appear on the text stream data. You know that, right?
It's possible.
It's possible. Did you know that the
Forensic
defendant's
data certainty. Yeah.
vehicle at 5:07
Cringing.
a.m. on January 29, 2022 bumped into a different car?
Yes.
Do you see that reflected on the text stream data?
I'm thinking back to when I reviewed the raw text stream data, and I don't remember seeing an event from that.
I can't really
I
hear
don't
you.
remember seeing an event from that time in the text stream data.
Well, you don't remember seeing it. It's not there, is it?
I don't think it is. I don't remember seeing it. I don't think there's one.
You're not.
I was going to finish and say I don't have all of the events committed to memory. There's 19.
Okay. Somebody explain to me why her backing out of the driveway and just making a 3-point turn, because it's the 3-point turn. We've all seen it. Why that would not register as a 3-point turn when the 3-point turn on Cedar Crest is registering as a 3-point turn, and the 3-point turn in the driveway at Dighton, which we really think is key cycle 1162, is also a 3-point turn. There is no way that the jury, I don't think the jury's following this. Why wouldn't that even register as just a 3-point turn?
Of them.
I'm sorry.
There's 19 events. I don't have them all committed to memory.
You're not testifying or offering an opinion that there was no collision with this car that night, are you?
No.
Because if you were implying that or suggesting that or
It was in the morning.
insinuating that would be misleading, wouldn't it?
It's not.
Sustained.
I have no further questions.
Oh, for the love of the traveling Mary, praise be. Praise Kier at this point.
Yes.
Thank you. You were asked a number of questions a few minutes ago by Mr. Brennan concerning your expertise. I'm just going to grab a pen.
Please do. We have a little room to scooch here.
Specifically, you were asked about your expertise regarding mobile data devices. Mobile devices and their data, correct?
Yes.
And were you being truthful when you indicated that you were not an expert in
Yes.
that field? Were you being truthful when you indicated that you have a certain expertise in EDR data?
Yes.
Were you being truthful when you indicated that you did review Mr. Burgess's data and Mr. Welcher's data as reflected in their reports and PowerPoints?
Yes.
Were you being truthful about your credentials?
Yes.
Have you ever lied about your credentials?
No.
You hold a bachelor's degree?
Yes.
And you hold a master's degree?
I do.
You ever lied to anybody about that?
No.
Mr. DiSogra, what is the only reason you amended your PowerPoint presentation from its original version to the one that you most recently amended it to?
To include the additional analysis and data points from Mr. Burgess's supplemental report, the May 8th report.
I'm sorry, I interrupted you. Go
The
ahead.
May 8th report.
So you amended yours because he amended his.
Correct.
Tit for tat.
You were asked just a second ago about all the text stream events that you noted on Ms. Reed's SUV, correct?
Yes.
Mr. Brennan asked you about a specific text stream event at or around 5:07 in the morning, and whether you had something like that committed to memory, correct?
Yes.
You said, I don't have them all committed to memory, right?
I don't.
What did you say after that? Because there's how many?
It was 19 events prior to 1162-2, 19 other events.
How about after 1162?
There were a number after 1162-2. I don't have the exact count in my head.
How about after 1162, just on January 29th, going into January 30th?
Oh, yeah.
There were other events.
How many?
I don't recall the exact number.
Does 11 sound right?
That it sounds plausible. I recall seeing in the chart. I recall seeing a number of events after.
Would it refresh your recollection to look at a chart?
It would.
There were 11 other events recorded after 1162 before midnight. Is that what he said? Before the 30th? Mic drop. He doesn't have a laptop. He doesn't have a watch. He doesn't have an
Yeah,
emotional
there
support laptop.
Are a lot. I would have to really use my finger to
We have
count them all.
time. That's okay.
More than 8.
Total after 1162-2.
Only on the 29th.
There aren't date stamps on these because this chart is the raw text stream data, which doesn't have timestamps.
Safe to say there are many, right?
Yes.
Mayor, approach.
Yes.
And again, this goes back to a question that you were asked by Mr. Brennan. I want to follow up on. In no instance were any of those related to a collision, to your knowledge, correct?
Objection.
Sustained.
Were any of those that you reviewed at any time, the lifetime of the vehicle, related to a collision?
None of them were triggered by a collision.
Thank you. I want to ask you a hypothetical, if I could, based on questioning by Mr. Brennan surrounding the 12/32/09 lock event. Do you remember him asking about those questions, about that event?
Yes.
Your analysis was based on the time span. Let me rephrase that. Was your analysis based on Mr. Burgess's and Mr. Welcher's analyses together of a span of time between the 1162-2 text stream event or trigger event and the lock event at 12/32/09?
Objection.
So the question is that what he's considering?
Correct. In other words, was he basing his opinion or analysis on that time frame, at least in part?
So I'll let that question stand.
Thank you.
Yes.
Okay. If you were told that there was another interaction phone event on John O'Keefe's phone at 12/32/16 in the form of steps taken, 36 steps over the course of 83 feet, would that change your analysis or opinion in any way?
Objection.
I'll allow that in that form.
Yes.
In what way?
If the phone event moves from 12/32/09 to 12/32/16, then of the 30 possibilities I had in the chart, all of them would become positive. That would mean that that interaction occurs after the end of the vehicle event every single time. Instead of, it was 25 for 30 in the original analysis, the hypothetical would change it to 30 for 30.
All of them, all 30 of them would occur at a point in time. Let me rephrase that. All of them would reflect a scenario in which the phone interaction took place after the trigger event.
That's correct.
Thank you. If you were told, let me give you another hypothetical. If you were told that there was a Doppler state event on the phone, pocket state event on the phone at 12/33/14, would that impact your opinion in any way?
Objection.
Sustained.
Thank you, Remy, for gifting 5. You're awesome.
You were asked several questions about what you believed Mr. Burgess may have gotten wrong in terms of his original report and one of his original analyses dealing with bits and bytes. Do you recall that?
Yes.
Did Mr. Burgess?
Hold on.
Of course.
You need to, we have to turn the fans off.
And I'm not speaking loud enough?
Right.
I'm sorry. I'll raise my voice. I just don't want to scream over people, but I will raise my voice.
Let's try this for a few minutes.
Yeah, sure. Blame it on Alan
May I start
Jackson.
again?
When the jury starts sweating, they can blame it on him. Great idea, Judge. Great idea. We're going to have to turn the fans off.
That question, yes.
Thank you. Scream over people, but I will raise my voice.
Let's try this for a few minutes.
May I start again?
That question, yes.
Thank you. You were asked about whether or not you believed that Mr. Burgess was incorrect in terms of certain analyses he undertook or reflected in his original report back in January of 2025, correct?
Correct.
As it relates to the bits and bytes, did you find that Mr. Burgess was incorrect or correct about his analysis concerning the size of the data set collected based on bits versus bytes?
He was incorrect.
Explain that to the jurors very briefly.
These are just different units. A bit is a different size than a byte. And so if a size for something is listed in bits, for example, and you look at the data and assume it's in bytes, you will assume it's the wrong size.
Which Mr. Burgess did based on your review of his report, correct?
Correct.
He mixed up the big B and the little b.
I want to change gears and ask a different question or series of questions about the text stream data versus the infotainment system data, specifically the timestamps associated therewith. Is there a timestamp associated with text stream data?
In this case, no.
Okay. Is there a timestamp associated with infotainment system data?
Yes.
All right. The infotainment system data, well, let me see if I can ask it a different way. Where did the 3-second delay come from? Your analysis of Mr. Burgess's review of the text stream data or his review of the infotainment system data?
The 3 seconds came, well, fundamentally it came from the exemplar testing where he identified, and he was actually, well, Aperture collectively in that testing identified a difference between when the button was pushed and the time that showed up in the infotainment. But they didn't actually look at, as far as I know, or at least it wasn't provided if they did, how that specifically related to the key on timer itself. But they showed that the button is pushed, there's a 3-second delay, and then the time gets logged.
When that button is pushed for the infotainment system, I'm going to rephrase again, so I'm as clear as I can be. When that button is pushed for the on event, the key on event, is that like a stopwatch click? A stopwatch starts running? Timer?
In the VCH system, yes.
Okay. Separate and apart from the VCH system, is there an infotainment system that also has a timer or a clock on it?
Has a clock.
Are those two things independent of one another?
Completely independent.
What were you doing with regard to the 3-second delay as it relates to the key on event and the infotainment system event to marry those two things together?
Right. I'm making the adjustment or proposing that adjustment can be made because the key on timer is going to start generally as soon as the vehicle powers on. But the infotainment, when you go and download the data, it will say, hey, I think I powered on at this time, and it turns out that time is actually 3 seconds off. So if you're going to then apply the infotainment time anywhere else to VCH data, you've got to realign the two. And that's where the 3 seconds comes from, is these are independent data sources.
Did Mr. Burgess, to your review of his, insofar as your review of his analysis, his report is concerned, did he align the two vis-a-vis the 3-second delay?
No, he did not.
Thank you. With the court's permission, may we have slide 10 of the PowerPoint of,
Okay.
and that is, we've talked a lot about PowerPoints of Mr. DiSogra's PowerPoint. Can you highlight the table on the left, Mr. Wolk? Thank you. Did you create this table?
No.
Was this table, I don't know if you call it cut and paste or if there's some better engineering term for it, was it basically pulled from Mr. Burgess's report?
It was. It was
Did
a
you
screen.
type-
It was a screenshot.
Thank you, screenshot. Did you type a single word on this?
I did not. I added a green box.
Put a green box around it.
Yes,
You didn't type anything on this.
I did not.
You were asked a ton of questions just a few minutes ago about whether or not the column on the left and the center column were reflective of an infotainment timestamp versus an iPhone to iPhone timestamp, correct?
That's right.
Mr. Brennan asked you a bunch of questions about that left column being an iPhone timestamp, at least the top 5 rows of it. 1, 2, 3, 4, 5 rows of it. Remember that?
Yes.
Read the name that Mr. Burgess labeled that column.
Infotainment call timestamps.
So what, as an expert, what did you presume he, as an expert, was presuming?
There you go.
Sustain.
What did you presume that meant to you, just to you?
Call timestamps from the infotainment.
So if anything is wrong with your analysis, would it be based on Mr. Burgess being wrong in his analysis?
Objection.
Sustain.
Yes, though, that's exactly the point. He didn't create this. It's in his PowerPoint, but this is Burgess's own data. He was hired to analyze Burgess's analyzation of the data, analysis. He was hired to analyze Burgess's analysis. Thank you, Mimi. Love you, girl.
May I have just a moment, Your Honor?
Sure. Do you need the light on?
I don't. And we can pull that down. What was your entire analysis predicated on? What was it based on? The foundation of it, as you explained your analysis to Ms. Jury during the course of the day.
The testing by Aperture and the collective reports and PowerPoint presentations by Aperture. That would be an initial report by Mr. Burgess, an initial PowerPoint by Dr. Welcher, and a supplemental report by Mr. Burgess.
Did you change any of their data?
No,
Did you change any of their analyses?
no,
Did you explain their analyses?
yes.
Sustained, ask it to.
Sure. What were you trying to do in terms of your presentation, in your PowerPoint, and the presentation to the jury?
There were a number of different methodologies presented across all of those reports and PowerPoints, and sort of all in different places. So my goal was to bring all of them into one place so we could look at the totality of the data.
You were asked whether the genesis of your analysis relies on knowing the source of the calls, correct? You remember being asked that by Mr. Brennan?
Yes,
The actual genesis of your entire opinion is based on Mr. Burgess's and Mr. Welcher's analyses, correct?
that's correct.
You were also asked why you believed Mr. Burgess did a quote unquote more detailed report in May versus January of 2025. Do you remember being asked that just a few minutes ago?
Yes,
When you presented your analysis, your math, based on Mr. Burgess's January 2025 report, how many of the scenarios indicated, based on his data and his analysis, that the lock event occurred after the texting?
all of them.
Thank you. That's all I have, Your Honor.
All right, Mr. Brennan.
So, Mr. DiSogra, this demonstrates the danger or the difficulty.
Hold on.
First of all, his name's
Start-
DiSogra.
Start the
It's
question
cross-examination.
differently.
It has to be a question.
Start. Go ahead, Mr.
Has to be a question.
This demonstrates the difficulty in giving opinions when you don't actually study the data itself. Isn't that fair to say?
What are you referring to with this?
Well, you're giving opinions, but you can't verify any of the data because you're not relying on your study of the data, are you?
He's relying on your
Relying on expert reports.
You're criticizing somebody's report, but you yourself can't defend data that you haven't actually analyzed and broken down yourself.
I don't think that's true.
When you're looking at, turn on 10, please. When you're looking at someone's report, you're guessing as to what they thought or presumed if you haven't spoken to them. Fair?
You shouldn't have to guess if the expert report is clear. Nobody should have to guess. The entire premise of your persecution of Karen Reed is based on a guess, guesswork and hearsay from people who hate Karen Reed and or are protecting their own family and friends. What part of that don't you understand, Mr. Brennan?
Thought, you're looking at someone's report, you're guessing as to what they thought or presumed if you haven't spoken to them. Fair?
I would say I'm reading the words that are in front of me and interpreting them for what they say.
When someone plugs their iPhone into a car after it turns on, and the car reads data that's on the iPhone, that data then resides on the infotainment system, correct?
There's a transfer of data. Yes.
And so unless you actually do the study yourself, you had no way of knowing if that information, although on the iPhone, on the infotainment system, you had no idea whether it was from an iPhone or from the infotainment. Fair?
That's right. I don't think that's.
And so when you don't actually do the work yourself, and you just presume or you guess, you could get it wrong, couldn't you?
If I had guessed, yes, but I didn't guess. I used the data in the reports and I referenced the testing that Aperture did. So I did not make a guess.
1 through 5, and you telling me right now, to a reasonable degree of data certainty, that
Data
that
certainty?
information is based on the infotainment clock. Is that what you're saying?
I don't know.
You don't know. But if you actually did the analysis yourself rather than just Monday morning quarterback and somebody's report.
So,
Monday morning
I'm going to
quarterback.
Strike it, ask it differently.
Bella's mom is here and her head is rolling down the freeway and she had to pull over. She was so upset by this. Please drive safe, Bella's mom.
If you actually did the analysis
So,
yourself rather than just
Oh.
you don't know. But if you actually did the analysis yourself rather than just Monday morning quarterback and somebody's report.
so I'm going to strike it, ask it differently, Mr.
If you
Brown.
actually did the analysis yourself, you wouldn't have to make a presumption that you'd be wrong, correct?
I don't think the analysis was possible in this case because the testing wasn't done in this case.
You don't know if the testing was done or not. You didn't do the testing.
So I need to hear the question.
You don't know if the testing was done or not, do you?
I know it's in the reports. The testing wasn't in the reports.
Did you read Jessica Hyde's report?
No,
Did you read Ian Woodford's report?
no,
You don't know if that testing was done, do you?
I don't.
I'm going to let that stand. Next.
I do
Why?
not,
Because
sir.
he answered it?
And so if you're wrong, your assumptions and product of that are wrong.
Part of my conclusions would change. I wouldn't agree that I'm wholesale wrong.
Well, as a scientist, if they're not accurate, that would be wrong, wouldn't it?
That might be a nuanced answer.
I'm sorry?
I said that might be a nuanced answer. Frankly, I'm not sure how to give you a good answer to that
If you
question.
have the wrong data when you're doing your analysis, then the final analysis is going to be wrong. If you have using the wrong data, it's that simple.
Yes.
Right? You don't have to be a scientist to figure that out.
Yes. That's
Okay. If we could have Mr. Welcher's 33.
I don't know, collusion, not collision, why they
Open
can't
up,
keep it
please.
simple. We're all confused. We're in the land of
You
confusion.
were asked about
Two different
whether
versions, the Genesis one and the disturbed
the
one.
window is within the time frame of 12/32/09, the last user interaction with the phone. When you look at this data, could you go to the top, please? You see on vehicle speed, the car is moving. You see that? Could you enlarge that a little bit, please? The beginning of that data capture, the car's already moving, correct?
I see vehicle speeds, right, in those first couple of lines, yes.
Yes?
Yes, I see
Yes.
vehicle speed.
If you go to the bottom, at the end, the car is still moving, yes?
I see vehicle speeds there as well.
2361. That would indicate, in your experience with text stream data, the car is still moving, yes?
At the end of the record, there is a vehicle speed, the car is moving. That would be my assumption.
Okay. And so when you're making your conclusions that something's with or without, you're simply talking about the time of the 10 seconds of data. Yes?
Yeah, everything that I've done has been referencing the end of event 1162-2, which is exactly how it's been referenced in all of the other reports.
That 10-second window. Yes?
Not even the window, just the end. Everything in the Aperture reports talks about the end of event 1162-2. So that's what I used across everything.
And when you say end of event, you're referring just to data, not the actual real life event.
Yeah, absolutely. The end of the recording.
Okay. And so after that window, 12:32:04 to 12:32:12, you were asked a question about what might have happened 4 seconds later, 12:32:16. Remember you were asked about that?
Yes.
Did you know at 12:32:16 that John O'Keefe's cell phone moved for the last time? Did you know that?
No.
And between 12:32:12, which is in the 10-second window, and 12:32:16, do you know what John O'Keefe was doing in that 4-second period?
No.
Do you know if he was walking?
No.
Do you know if he was crawling?
No.
Do you know if he was falling?
No.
You don't know.
I do not know.
Okay.
12:32:16 wasn't just that Mr. O'Keefe's phone was moving, there were steps.
I didn't review the phone data, so I don't know.
Did you review anything to indicate that steps were taken over the course of the week?
Objection.
So that's sustained.
You were asked just a second ago. What about the data? What if it's wrong? Then you'd be wrong, correct?
Generally, yes.
Garbage in, garbage out. Basic
Right.
scientific postulate, correct?
Generally, yes.
Exactly.
You're relying on whose data?
Mr. Burgess's data and Dr. Welcher's data.
All right, Mr. DiSogra, you are all set, sir.
Garbage in, garbage out. That
Wanna
was
see
the point of that
counsel for a
whole
minute?
entire
Jurors, feel free to stand up.
lengthy exercise. What time did this man take the stand this morning? Ms. Mojo Rising, you're amazing. You're amazing. Seems that the guy who wrote me that email earlier calling me the C word
So.
may just be
Because we know we'll be longer. We don't
law
want to do this,
enforcement.
okay? So, we'll break for the
Makes
day.
sense, doesn't it?
I have to give you those.
We're breaking for the day. Lucky is not coming to the stand, really? Wow. Just wow.
All right. Jurors.
Well, 20-4.
We did that to have me decide whether I'm going to let you go home now or not, and I'm going to let you go home. So that 5 minutes that just took means that you get to go home, because we know we'll be longer. We don't want to do this to you, okay? So we'll break for the day. I have
Can you
give
apologize
those
to the
same
world?
Cautions. Please do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about the case, please disregard it and let us know. Additional caution, please be very careful. Continue to be careful with your social media use. We will see you Monday. Monday will be a full day.
I think You're So Vain is on.
Right around 9 on Monday morning. So we'll see you
Another
then.
weekend.
Have a great week.
Please rise to the jury.
Well, I think they have things to discuss, so let's see what they're going to discuss. If maybe some of those motions that we read this morning. Really? They're cutting it off? Hold on. Screw you, because Boston 25 might have it on still, so hang tight. Hold on, hang tight. Oh, okay, yeah, no, they're back. I heard somebody say Eugenia. Hold on. I mean, Core TV said that it was done, but it's not done, because then they just put the Put it back on. That was like a fake out. That was like a major fake out just there. You just saw it. You just saw it. And I just heard that closed captions just picked up the word Eugenia. So we know that Eugenia is the court officer and she's amazing. We love her. I like when the captions pick up some like hot mic moments. Sometimes that happens. All right, so we're just waiting. I guess they're going to come back and argue some things like the motions. I thought your surveying is on the playlist, but if it's not, it should be. Jury's gone.
Floor is now open, maybe seated.
So you're gonna step up, face the clerk, and raise your right hand.
You solemnly swear the evidence you give the court in the case now and hearing the truth, the whole truth, and nothing but the truth, so help you God. Thanks. You take the stand.
Thank you. I know this is a good opportunity. There is a witness outside. Just to get her.
Sure. Is she right outside the door?
Last time I checked.
Do you mind, sir, if you can stay right there?
Sure.
And it'll just be a few minutes, okay? Misty and Eddie, when do you need this witness back? Monday?
Misty and Eddie. Closed captions. Gotta love them. Who's right outside the door? What did I miss?
So I'm going to need her at a microphone. Do you have one on council table there? So the podium, or one of those back where Eugenia is. Thank you.
Eugenia, we love you so much. We don't know what's going here. They swore somebody in.
No, there's a microphone a little closer. We're just follow the.
We're waiting. Who's she? Is
Hi,
she-
good afternoon.
Hello,
Could you tell me your name, please?
Kelly Dever.
And Ms. Dever, you've been summoned here. I think I saw you earlier. You've been here all day.
Yes.
All right. So we're not going to reach you today, unfortunately, but you were summoned to be here.
Yes.
All right. So that summons is still good until we reach you. So you're going to have to come back Monday morning. Okay.
Yes, ma'am.
Do you agree to do so?
Yes, ma'am.
Okay. Thank you very much. We'll see you Monday morning. Be here before 9. Okay.
Will do.
All right. Thank you very much.
Thank you, Your Honor.
She might need an excuse to get out of work, and so they had to do it on the record.
Go ahead, Mr. Leslie.
She's with, where's she now, you guys? Boston PD?
Oh, she's in Eddie.
Wait,
Oh, she's in Eddie. Go ahead, Mr. Leslie.
Misty.
Oh,
I'm
she's in
Yannetti. She said, oh, Jesus, Misty and Eddie.
That was a big compliment, Your Honor. Thank you.
Oh, said it was a compliment to call
Good
Melissa.
afternoon, sir. Would you please state your name and spell your last name?
Jonathan Diamandis, Diamandis.
You've also been here all day.
Yes,
Sorry for making you wait.
no problem.
Do you know former State Trooper Michael Proctor?
I do.
How do you know him?
I've known him since middle school, probably the 6th grade.
Grew up with him essentially?
Grew up with him, been friends for 30 years.
Okay, and if you just keep your voice up,
Sure, yeah.
I'm sure other people can hear you, but this
So
old guy.
can we turn off the fans?
This is one of Chippy Proctor's friends who's been there all day. This is an offer of proof. We're doing a little voir dire to see what he would say. You saw, we read earlier, Brennan made a motion this morning. He does not want these guys coming in to testify. And so we're doing a voir dire because he's been sitting here all day. Jonathan Diamandis, shout out to you. He has hair. He's in the grammar school. He's in the grammar school text threat group of Proctor. Here we go. This will be fun.
Friends for 30 years.
Listen, 30 years.
I do.
How do you know him?
I've known him since middle school, probably the 6th grade.
Grew up with him essentially?
Grew up with him, been friends for 30 years.
Okay, and if you just keep your voice up,
Sure, yeah.
I'm sure other people can hear you, but this
So
old guy.
can we turn off the fans and the air conditioning? Are they all off? We're just going to do that, sir, so that we can get through this a little bit.
Absolutely, sure.
Much better, thank you. So you say you've known him since middle school, elementary school?
Yes,
Graduate high school with him?
yes,
And are you friends after high school as well?
yes,
Do you have his cell phone number in your phone?
I do.
Have you texted with him over the years?
I have.
In fact, were you on a group text chain with him that lasted a number of years?
Yes.
I would like to show you a document, sir, and I'm going to ask you to read it to yourself, familiarize yourself with it, and then when you're done, look up at me. Okay. May I approach?
Yes.
No, this is not Lucky. It's scrolling on the bottom. This is a 30-year friend of Michael Proctor. He's on the text message thread with him. If you weren't here this morning,
Would you like this mark for identification?
Brennan made a motion to not allow these guys to testify. He wants them to call Proctor to get those messages in. This is an offer of proof, also known as a voir dire, as to what this witness would say if called. And so that, oh, look at the judge. She's smiling at him. Hang on, check it out. Oh, she's looking a little bit giddy. Oh, we need this. My freeze game is on point again today. Wonder if they're still friends. Look, ooh, she's so happy. She bounced in her chair a little bit. She's a little bouncy right now. It's like, ooh, a couple of tasty snacks in the witness stand today. It's a lot more exciting than normal, right? From John Canone and Lydia. Justice Beverly J. Canone.
Thank you.
This is fun. Here's the text messages in which Michael Proctor called Karen Reed a whack job C-word and talked about her leaky something that I would not repeat. It said, gonna pin it on the girl. I don't know if that was actually in the text messages. Boston cop's gonna catch some shit. And he said, no. Oh, no, the homeowner is gonna catch some shit. And one of the friends said, nope. Nope. Proctor said, nope. He's a Boston cop too. Kimberly says, I hope I'm not driving my Harley to Dedham and crash daddies are testifying I might not make it there. Having to pull over and stop my feet. Thanks, Kimberly. Oh, you mean stomp your feet, probably. Marianne is quoting Mark Twain, no amount of evidence will ever persuade an idiot. Thank you. Thank you also, Judge Occiput Boner. This guy has such patience. Hank, he's mad. Thank you, Will Wallace. Today's lesson, garbage in, garbage out. So true. Proctor's dishonorable discharge from Canada says, I'm a complete disgrace and I love trolling here. Wave to my fans, Proctor. We see you. Nico 2020 says probably because Proctor will plead the fifth. Whether he can or not is in dispute. He's already testified in several proceedings before, so we shall see. I'm sure it's in the unlikely event that he might, and so why not call in all these other witnesses to say, yeah, this is him. This is what he said. I was there. I was in that conversation. But it seems like they have a lot more messages than that because they did say earlier, or in that motion, there's something like 30,000 messages in this group text in something like 8 months. Crafty councilwoman, I have a creepy feeling the court reporter is an anti-Bev ally. I hope I'm wrong. No. She's doing the Lord's work. No. This court reporter is amazing. I do not. I would never, ever disparage her. It is very, very difficult to do that job. And we love Nancy, the first Madam Court Reporter. We love this court reporter too. She's familiar to me. So I think, was she on the, Penny McGee trial? No, maybe.
Thank you, Ronald.
I know Madam Court Reporter's
on
Turk,
that,
Nancy.
Entire document?
Yes.
Does that look familiar to you?
Yes.
What do you recognize it to be?
It looks to be a text chain with a group of my friends that I grew up with.
Okay. And so would all of those friends have been people that you went to high school with?
Grammar school.
Not all the same high school, but the same time. Some of us went to different schools.
And you were friends during that era?
Yes.
And you've remained friends for how many years since then?
We've been friends for 30 plus years, probably.
Do you know precisely when that text chain started?
I do not know when the text chain started.
Months, years?
Years, definitely years.
And that's a portion, in other words, there's a start time and an end time to that. But the text chain started before the start time that's listed on that document?
That's correct.
Now, I'd like to ask you about 5 different categories of information that allow you to identify the text chain. First of all, directing your attention to page 1. That is an unredacted version of this. Do you see your phone number on page 1?
I do.
And is that accurate in terms of your phone number?
It is.
Well, do you have a passcode on your phone?
On my phone, yes, I do.
All right, and have you had that for years?
Yes,
So as of January of 2022, you would have had a passcode to get into your phone, correct?
correct.
With regard to the typing of text messages, you didn't appear to be too active on this thread, is that correct?
Not from what I see here.
Did you see one entry that you actually did text?
Yes, one.
Okay, and I think these page numbers, they're all numbered. Could you direct us to the page where you actually chimed in? And if I suggested to you, it might be 4 from the end. And you don't have to read the actual text, sir. I just want to.
Sure. I'm just trying to locate it. Yes, I see it.
Okay, and the time of that, date and time of that text as it's reflected on this document?
February 2nd, 2022, 12:38 p.m.
Okay, and what you type.
I have a different clock.
Oh,
That
I'm
was
sorry.
the day.
For the record, it's on page. Oh,
2222 was the day that Karen Reed was arraigned in Stoughton District Court. She was arrested on the 1st. She was held overnight. She was arraigned on the 2nd. 2222. At what time?
and for the record, reading what is typed there, does that sound consistent with something you might chime in a text message, a text chain of this sort?
I mean, it could be. I have no memory of actually typing it, but
sure,
that's not something. I mean, it could have been something that I would say. Yeah.
At the very last line of that text, do you mention somebody's nickname?
Yes.
And what nickname is that?
Chip.
And whom do you know as Chip?
Michael Proctor.
Now, going back to the first page, there are a number of other phone numbers there. Have you checked your phone prior to taking the stand today to match those phone numbers with other friends of yours?
Yes.
And if you could, and hopefully you remember them all, can you list by first name only your friends who are included in this text chain?
Sure.
Yeah.
You don't think it's
So let's
necessary,
not-
Brennan?
If he recognizes, I don't want to put names out.
Oh, I don't either, Judge.
First
That's why I was
names.
saying first names. But if that's sufficient that he recognizes,
Why don't you refer to the last 2 digits in the phone?
sure.
Sure.
Is that acceptable, Mr. Brennan?
It is.
Okay.
You don't mind doxing, though, the minor children, the niece and nephew of John O'Keefe, right? It's cool for you to mention their names in court, but you can't even call these guys by their first name. Who cares? We know who they are. There's a public filing about them. They've been added as witnesses.
You see, I'll list the last 2 digits of the phone numbers that don't have a name associated with them. Okay?
Okay.
If I may just have a moment.
Yes.
Yeah, it's funny how they're real protective when it comes to certain things and completely not when it comes to other things. I mean, I wonder if these guys are all friends with Proctor. You know they've been watching this trial.
Okay, starting with the phone number that ends in 51. After you checked your contacts, is that a friend of yours?
Yes, it is.
Who was on the text chain?
Correct.
With regard to the phone number that ends in 68, same question. Is that a friend of yours who was on the text chain?
Correct.
And with regard to 45, which is the next one, again, a friend of yours who was on the text chain?
That's me.
Oh, I'm sorry, that is you, of course. With regard to 95, is that a friend of yours who was on the text chain?
Yes, it is.
And with regard to 9-3, same question, friend of yours on the text chain?
Yes.
And then there are 3 numbers there, one that ends in 11, one that ends in 46, and one that ends in 82. Do you see that those particular numbers have a nickname associated with them?
Yes.
Those nicknames, do you recognize them as being also friends of yours who are on the text chain?
I do.
And then finally, there is somebody listed as local user. We'll get back to that one.
Okay.
With regard to the other ones that you've just identified, sir, have you texted back and forth with them on those phone numbers over the years?
Yes.
And also with regard to this particular text thread?
Yes.
All right.
He looks like a retro Karate Kid.
I'd also ask you, with regard to the content
Thanks, Maureen.
of these messages and who said what, and particularly focusing on the one that's identified as local user. Having read that text chain, were you able to determine who local user is?
Yes.
And who is that?
Michael Proctor.
And was that by the content of the messages that Michael Proctor typed that you recognized it?
Yes.
And with regard to whether this is a complete, accurate record of what it purports to be, what is your testimony in that regard?
I believe this to be a record of our text chain for this period of time.
Appears to be accurate and complete.
It does.
If I may have a moment, Your Honor.
He's authenticating the records. That's the purpose for him to be called to the stand. This is an accurate representation of our text message thread. Thank you. There's no reason why he should not be allowed to testify. He's been sitting there all day. I don't know. I don't know how.
The text message chain that you read fairly and accurately represent the circumstances of the conversation that was going on?
Yes.
Nothing further.
Mr. Brennan?
Good morning.
Good morning. Good afternoon.
Do you have an independent memory of any of the text conversations in the package that you reviewed?
I do not have a memory of this happening.
Thank you.
Nothing on that.
All right. So, sir, I'm going to ask you to, you're all set.
Okay.
I'm going to ask you to step down.
All set.
Your Honor, given that unfortunately this witness was not reached by the jury today, I would like him recognized as well.
He has counsel here with him, right? Does he have counsel here with him?
He has an attorney
Sir,
with
you'll
him?
make sure your client is here when we need him?
I will do so, Your Honor.
All right, thank you.
Why would he have his attorney with him?
My office is in Boston.
And I'll speak with Mr. Campbell in terms of an appropriate time of day.
Whoa, hold on. Whoa. I think he just said his name. Hold on, the attorney. Hold on.
Sir, you'll make sure your client is here when we need him?
I will do so, Your Honor.
All right.
Unfortunately, this witness was not reached by the jury today. I would like him recognized as well.
He has counsel here with him, right? Does he have counsel here with him? All right. Sir, you'll make sure your client is here when we need him?
I will do so, Your Honor.
All right, thank you.
My name is Thomas Campbell.
Thomas Campbell,
Boston.
Boston.
And I'll speak with Mr. Campbell in terms of an appropriate time of day. He's been very cooperative.
All right. So, sir.
Doesn't mean anything that he has an attorney, probably
Right,
smart.
and, thank you, Mr. Campbell. We'll see you. We'll let you know when we
Jonathan
need
brought his lawyer.
Probably going to be Monday first thing.
Understood.
Oh, that means she's going to allow him to testify. Sounds like to me. I don't blame him for having a lawyer either.
All right. I'll hear you, Mr. Yannetti.
So, Your Honor, my understanding is there's an objection, so I'd rather respond to the objection.
I want to hear you as to why this is admissible.
How about ask Brennan why it's not admissible? Why don't we start there, Your Honor? Why is the burden always on the defense? The prosecution is the one who needs to prove the case, Your Honor, beyond a reasonable doubt. There should be no burden on the defense. How about we start there? Thomas Campbell is the attorney for Jonathan Diamandis, who is the 30-year friend of Michael Proctor, maybe former friend, I don't know. But again, Yannetti should have to prove why it's admissible instead of the reverse, instead of Brennan proving or showing or arguing why it's not admissible. Okay, here we go. King David, here's the floor.
U.S. to apply. All right. I'll hear you, Mr. Yannetti.
My understanding is there's an objection, so I've got to respond to the.
No, I want to hear you as to why this is admissible. Why this is admissible.
Let's give the defense all kind of burdens that they shouldn't have, because it's not innocent until proven guilty here. It's guilty until proven innocent. Proctor's buddy is thinking, I need to get this chip off my shoulder. I need an attorney. Well done, Maria. Well done. Oh, I have a typo in I hate typos.
So, Your Honor, with regard, I assume we're just dealing with authenticity at this point?
No, we're dealing with both. You're the proponent of the testimony, so let's deal with both.
Okay, all right. So regarding authenticity, Your Honor, there are several ways that are either independent or connected with each other by which or through which a party can authenticate text messages. The majority of the case law out there are defendants having appealed judges' decisions to admit text messages offered by the Commonwealth, and the majority of the case law that exists affirm judges' allowance of text messages into evidence. The Commonwealth filed a memorandum in opposition to these text messages being admitted, and not one of the cases cited by the Commonwealth apply here or are appropriate.
Are you surprised?
The case of Commonwealth versus Purdy. In that case, the Commonwealth introduced text messages from computers seized at a massage parlor. The defendant objected that there was no evidence that he had authored any of the, these actually were emails, not text messages, any of the emails that were admitted into evidence. Nobody saw him do it. Nobody saw him type it, and nobody discussed any of the emails with him. But the SJC cited a longstanding rule, including Rule of Evidence 901B1, evidence may be authenticated by direct or circumstantial evidence. And the circumstantial evidence is essentially what we covered here in court today: the appearance of the electronic communications, the content, the substance, internal patterns, or other distinctive characteristics. Commonwealth versus Welch, it was a murder case where a boyfriend killed his girlfriend, was charged with killing his girlfriend, was convicted. The Commonwealth sought to introduce text messages between them, and various text messages from the victim's cell phone were admitted into evidence because, for one reason, they referenced the defendant's distinctive nickname. And in this case, we have a text chain with 3 nicknames, all of whom the witness recognized as being his friends. We have more to authenticate this text chain than in any case I have seen, and also more than in any case the Commonwealth has cited. In this case, we have an identification of every phone number pursuant to the last 2 digits. We have an identification of Michael Proctor's message relating to the contents. We have evidence of the witness's cell phone requiring a passcode, meaning that in order for his phone to be active in this chain, he would have had to have unlocked the phone with the passcode. And he testified that what was in the content of the message that he identified as being his is consistent with something that he would have said. And not only that, but he adds a 4th nickname, that being Chip, that being Michael Proctor. The Commonwealth, with regard to Commonwealth versus Welch, which is again cited in their memorandum. This opposition, Your Honor, they state what appear to be rock solid black and white legal principles, but when you scratch below the surface and you actually read the case stands for nothing in terms of what they've represented it to be. They stated that in Welch, the court must find that each and every communication was authored by the individual member of the group. That's just plain false. The case doesn't say that at all. It's nowhere in that case. And in fact, the messages were let in again because of the circumstances and the content of the messages. Commonwealth versus Raposa, another case that they cite. The defense sought to call a neighbor to testify that he had seen the victim alive after the defendant had confessed to having shot him, another murder case. The problem was that the neighbor denied making the statement, so the defense wanted to call the neighbor for the sole purpose of impeaching him with his prior statement that he supposedly made to the police and use that statement as substantive evidence. So in that case, the defendant wanted to use an out-of-court statement for its truth. It was rank hearsay. That case had nothing to do with text messages or statements used to show state of mind or electronic communications. But somehow it makes its way into the Commonwealth's memorandum. Commonwealth versus Rajiv R., which is the second to last case that they cite, that dealt with a search warrant done at a juvenile's home. The police officer in that case was allowed to testify to what he was seeking, which was the goal of the search warrant, a firearm allegedly in the juvenile's possession. And he was also allowed to testify to what the juvenile's mother did during the execution of the search warrant, which is she directed the police to the juvenile's bedroom. The Commonwealth cited that case to say you can't use hearsay when trying to prove a Bowden defense or present a Bowden defense. That case had nothing to do with Bowden. The evidence was admitted to explain what the police were doing in the home. So it's a situation where, there are times when, the police stop somebody on the street or the police get a search warrant and then they show up at a home. And rather than just have them magically appear at the home with the warrant, the police are allowed to give some circumstances as to how they got there. Nothing to do with Bowden. It's just giving the jury a fuller picture. Yet it was represented to you by the Commonwealth that, geez, this is a Bowden issue and you can't use hearsay to present a Bowden defense. Commonwealth versus Sullivan, exact same situation. Testimony was admitted about DNA on evidence matching the defendant's DNA from a national database. The Commonwealth cites three principles. It's almost like they're setting a standard down that the court is supposed to follow with three factors. But again, none of the three principles that the Commonwealth cites is found in Sullivan at all. They're not even mentioned in the case. They're simply made up and put in a memo to ask this court to do something that the case does not support. And again,
Anybody
it has
surprised?
nothing to do with Bowden. So now we come to the arguments about the fact that the Commonwealth is claiming that these statements are hearsay. They're not. These statements contain insults of my client. I'll be kind and just mention the word.
So I read them.
Yes. Okay. Well, I mean, Your Honor, if you're going to allow this into evidence, I'll stop talking. Otherwise, I have to make my argument.
I understand what you mean by insults.
Okay.
He's allowed to
So
say it out loud for the world.
The Commonwealth is essentially arguing that we're offering these text messages to show that the insults were true. That's a silly argument. Obviously, we're not.
I made that
Hearsay
argument.
has three components. These are all statements out of court. None of them are offered for the truth of the matter asserted. None of them.
Of course.
Even the statement when Michael Proctor says that the homeowner's not going to catch any grief because he's a Boston cop. We don't know if that's true or not true. It's offered to show that Michael Proctor believes it's true. He's the lead investigator in the case. He has input into the case. He can decide who's investigated or not investigated. At least that's our argument. It's all consistent with our defense. It's offered to show his state of mind. Everything that he says is offered to show his state of mind. and to show his bias. He, as the lead investigator, his bias in what he does or doesn't do. And in fact, Mr. Brennan said at sidebar earlier when we started this conversation that Bowden deals with what was done or what was not done. We're entitled to explore what was not done and not done, and we're entitled to explore why. We have evidence of why. We have Michael Proctor's words about why he did or didn't interview people separately, why he waited, for instance, a year and a half to interview a plow driver who was out there on January 29th.
Lucky.
Why he treated some people with kid gloves and other people with brass knuckles. He's stating it in these text messages. She's gonna go down for this. We're gonna pin it on the girl. We're going to make sure that there are some serious charges. She's effed. Those are what he says about, those are the statements he makes about Karen Reed in the infancy of this investigation.
Mm-hmm. Same day.
And to the contrary,
3 days
is
later.
anything going to happen to Brian Albert? Nope.
Nope, we have an emoji for
He's
that.
a Boston cop too. These are all statements about Michael Proctor's state of mind. The prosecutor and I have been over the statements. I realize he's objecting to the admission of these statements. I don't think he has a legal argument that passes muster to do that, but should the court allow them in, we're agreed on everything except for 3 entries, which I think we could deal with pretty quickly. And unless the court has questions, I'd rest on that.
No, but I'd appreciate a copy of whatever you've agreed upon.
Okay.
What do you mean?
It's been a long day for staff, so I don't need to sit here and go through each one. Just get me a copy of what you've agreed to.
Okay. So this is the only marked copy. I'm happy to hand it to the court.
The nope emoji
And,
is still
You
there.
can take care of it and email it in.
Thank you, Camille, for gifting
Thank you.
10 memberships.
So,
You're
Mr.
amazing. I
Brennan,
love
I'd
you.
like to hear you on admissibility. I haven't decided admissibility, and I'll hear you on authentication.
He doesn't. This should be interesting.
On the first issue of authenticity, this witness has no memory of any of the text messages. I think it's fair to conclude he's on the text message string. He recognizes the people on it, but there is no authenticity if he doesn't recognize them. The
True.
person that could best authenticate these text messages is Michael Proctor. This witness does nothing as far as identifying the individual text messages and whether they're reliable, whether there's been any additions, deletions, whether in sum and substance this is part of the conversation. Notably, I think, according to the questioning by Attorney Yannetti, he's made one comment at the end of the string that really has nothing whatsoever to do with the text messages that are at issue. So authenticity, I don't believe this witness reaches that conclusion for them.
Okay.
Regarding admissibility,
It's ridiculous.
I
lose.
do not dispute that in the right context, these text messages are admissible. If there is an investigator in a case that makes derogatory remarks about an accused, I can't say that doesn't go to bias, nor do I reject the idea that it shows an unfairness or a motivation. But really, you need to put that in context, and I think Attorney Yannetti highlighted that. He says that this is not hearsay, it's how he thought, or whether it affected a particular part of the investigation. It may have, it may not have. Even if he denies that it affected his investigation, it's still an appropriate question to ask just because that type of negative commentary, inappropriate commentary was made.
He got fired for, among other things, these text messages. He got fired. You know how hard it is to get fired as a Massachusetts state trooper? He managed to do that. Why do you want them to call Proctor so badly, Brennan? He's the
But to
thug police.
explore the
Yeah.
state of mind and put it in context, you need to ask the person that you're accusing of having the bias. Because perhaps it did affect the bias. Perhaps the person was very biased and made decisions based on that animus. Or perhaps the person made negative comments but had nothing whatsoever to do with the investigation.
Had everything to do with the investigation, because when he was texting his buddies this the same day as her arraignment, he already knew he was going to do whatever it took to pin it on the girl. And in fact, if these messages were made at 4:30, which is what I thought I heard him say, wasn't her arraignment at something like 7:30 p.m.? It was before she was even dragged into court after having spent the night there. You can correct me on the times. I might be wrong. We're very collaborative here.
It is surmised to say because these comments were made, a witness was not investigated, or there was some other amorphous, undefined ill that happened. That's the whole reason why the witness who made the comments should be confronted with the comments they made so the jury can fairly assess, is this relevant?
He's made a
Is it
deal with Proctor
material?
of some kind.
And what is the value of it? I am not opposed to the admission of bias against a witness, especially a police officer.
The text was at
But it
12:39
should be
p.m.
against that witness because they need to have the opportunity to admit, deny, define, accept, and explain. By putting these messages in with sidestepping, calling Mr. Proctor, they are trying to gain the advantage of putting information in front of the jury that has no context, suggesting it has a value that.
Why didn't you call your own lead investigator? Why didn't you call your own lead investigator? Why did you have Yuri Buchanan testify to every single thing Michael Proctor did? Why didn't you call him? Why are you fighting so hard now for the defense to call him? Have you made some sort of deal with Michael Proctor? Have you prepped him as well as you prepped all of your witnesses in your case in chief who proved nothing, including no car accident was ever proved? Why do you want him to come in so bad? This is crazy.
Has not been defined. Calling Mr. Proctor, they are trying to gain the advantage of putting information in front of the jury that has no context, suggesting it has a value that has not been defined, and then, as Mr. Yannetti just did, making an argument that because the comment was merely made, that therefore there was a consequence, and specify a consequence where there's no factual basis to conclude. Because he made a derogatory comment, he didn't investigate or speak to a plow driver for a year and a half.
He was by.
That defeats the purpose of defining the value for which this is being emitted. I do have some issue that it's really not under the context of Bowden, because this doesn't have to do with the adequacy of a police investigation. It has to do with bias. And that purely is the state of mind of the person who made the comment.
No.
I would not get in the way of confronting the witness about their bias if they were called to the stand. But to put it in this way invites speculation, it invites manipulation, and it
Manipulation and
invites
speculation, that's your whole case.
a party on either side to portray this in a way that is not factually viable. It will be distracting, confusing for the jury, and it could be unfair for either side because it will lead to
Why did he stop?
arguments about
He just stopped
what
right
it
there about
means.
something. Hang on. Your entire case is speculation and manipulation and proctoring. There's even a verb for that now. It's been proctored. He stopped as if, he was offended by maybe the defense talking amongst themselves or something. I don't know. We got to find out from someone in the courtroom. If you are ahead in this on another channel or something, do not put any spoilers in the chat about what she's going to decide.
A party on either side to portray this in a way that is not factually viable. It will be distracting, confusing for the jury, and it could be unfair for either side because it will lead to
Look at him. He just stops.
It will lead to arguments about what it means without a factual basis.
There's no factual
And so
basis for it.
My position is, I don't necessarily disagree that it's relevant, but it should come through Michael Proctor. And if the defense wants the value, they should call Michael Proctor.
Mr. Yannetti, do you want to respond?
I know we're 3 hours late from I won't belabor the points. I would state the following very as succinctly as I can, which is, yes, it goes to bias, but it also goes to the adequacy of the evaluation. The two concepts are intertwined. If you're biased or exhibit bias, the defense should be able to argue that the investigation was not adequate. I would note, Mr. Brennan is not sitting at defense counsel table in this case. We appreciate the offer to help us with strategy about which witness we should call, but that's solely the province of the defense to determine which witness we want to use to authenticate and admit text messages. That's our choice. And we should not be deprived of that choice because Mr. Brennan thinks there's a better witness that should have introduced the text messages. There is no rule. There's no best witness rule in this case. I believe my co-counsel has already made that argument in another circumstance. His arguments, Mr. Brennan's arguments, go to the weight, not the admissibility. He is fully entitled to cross-examine this witness about all of the points that he raises. And in conclusion, Your Honor, he complains that we have not called Michael Proctor. I think that's the whole impetus for this objection, so that we will call a witness that they do not have confidence in to call themselves. It's unheard of in a murder case that you don't call the lead investigator, but that's what's happened in this case. We should not be forced to call Michael Proctor so that Mr. Brennan can then cross-examine him and lead him through basically his entire closing argument. He is entitled to call Mr. Proctor in rebuttal. He has every right to call Mr. Proctor again. I would rest on that. Thank you.
Okay. And just the very last thing, there's Commonwealth's motion for reciprocal discovery. Is there any objection to that?
Yes, it's not in compliance with Rule 14.
Okay.
We don't have any written communications with Ms. Deborah, and they've asked for all oral communications to be reduced to writing, to be turned over. That's not in keeping with Rule.
All right. So you're saying two different things. So you don't, this information doesn't exist because she has not had communications with you, right?
Written communications do not exist. I'm not saying two different things. Written communications do not exist. They also ask secondarily for all oral communications to be reduced to writing. We have no obligation to do that. We have no intention.
All right. So I'll get a decision out on that before 4:30. And I'm
Before
going
4:30.
to do a little more research on the text messages. Want to be heard, Mr. Brennan?
I thought you were standing up, Your Honor. No.
Oh, no. Okay.
Oh,
All
because
right, I'll
I'm so
see
polite, I
everybody
stand up when
Monday
you do.
morning.
She's going to have a decision by 4:30 and she needs to do more research on the text messages. The text messages are totally coming in. There's no reason why this man, Jonathan Diamandis of Milton, Massachusetts, by the way, should not be allowed to authenticate them. We heard from him. We heard a whole voir dire. She's got to do some research. Yeah. As I explained to you this morning, and I am so happy that David Yannetti has validated me by agreeing with my analysis, not that he saw it, but we just, great minds and all think alike. These text messages are not being offered for the truth that Karen Reed is a whack job C word with a leaky something, 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 not being offered for the truth of Boston police officer, homeowner, nope, not going to be catching any shit. Not offered for the truth of all of the others horrific things that he said about Karen Reed. But they go to bias. And this man, Jonathan Diamandis, who showed up with his attorney, can authenticate the messages, whether he remembers them or not. He says, I have no reason to believe I didn't make this text message because it was 3 years ago and they had 38,000 messages before that date amongst this group of elementary school boys that are still friends with nicknames. There's no reason why he should not be allowed to testify. There are two witnesses that were exchanged on that prospective list, the first list of 4. 2 of them are from Milton. He's one of them. And I'm wondering if he's a police officer. And here's why I think that. Because the 2 from Milton are Nicholas David White and Jonathan Diamandis, both of whom are childhood friends of Michael Proctor. It's a public filing. I'm not doxing anyone. Could they be with Milton PD? Could they also be in trouble? Could they also, for who knows what other text messages are in there that the FBI got a hold of? Could he have also conducted himself off duty on his private cell phone with other police officers in a way that could get him reprimanded as a police officer? I do not know if he's a police officer or not. And then we have Matthew Coleman of Quincy and Michael Arico or Arico of Canton, Arico. They are all on the text message chain. There was another one who was on the original witness list, whose name is escaping me at the moment, but was also a friend. And so that could be why he brought his attorney with him, and smart move. Doesn't mean he's guilty of anything. Just means he's got to protect himself. So I don't know. But wow, the day started off a little meh, and then it ended off with a bang. Masters of Criminology was like, am I watching SNL? Skit right now? No, but they are missing a huge opportunity. They may not be on hiatus right now. I don't even know. She's got to do some research to find some cases that support her position to not let him testify, because for some reason, Hank Brennan really, 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 really wants them to call Michael Proctor, because then if they do, they have to conduct a direct examination of Michael Proctor, the defense would. And then, as pointed out by David Yannetti, Hank Brennan would be allowed to cross-examine Michael Proctor. She's already made up her mind. That is a song on the playlist. It's an amazing Lie I Love It song, and it is on there. Let's take a look. We've been here for 7 hours and 24 minutes today, and I could go another hour. Why does the defense not want to call Proctor? Well, Strawberry Nana, that's a great question. It's not, they may call him anyway. But when they call him, they have to do a direct examination of him. And he may be better off. It may be a defense strategy to just keep him out there as this villain who's like a ghost. And then they can point out in their closing, why didn't Mr. Brennan bring Michael Proctor in here for you? He was the lead investigator. Why didn't he bring him in? It's a strategy. Will Wallace, thanks for your 20, says, I'd like to think most police carry the badge of integrity and proudly and unmistakably, just like the other one they carry. The silence from the other police leads me to believe that the corruption goes far up. How far? Who knows? Yeah, I tend to agree with you. I back the blue 100%. Nobody hates a bad cop more than a good cop. Duty Ron and Ed Wallace will tell you that. In my mind, what is going on here is so much bigger than the Karen Read case. So much bigger than the Karen Read case. This is just the tip of the iceberg, the proverbial iceberg, in my opinion. Lisa Atkinson wanted to know, can anyone tell me if the FBI is watching this trial? I don't think anybody knows for sure. But what we did see the other day, handed down by the feds, was an indictment of the Norfolk County Sheriff on felony charges for bringing 3 maintenance workers who were employed by the county to his house to work on his boiler. And he's facing decades of years in prison for that. And those charges go back 3 years. So much deeper. Thank you, Will, for pointing that out. People who live in Massachusetts will tell you that. I'm not saying the judge is corrupt, but what I'm saying is that the judges in Massachusetts are appointed. They're state court judges. Here in New York, we vote for our state court judges. These judges are appointed by the governor. You can't, it's very hard to get rid of them. Very hard to get rid of them. So words only matter if not memorialized, says Lindsay. Would additional, possibly more damning text be admitted? Could be. Could be. That's what I'm thinking. Who knows what else is in there? Storm Dancer says Brennan is wrong. It was not a comment. It was a multitude of comments. Correct. Camille, so Brennan, it's okay for a Commonwealth police officer to interact with supervisors unprofessionally and with bias in a murder case. These aren't even the text messages with the supervisors. Those came in another way. Those came in through Buchanan. This is just text messages with his buddies in which he said, I think some of them were on January 30th or January 29th in the evening, because his buddies had heard about it on the news and they were asking him details and he was sharing details. Yeah, Jonathan Long points out, that is why us Massachusetts residents are so intrigued in the case. The law has been dirty. Look at the judge and see how she's acting. Well, I'm not going to take it that far, but and I won't highlight the comment. But people in Massachusetts who live there, who have been living with this for decades, will tell you that. Thank you, RPM 6971, for loving my coverage. Patty, I appreciate your super sticker. Thank you. Life goes on. Remember, Hank Brennan said defense can try to call him. Yes. I think they have him in witness protection, so definitely defense can find him and serve him. Well, I don't know if he's in witness protection. That's an interesting point. But yeah, they said the defense can try and call Michael Proctor. Yes, we did point that out. I think he's under subpoena. He would have to come in. I don't know if he's in hiding. I really don't know. I have no personal knowledge of that. Do you think ARCA will be the next witnesses the defense calls? I don't know. We know that we do know there was a sighting of Lucky Locker and the plow driver in the courthouse today. These other two witnesses were also there. Kelly Dever, who was employed by Canton PD, and this man, Jonathan Diamondes. So I don't think anybody expected that the testimony of Matthew DiSogra was going to take the entire day. I don't know at what point they're going to call ARCA, Turtle, but that remains to be seen. Proctor will be working for Brennan after this trial is over, says Nancy. I bet he made some kind of deal. You're right, Melanie. Here's the thing. It has also been pointed out by people who live in the area, and I don't know if this is true, and I hate to give rumors legs, but perhaps some of the people involved in this case that were witnesses that were called during the first trial that were not called during the second trial are working for a private investigation firm. I don't know if it's true or not. Some of them used to be law enforcement. One of them is the not so confidential informant named Mafia Masshole. And so I don't know. Red's daughter says, then how could all of Higgins' messages be admitted? Because those messages were discovered by or evaluated by. Well, wait, Garino read those into evidence. Higgins turned over those messages, right? And gave them to Buchanan. These messages came from the feds. That's what Brennan should be arguing, but he really didn't even mention that. These messages came from the feds. They were on Michael Proctor's personal cell phone. The feds got a hold of them. They were turned over to both sides, the prosecution and the defense, before the first trial, when the acting U.S. attorney for Massachusetts, his name was is still Josh Levy, he's no longer because of the change in administration, said in a conference call to Adam Lally and the defense attorneys, I cannot in good conscience allow the Karen Reed case to go to trial. And so I'm giving you 3,074 pages of our investigation. Here you go. Those Proctor text messages were in those federal materials, as was the ARCA report, because the feds were doing a parallel investigation into the investigation of the murder of John O'Keefe. That never happens. That's why there's so much, it's so messy with the ARCA witnesses, because they were not allowed to be hired by the defense directly because they were hired by the feds. The first jury was not allowed to hear that the feds hired ARCA. And so some of the jurors who were interviewed after the trial was over said, we didn't really give the ARCA testimony much weight because we didn't know who hired them. And we thought they were either hired by Turtle Boy or by Karen's car insurance company. So we really didn't pay them a whole lot of mind. That is why the defense is fighting to have them know this time that ARCA was hired by the federal government. I still don't know if she's going to allow that. Yannetti Spaghetti wants to know, can she deny the messages even though they were led into the first trial? Well, they were led into the first trial because Lally called Proctor. Proctor read them into evidence. They're Proctor's messages. She loves to say, this is a new trial, new rules. And apparently there's a lot of new rules here. Because at the first trial, someone who wasn't a medical doctor couldn't testify about causation of injuries. This time, she let Welcher do it. So, rules for me, but not for thee. It seems to be the running theme here. Can they do readback from prior testimony? No, they still have to come in through a witness. Jessica, off topic, I know, but Taylor got her master's back. She did? Oh, I didn't see the breaking news on that. That makes me happy. Scooter Braun. Hate that guy. I did a show on that too, a long time ago. Didn't get a lot of views. It was like one of my first things I ever did about how Taylor Swift is a genius, remaking all of her albums because she was totally screwed with the masters. So that is excellent. How much did she pay? Is that out? I don't know. But thank you, Jessica. Is Mojo Rising Dirty Deeds Done Dirt Cheap by Joan Jett, AC/DC cover. Oh, that's good. We have AC/DC one, the AC/DC version on the list, but I do love a Joan Jett. Anything. I love Joan Jett. We are just like normal. Mom says, I'm so outraged. I've never said so many cuss words. I think you're not alone. Claire D, how does Bev get away with this legally? Well, judges have very wide judicial discretion. and judicial immunity for most things. Can't they remove her from her position? The corruption is deep. Very difficult. Chip nickname from Paint Chip Muncher. Thank you. Hank's little bulger. I just got out of timeout. I'm sorry. Throw this in the jar. I have no idea who gets timed out, who doesn't. I'm not in charge of that. I got people for that. I have no idea. Can you share the PC affidavit so I can avoid a future incarceration? I have no idea. You can ask the mods. It's like we run a tight ship here because we just try and keep it classy. If you say anything that's defamatory or foul or spreading misinformation, there's lots of reasons. YouTube has demonetized me and many other creators for the stream on Wednesday because the dead body picture was shown, even though it was minimized. They scan the chat with their AI. If you say drug names in the chat, that's not a good thing because YouTube thinks you're promoting it. Sometimes people get timed out by accident. I don't know. Somebody wrote me like 5 emails while I was on here that I haven't even looked at yet. Like, I'm in timeout. How do I get out? I'm still in timeout. How do I get out? I don't know. Just be classy. That's all. It's not hard. Linda, thank you so much for your super sticker. Irony in the Land of the Lost says, need a diaper for May. Abacus, Mel, could you get BN Trouble in contact with Duty Ron? They've started a strong desire to have him on their show. I don't have BN Trouble's information, so I don't know how I would do that. He's just the guy I know from YouTube. I don't know. Maybe he's emailed me. I could do that. Yeah, I could do that. If BN Trouble gives me permission to share his information with Duty Ron, that's cool. Sure. Just send me an email saying that you give me permission to give you the email. Oh, you're going to do their show. All right. So you already worked it out. Yeah, I'm pretty sure Duty Ron has a his email in his as such. Oh, yeah, not surprised. Okay, thank you. In his thing. So good. I'm glad you guys got in touch. Thank you, Abacus, for giving me $10 to just highlight that. I guess they worked it out. Lisa B down the rabbit hole. Thanks for tuning in from Canada. I don't know what this was about. Web of confusion. Oops, AI assisted. How embarrassing. I don't know what that was from. What was AI assisted? Carly Marsh says, perfect day. Get the views up on your Taylor video. Heading there after this. Oh, cool. Thank you, Carly. That's a great idea. I could promote that again. It's an old one. It's a really old one. It's from when I first started the channel, probably 2 years ago. Cindy, thanks for the Venmo. It says, awesome analysis. Kathleen, thank you for the coffee. Through Venmo. Marianne, screw that. Dirtbag, buy yourself a cocktail. Thank you. Donna, go have a drink on me. Mark, obviously, is a keyboard warrior. Thanks as always for all you do. I mean, it wasn't public. He sent it to me privately. And we've done a little digging, and it seems that he may be law enforcement. So that's real interesting. Stay tuned for that or not. I may have to keep it quiet now. But thank you, Donna. Tammy, Hank is such a word weasel. Kelly, thank you for your very, very generous Venmo. You're going to need more than one drink after today. Thank you, Kelly. Tammy, thank you. Losers will be losers, especially when they're losing. I agree. The C word is the worst word to call a woman ever. I agree. Ashley, thank you. Trolls are threatened by your intelligence. Love you, Mel. Thanks for the snark and commentary. Well, it seems that this guy could be a little more than that. Karen, is Brennan discrediting his own expert witnesses? Kinda. Yeah, it kind of felt like that. Didn't it? I don't know. Is it just me? He just wants to win so badly that he'll do whatever it takes. Steve, thank you. Says, excellent coverage of the corruption in Norfolk County, Mass. Jonathan is not a police officer. Okay. Neither is Mr. Arico. Thank you for that anonymous hot tip. But I imagine that he does not want, he wants his attorney there. He's smart. Look, he's smart. I would never throw shade. I think everyone should have an attorney when you have any chance, especially if you are not guilty. Always have an attorney when you're talking to the cops, for sure. For absolute sure. Thank you, Brid, for buying a matcha latte. Couldn't watch this trial with anyone else. Thank you. Eileen, I can't tell you anything about the sizing on the spread shop except for there's a size chart right there. So you can click on that. I can't respond to your email. And so it could be a men's V-neck. It absolutely could. It looks like a women's, but it says it's a men's. No, I put men's and women's in there. So just click on the size chart. They will let you know exactly how to pick out your your sizing. I can only tell you, and everything's 20% off. So the link is pinned in the chat. We covered all the motions from today, except for this one, which just came in writing. And so we might as well put up the receipt on this. Because we're here and that's what we do. And you guys like receipts and I like receipts. Cheryl with an S said, Mr. Reed said hi to the boots this morning. Oh, that's awesome. And Karen at the break supporting Karen after being laid off. Outraged. I'm sorry that you were laid off, Cheryl with an S. But I'm glad that you're there to support. Here it is in writing, filing number 702, docket number 702. And Mr. Reed is one of the nicest. Her parents are incredibly nice, Mr. and Mrs. Reed. I've had the pleasure of meeting them more than once. This was filing docket number 702. This was in writing the defendant's motion for a required finding of not guilty. Now comes Karen Reed, the defendant in the above captioned matter, and respectfully moves this honorable court, pursuant to Rule 25, to enter a required finding of not guilty on the above referenced indictments before this court. We heard that argued orally this morning in open court. As grounds, therefore, the defendant states that the evidence taken in the light most favorable to the Commonwealth is insufficient as a matter of law to prove these indictments beyond a reasonable doubt. Citing Lattimore, which we know is one of the judge's favorite cases. Wherefore, the defendant respectfully requests that this honorable court allow this motion for a required finding of not guilty on all indictments, XOXO, Alan Jackson, Elizabeth Little, and then look, the little scribble scrabble on the side just says denied, B. Canone. And it's good that it's in writing in the event of an appeal. David Unetti, Robert Alessi. Denied. Anybody surprised? Remember, the appeal would only come into play if there, God forbid, is a conviction. We don't want a conviction. I can't wait to hear the magic words not guilty, but I just don't know. I just don't know. I just don't know. I'm sensing another mistrial, and I really, really don't want to see that. Never thought being unemployed could be so much fun. Great channel, Melanie. Gary from Smithtown, Long Island. Love it. I love Long Island in the house. I love it. I love it. Did you see? Okay. Check this out. There was a story the other day. First of all, I hate Newsday because it's behind a paywall, but since you're from Long Island, I got to just share this with you guys. A homeowner opened their pool the other day because that's what people are doing right now. It's been really rainy, so a lot of people couldn't get their pools open before Memorial Day. And when they opened the pool, they found a dead body in the pool. Turns out there's been a guy on the lam since November for allegedly killing his father. It came out yesterday that the pool belongs to the detective who was looking for this guy. And that's the guy that was dead in the pool. Right? How crazy is that? I'm sorry that you're unemployed, but I'm glad you get to spend your days with us. Yeah, Anti-Bev Sidebar. And the pool owner is a cop. Not only a cop, the detective who was looking for that guy. Yeah. Not a lot, not enough. Yeah, in Shoreham, right? Kindergarten cop. It was in Shoreham, yeah. And so we're waiting for more info on that. It's been very sketch. Yeah, you haven't seen it? Yeah, it was like maybe it was on Newsday's Instagram or something. Craziness. Thank you, John, for saying excellent commentary. And you look like maybe you're an attorney. I don't know. You have a suit and tie on. I love a man in a suit and tie. Thank you. Thank you for thanking me for my hard work. This is a labor of love, you know? This is a labor of love. We're all just like normal moms. It says, can we all file class action lawsuit against Norfolk County for emotional distress watching this mess? I said that yesterday. I said, I know a good attorney. Do we have a cause of action? Intentional infliction of emotional distress. And then my kids and I are like spitballing. We're like, Why would that kid who was trying to escape be found in the detective's pool? How would he even know where the detective lived? Maybe somebody's trying to frame the detective. Like, we have so many theories going on in our family chat about this. It's crazy. Detail Junkie Melanie, 100% confirmed the feds are still watching. Can't really explain in the chat. Well, thank you. I mean, I'll allow it. Wine o'clock. Shout out to dad, to Amanda's dad. Shout out to Amanda's dad. The fugitive figured the detective would not look in his backyard for him. But why would he hide underneath the pool cover? Like, the pool was covered. It's a big ass pool. I mean, when they opened it, and from the aerial view anyway, it looked like a big ass pool. I put this up earlier, inverted sneaker, but thank you again. Do you think we'll ever know the real reason why MSP, Hank Brennan, and Judge Cannoni are willing to throw their careers and reputations down the toilet by attempting to convict an innocent woman? I don't know. What I do know, or what I think I know, or what I speculate, or what I believe is that it goes far, far deeper than just this case. Hi, Danielle. I don't know what that means. My apologies. My phone has reported to YouTube twice while in my pocket. So embarrassing. Thanks to life. I don't even know what that means. Like, there's a little way that you can report the stream. I don't know. I don't know if it, I don't know what it does, if anything. What, if anything, it does? And then Kindergarten Cop says the house was blocks away from where he crashed his car. PD cars flooded the area looking for him. Oh, so the kid crashed his car and then he just coincidentally winds up dead in the pool of the detective that was looking for him. I mean, that's just, it's crazy, Scott. We got to talk about this offline. Yeah, Casarija, Long Island serial killer is going to be easy listening after this. Yeah, 100%. Bruni Saint wanted to know, can a review of Bev's handling of this case happen after it's finished? Who's going to complain? I mean, they do have a judicial committee that oversees the judges, but I don't know. Anything can happen. Will it? Shout out to all the gifters today. Peekaboo Baby Shark gifted 2. Mark McKay gifted a membership. Bianca gifted a membership. Amanda Riley gifted a membership. Yes, thank you. I was going to come back to this and I'm glad I did. Look up Paul Fahey. Norfolk County is shady. Well, we did. We did this in a pretrial. Paul Fahey is the guy. Is he still in prison? Dusty Truth? Paul Fahey was convicted of murdering a man by the name of Keith Boudreau in a sports bar in Quincy, maybe back in 2015, 2016. I don't know the exact dates, but I did cover this on a pretrial show. As often happens in criminal cases, there is a civil suit to follow. And in the civil suit, the family of Keith Boudreau sued Paul Fahey for wrongful death, in addition to, I think, the bar that he was in, and I forget the bar name. I think it was a hockey bar. There were some filings in the civil case. Paul Fahey made a motion. He's the defendant, remember, who there's video of him, okay, killing Keith Boudreau and stomping on his head and stomping his head to death. And then the owner of the bar, you can't make this up, helps Paul Fahey drag his body out to the back alley and is like, yeah, we don't know. We just found him in the back alley. During the investigation into the surveillance video, into the murder, Trooper Fanning and Colleen Crawford, who were employed by the Norfolk County DA's office, went to this bar in Quincy and seized the entire system, the entire surveillance system. 2015, 2014, around that time. Paul Fahey, in his motion in the civil case, said the surveillance video was doctored, altered by Fanning and Crawford. And if we believe that to be true, this may have been going on since at least that time by these exact same players. They seized the entire surveillance system. There was no metadata. It may have been altered. I don't know. We covered the motion. Thank you for reminding me of that. It was also brought out before this trial. Colleen Crawford, who's like the video person for the Norfolk County DA's office, and Fanning had at least 2 businesses together. One of them was dissolved, I think, right after Karen Reed was arraigned in February of 2022. You guys are like armchair detectives. You do so much of the work. It takes a village to get justice, and we are a village, and everyone has a role. Some of us just get on here and yell about it all day. I have no dog in the fight, but I have a passion for justice. And it's not very often that you see someone being railroaded as publicly as Karen Reed. Hi, Amanda Riley and Eddie in Scotland. Thank you for watching. Also, Marilyn, I had this up earlier, but I didn't shout you out. She was on the road with her boyfriend watching from the car on 2 different phones. I love you too. Thank you very much, Free Karen Reed. Thank you, Valerie. Loves the vibe of the chat and me. Thank you so much. And then Mike from Providence said, I acknowledge you as my trial chief. I'll allow it. iTunes got your Paris Ray tunes. Listen to this. This was also in the family group chat. This is very exciting news for Paris Ray and the Crush. They have been added to Miller High Life's official playlist. Yes, they have. Because you know their logo, Paris Ray and the Crush, is the Miller High Life logo. Let's see what song they put it. Green Flag. Thank you. Thank you, thank you, thank you. That's pretty amazing. That's pretty big. That's a big deal. And there's not a lot of songs on there. Look, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, maybe 20 songs on their official playlist. Shout out to Paris Ray and the Crush. Jamie, can the defense get Trooper Paul's info out with the crash daddies? The fact that there was a differing opinion of Welcher's. The comment that the Commonwealth clearly hid. The crash daddies did not review Trooper Paul's report. They weren't given Trooper Paul's report by the feds. Remember, all of their original investigation was based on information given to them by the feds, and they weren't given it because it didn't matter to them. They were given one job. The job was the damages to John O'Keefe's body line up with the pedestrian strike, and, well, 2 jobs really, 2 questions answered. Do the damages to Karen's Lexus match up with it hitting a pedestrian? And their answer was no. They were paid a ton of money by the feds to come to those conclusions, but they were not given Trooper Paul's report that I know of. So I don't think they can get it in that way. They can call Trooper Paul, but same thing. Then Brennan's going to get the chance to cross-examine him, and he's going to try and destroy his own Commonwealth witness. Thanks, Amanda, for gifting a membership. So, you know, again, another strategic decision, but who doesn't want to see Trooper Paul again? Whoever thought we would miss Trooper Paul? Right? Yes, they created a cannon, Martha Ivy. Chris Daddy's built a cannon, and it was awesome. It was awesome. Right? Midnight Mike gifted 10 earlier. I think I thanked you for that. Jessica Whaley is from Northampton, Northampton. I don't know. I'm probably pronouncing it wrong. That was where the Brian Camp case, where the Brian Camp home intruder, where they lived, right? In Northampton. 20 minutes was fast for the police because Chesterfield is so small that they don't have a police department. Glad he was acquitted. Yes. That was Brian Camp. Kindergarten cop says Uncle Giuseppe's in Smithtown is hiring. Who needs a job? Oh, for Gary. Oh, thank you. Thank you, Kindergarten cop. I love who doesn't love Uncle Giuseppe's is a chain here. It's an Italian market. It's amazing. Oh my God. The chocolate counter at Uncle Giuseppe's to die for. Yes. Chesterfield is where Brian Camp was at the time, right? Thank you. Thank you, Jessica. Yes. The intruder was inside with the little girls. Yes. That was the Brian Camp case. Thanks, Rihanna. I put these up earlier. Thank you, Becky's Blue Eyed Paranormal, for all of your compliments today and all of your super chats and all of your gifting. And you're amazing. And I love you. We love you. Aaron wants to know your thoughts on Attorney Little's new mini bangs. I like them. I like them too. I like them too. I have some own personal trauma about bangs that are too short because I think when I was little, well, I know this happened. I think I was like 6 and got a haircut and like the bangs were way too short and they looked terrible. And there's nothing, as you know, that you can do when your bangs are too short. You just have to wait. I think I cried for like a week, but you know, that's my own personal drama. But I think it looks adorable on her. Brittany Saint said Melanie Welcher said John O'Keefe's arm could have broken the taillight at 8 miles an hour. And I must have zoned out during that part of his testimony. So that's possible. That's a good question, Deborah. Do you think the Commonwealth knows they won't get a conviction, so they're strategizing for another hung jury or mistrial, knowing that Karen Reed will eventually run out of money for counsel? Let me tell you something. That may be their strategy. I don't think it is, but it may be. I don't think they're ever going to let this go because they're so far deep into it that they need a conviction to maybe save some asses up the chain here. The more exposure this case gets, the more support Karen Reed has, and the more people will donate to her defense fund. If you have an extra $5 or $2, the defense fund is in the show notes below this video. Imagine how much it is costing to house all of her attorneys, to feed all of her attorneys. They moved here from California and New York because they believe fiercely in her innocence, and they are not getting paid for this. But I think the more steam her case gets, the more money she will raise for defense funds and expert funds. And yeah, Flower Child says, I think all of us ladies have had bang trauma in our lives. And she's, I think, referring to the hair do or hair don't of bang trauma. But that is funny, Flower Child 76 nonetheless. And I see it. I see that so many more people are watching this trial than the first trial. I don't know how many live viewers I was getting during the first trial. I want to say maybe a couple thousand. My live streams are consistently getting over, we're getting into over 22,000. I know Emily Baker has something like over 40,000 a day. And then you have Court TV and you have Law and Crime. They have viewers who want to watch without commentary. And so somebody did the math, and they're doing the stats, or they were doing them anyway on Twitter. And that is just the YouTube views that this trial is getting something like, this isn't even including like networks. So it's just YouTube streams. Close to 3 million views a day. A lot of eyes on this case. A lot of eyes, right? On Top said earlier, after this opening, AJ just ought to say we arrest him, walk out with Karen Reed free. I know you're talking about his argument this morning on the motion to dismiss. Motion to dismiss, but it was denied, as we just saw, by the judge. So, you know. 70 says, anyone notice that none of the McCabe's or Alberts have been in the courtroom supporting the O'Keefe family? This trial screams guilty to me. Well, they're not allowed. There's a sequestration order, and they are all on the witness list. And so they're not allowed in. There's an order saying they can't come in before their testimony or after their testimony, but they can come in during closings. Mulva. I love a good Seinfeld reference. It makes me laugh every time I read your name. I feel like the defense is forced to say, thank you, Bev. May I have another? Every time she denies everything they ask for. I know. I feel that too. And Becky gifted a membership. Thanks, Becky. Going back to Lena, I put this up earlier, but thanks for your 20. Is it just me, or is there a stark contrast in clarity between his answers, meaning DiSogra, and Welcher's? Yes, I'm biased, but the clouds have parted, and I'm not listening to some so-called expert talk in circles. This guy is a delight. It was clunky, his testimony, and I want to know from people who have. He didn't testify at the first trial, so this is new for all of us. Actually, let's do a poll. You want to do a poll? There's 14,000 people left here. Let's do a poll. Because I have mixed feelings about DiSogra's testimony, I'm not. I don't like to bash. Really, I'm not considering this a bashing of the defense. I just don't think that this was the best opener. So what should the poll be? Matthew DiSogra. We're gonna do it. We're gonna do the same thing we did yesterday about Welcher. Helps the defense, hurts the defense, or canceled out. Oh no, Q&A. I don't want a Q&A. I want a poll. Hold on. I mean, there's a lot of people who are going to say that Brennan did a great job today. Helped the defense, helped the Commonwealth, or what? Neither. Good. All right, the poll has. I'm just going to put hella confusing. The fourth one. Okay, start the poll. In your opinion, what did you think of Matthew DiSogra's testimony? Help the defense, help the Commonwealth, neither, or hella confusing. I'm going to unpin the merch link, but it's below the video if you want it. The merch is 20% off for, I think, 3 more days. Get your votes in now. There's still like over 14,000 people watching. Let's see how many votes we can get in there. Gone to the dogs. Thank you for your 10. Amanda was loving his simplified and organized slides. Most of his slides were just, a lot of them were pulled from, we found, Shannon Burgess. And the ones that he did himself were very simple and organized. I liked him too. Welcome, Ellie. He doesn't look, I don't know about anything about that, Dennis. T-Bone. I'm pretty sure all this is confusing and boring to the jury. Based on likability, defense wins. So far, he's not aggressively flailing his hands. That was earlier. And Terry said, look, Ma, no cheat sheets, watches, or PCs. Thank you, Beetlejuice Breenan, for your super sticker. Thank you, Priscilla. Oh, Jamie, leaving on a 7-day cruise today and can't stream. I'll miss you so much. Pay for the Wi-Fi. Do they have like a satellite Wi-Fi or something, a Starlink on the cruise? Jamie, you're going to miss it. But have a great time on your trip. Tammy says, I bet Hank Brennan is wishing he had an Alessinator right about now. Daniel Wolf's Dimples says, okay, we thought Hank and Bev were bad before. Well, I have a feeling we haven't seen anything yet. Big Haas wants to know who's a better lawyer, Jim Carrey or Spanky? Like Jim Carrey. Oh, thank you, T-Bone. No dog, but a clown in this fight, says I'm appalled. This is not a fair trial. That was earlier in the day. Sidebar Chick said, telling truth and openly and honestly fosters transparency, allowing individuals to understand situations and make informed decisions based on accurate info. Thank you. There was something underneath that I just deleted, and I'm sorry if I didn't put it up earlier. And whoever's super chat that was, don't be mad at me. I'm sorry. Kelly said today, my blood pressure is going up at the thought of Binky Boy Brennan's blooming voice and how he's going to spout tripe. I have to go to a party soon. Boo. Well, I hope you have fun at your party anyway. Snurf Pain said, thank you for Chaka. You keep me amused when I'm angry at the judge. Priscilla said, hi, Mel. There's the threes we were asking about. There was no collision, but a lot of collusion, says Heidi. Thanks, Mama Z, for joining. Commonwealth experts said collisions are not recorded. Said heir apparent. Camille, how does moving forward 3 times equal 2 feet forward 1 time and 5 in reverse equal a 3-point turn? You're asking me to explain things that are confusing. Chloe Albert's Revenge says, doesn't candor to the court mean truth? Or does Brennan thinks it just means his truth? Please clarify. It's supposed to be being truthful to the court. But I think he thinks it just does mean his truth. And I think you're being rhetorical, but I'll allow it. Thank you, Chloe Albert's Revenge. Oh, that's funny. That your you know what responded to me from England. Thanks, Iffy, for becoming a member. Cat Q said, Bev will exclude the Proctor text. Well, we don't know. She said she'll come to a decision. I don't think that was the one she was going to decide from 4:30. She didn't say which 4:30. And I don't think she just said the text she will decide by 4:30. I think that was the other motion. Leanne became a member. Welcome. And Manj, I'm convinced Hank can file or object to just about anything because he knows his whiny complaints will be approved. I'm beginning to think that. A lot of people think that. You're not alone. Okay, then the officer who downloaded those messages and reviewed them for another court proceeding should testify about what he downloaded and who. Skybell, thanks for gifting a membership. Stephanie Flynn, if Proctor was at the time of the messages employed, things would be based on while employed, not the fact that he's now out of work. Thanks, Lisa, for your super sticker. Lisa has crocheted 3 shirts, a stuffed birthday cupcake, and 2 camp chair cup holders during this trial. The rage works wonders for my speed. Free count read. That's awesome. Trisha, thanks for becoming a member. Julie, I didn't see Court TV's poll. What was it about? Entry required. Watching from Sweden says, Mr. DiSogra, would data be captured of a crowbar smashing a taillight in the Sallyport while Canton PD cameras are off or video went missing? Well done. There's Kaylee C., the paralegal's husband. He's an engineer. He came in to authenticate his wife's comment earlier. Thanks for keeping wife and all of us company while gone. That is awesome. Your wife's a smart woman. Michelle, who actually is an engineer. Michelle Conley comes in and says polycarbonate's flexibility allows it to absorb and dissipate impact energy, preventing it from shattering and fracturing like glass. It's 250 times more impact resistant than safety glass. Bling is the new black. Thank you. Says, I would love to do some bling swag and send you samples. I work mostly with major brands. DM me. That's awesome. I will. Hey, well, I think we connected on Instagram, right? It's hard. Like, you know how those messages on Instagram just get lost in a black hole? I'll look for it. Amy, thanks for your super sticker. Camille said, I would love tie-dyed dancing cupcakes on something like the Grateful Dead Dancing Bears. Much love. That's a great idea. I love it. Shannon Palumbo is rage gardening. Says, hi, Mom. She's rage working from home. Hi to Shannon's mom. KZ Gypsy Muse says, I'm going to bawl my eyes out if Hank treats Lucky badly. Please, Mel, tell me the defense has properly prepared Lucky for Hank's possible psycho cross. Well, they have more time if they didn't prep him because he was not called today. Chloe Abbas Revenge coming in with something funny. Rumor has it that if they intend to call Proctor, they must clear it with his new boss, Art Vandelay of Vandelay Industries. We do love Seinfeld references, and Alessi's Rage says, merch idea, I survived the land of the lost with Melanie Little. I wrote that down because I love it. Love it. Do I own, Steven wants to know, do I own any of the t-shirts with the Cancun logo on them or any of the big logos? Scared to order them in case they're not stretchy. They are comfortable. They're all comfortable. I have them, Steve. They're all comfortable. Some of them, it'll tell you what brand they are, so you can know if you have like a Hanes shirt at home that you like. They're not, there's nothing, it's nothing, nothing's like sandpaper. If you don't like it, Spread Shop is really good and they'll like send you a different one or something. I wouldn't worry about that so much. I survived the land of the lost with Melanie Little. Do we like that? The court's not coming back today, no. Not that I'm aware of. Bob Cromwell says he's bluffing. He's scared to call Proctor and he thinks the defense won't. Oh, his case is over. I don't think that he will call him on rebuttal even. I put this up earlier, but I'm gonna shout it out because I met you and your son Ben, I think last year outside the courthouse, didn't I? Either that or I saw him on the news. Love a Little 1989 says, thanks for your coverage. We have watched you since you started on this case. My son Ben, who has a colostomy and is 13 now, is outraged. We met Karen last summer during trial 1. Such an amazing woman. Maybe I saw it on the news. Shout out. To Ben. She's like Texas, who gifted 50 memberships earlier, by the way. We are seeing a pre-show of how Brennan is going to cross the crash daddies. He's a real-life court jester. We saw that also during the voir dire. Right? Look at Heather. Heather's in a campground in New Hampshire. She can't miss a second of it. She's camping and watching. Alicia Joe thought that Hank was coming across as so unlikable and quite frankly a bully. He also doesn't seem to understand the scientific stuff. Please sit down, sir. I have secondhand embarrassment. I hope the jury does too. And there it is. She's like Texas with the 50 memberships earlier around 2:30. LNM D93 says, what will we all do when this is over? It's always a case to watch. I try and find the interesting ones, not necessarily the most popular ones. When I started covering this, nobody was. None of the law tubers were really. January 2024. And then I was on Court TV twice before I even started covering it on my channel with a woman whose name we don't allow mentioned in this chat. Her initials are JC, and she used to work for the FBI, allegedly. She tried so hard to make me look like a fool on Court TV twice when I said there's no way that these are injuries from a car. It's definitely an animal attack or a dog attack. She was like, everybody who comes on here and everyone thinks they know what these injuries are caused from, and they're not a medical doctor and blah, 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 blah. So she tried to make me look like a fool. What did I do? I went out and found a guy. I found a guy who knows dog bites. Garrett Wing is his name. You might remember that his name is on the defense witness list. He's going to come in as an expert for the defense. He has a YouTube channel with something like 2 million followers on YouTube. Garrett Wing, I had him on my show. I said, what do you think? I showed him a picture. I said, I didn't even tell him about the case. I don't even think he knew about the case. What do you think these injuries are from? He said, absolutely a dog. He came on my show. He did a great interview. You can find it in the playlist. And fast forward to a year and a half later, and he's going to come in and testify as a defense expert. Because I ain't got no quit. And you don't try and make me look like a fool on national TV. Okay? That person may or may not be hired by the Norfolk County DA's office to AstroTurf. I'm not quite sure. I don't know. She has trashed me on Twitter like you can't believe. She's also not a doctor, correct? Wayno, after the season inevitably ends the same as the first one, do you think they'll change the ending for season 3? I'm hoping Colin and Allie come back next season for Karen Reed. Thanks, Wayne. I know. I have. Here's the thing about this case. It is so divided. People who believe that John O'Keefe was not hit by a car are never going to be convinced that he was. And if John O'Keefe was not hit by a car, you cannot convict Karen Reed. People who hate Karen Reed and want to convict her based on her facial expressions and some of the statements she made in her interviews are never going to be convinced that John O'Keefe was not hit by a car. There is no middle ground. Like, people are so dug in that all it takes is one holdout and it's another mistrial. And so Kat said, Dexter save us at one point during Brennan's cross, and that was fantastic. Emily C said, there's a setting where you can shut off or turn on whether the infotainment system pulls the time from your phone or keeps the time on its own. Does anyone know whether Karen had that on or off? I have no idea, Emily. There may be someone in the chat who can tell you. JB said, Melanie, there's a lot for me. Your voice, you voice what I feel. All of my heart. You speak what I feel. Cuss and rage. It creates an effect my boss at work knows about you. Love and love. Thank you, JB. It's a lot. It's a lot. If you need a break from this trial, take a break. It'll still be here when you come back. Don't worry. Yes, my Spotify playlist for Karen Reed has 170 songs. It's 12 hours and 13 minutes long. Plus 26 songs, which is an 18.06% increase from 10 days ago. Yes, I keep track. That was Argument Assassin Alessi in chat, who's been a member for over a year because you have the red velvet cupcake next to your name. So you must have changed your name. Thank you. Thank you, Proctor's dishonorable discharge. You're amazing. Vec Girl again, thank you for the 50. That was super, super generous. Tara Fitzgerald from Ireland says, your commentary, humor, facial expressions, and hand gestures crack me up. Thank you. Am I the only one who dreads the weekend? I count down the hours until Monday at 2 p.m. I'm in Ireland. I try to provide you with content over the weekend. Last Friday, I did 2 shows. I did one with Peter Tragos of Lawyer You Know, and I did another one with Defense Diaries. Saturday, I took off, but it was a long weekend. Sunday, we did a show, and Monday, I did a show. So I try to keep us, it's good to be on a schedule, you know? Nancy Rolfe, thank you so very much for this. They sent it private, make it public. Thank you. Love you. Love you, Nancy. She says that you have brought attention to the world regarding Karen Reed. I know you are doing God's work. It's not always easy. I know. I sued the Catholic Church too, and I'm Catholic. You know, for all of the victims/survivors of clergy SA here on Long Island against the Rockville Center Diocese, those cases broke all the way back in 2002. That's how long I've been a lawyer. So it's way longer than that. But that scandal broke in Boston. I know what corruption is. I have dealt with corruption on a very firsthand level. It exists. It can happen. And when they say, oh, it's impossible, 12 people can't keep a secret or whatever, Have you heard about the Catholic Church scandal? It can be done. It can. Thank you, Alicia Joe. Maybe it's not. I don't know. Maybe I watched too much Fleabag. I don't know. Great question. Do you think Brennan is jealous of AJ or too arrogant to be? It's a great question. Amy Tebow. This witness keeps looking around for the guy who will jump out and say he's being punked. Yeah, Ashton Kutcher, where are you? Alan Funt, if you want to go all the way back to the original. This is ridiculous. Free Ricky, thank you for your super sticker. Derek Carney, just for you, I did it. Edie Brickell, nothing is now on the playlist. Thank you for making another great video. Thank you, Ms. Mojo Horizon, for your excellent investigation. I appreciate you with all of my heart. Collusion, not collision. AJ completely misses the point of making it make sense for the jury. You have to keep it simple. Sorry. Listen, you're entitled to your opinion. I said I thought it was clunky too. I don't know what we got out of Matthew DiSogra's full day testimony today, because I have to go back and watch it because I couldn't even digest it because I was covering it, watching the chat, trying to do other things. And I just don't know how it came across. More of a Leslie says, I prefer analysassination. Analysas. Somebody said I offer analysas in my commentary, and I love it. I'll allow it. You're So Vain has to go on the playlist if it's not already there. Thank you. Ms. Mojo Horizon, thank you. I have to just screenshot that, which I need to do like this, because I'm not going to put it up right now because, discretion is the better part of valor and knowledge is power. Right? Right? See how much we learn on a daily basis here? So much. Ann Brennan coming in and pointing out that in 2022, Welcher was excluded from a Massachusetts court, used unreliable methods and data. Society of Automotive Engineers also deemed him unreliable. I don't know why the defense didn't bring that up to try and exclude him, but there were a lot of motions in this case. One of the motions on Welcher may have been about his methodology. And I remember Alessi arguing it and how he shouldn't be allowed in and they should at least get a voir dire, and it was denied. It was denied, but I don't think they had that information about him. Web of Confusion says this is totally a former friend of Michael Proctor, spending money on a lawyer, putting on a world stage, loss of privacy, professional on public stage, being forced to testify, possible reputation protection. That's what you're saying about why Jonathan Diamandez, Michael Proctor's Chippy Bear's childhood friend from 30 years, brought an attorney with him to court. Can't blame him at all. Life goes on. Why does Michael Proctor show up 2 times on IE chip and local user? I don't know. Life goes on. I can't answer that. Mackenzie, Judge Cannoni already allowed group texts to be corroborated by Buchanan. Isn't this technically the same way of getting the texts in? No, these were found by the feds. Buchanan was on that text thread. That was a different text thread between Proctor and all of his cronies from MSP, including his supervisor, Buchanan. And his supervisor was it Tully or Fanning, who was on vacation with the 5 kids and said, I never looked at those messages. So he didn't get in trouble. Was it Tully or Fanning? Who testifies tomorrow? Well, tomorrow's Saturday, so it's not until Monday. But we know that Kelly Dever is coming back, as is Jonathan Diamandez. And there was information that Lucky was spotted in the courthouse, so maybe Lucky Lochran. Lisa, why can't the FBI be called as expert witnesses or witnesses? Well, the FBI who did the investigation can't be called. They have immunity. They cannot be called to testify because what they do is top secret. They would have relevant info. Yeah, but they can't. Is that not one of the instances for them to be called? No. But the defense did try and get in an expert by the name of Michael Easter, who was an FBI. He's retired, I think. He's now an expert witness in police procedure to come in and testify about how bad the investigation was. The judge said, no, you can't have him. You don't need an expert for that. You can cross-examine the witnesses. The jury knows what a bad investigation is, and I disagreed strongly with that decision, and I still do. I need chapstick. Hold on. Talk amongst yourselves for a second. People with misophonia get mad if I swallow in their mic. It's a whole thing. Hold on. I feel like Andrea Burkhart today going 4 hours after court's over. And I stopped the stream to explain during. I think Andrea does it all after. Maria said, Mel, love how you talk to us like if we were all in the same room watching and chatting. Love it. Big Dave Matthews Band fan since 95, but I've never had the chance to go to a concert. Go. The summer tour is coming. It's like starting. He headlined Boston Calling last weekend. I don't like seeing him in a festival type situation, so I usually go to only his shows that he does alone. But you should go. Buy the tickets, do the things and stuff. Go. Just go on StubHub. Get some tickets. If you can't get them through Ticketmaster, do it. Buy the tickets, do the things. There's always a ticket. Make the memories, because you never know when your favorite artist is not going to be around anymore. My shiny blue car is a rock. It says Jules Cupcakes. Free Professor, Karen Reed. I like it. Will Wallace, membership on iPhone. Go to Melanie's channel. Click on Melanie's bio under a video. Click on word more inside box atop Melanie's pic. Scroll down. Click on Melanie's link next to the YouTube icon. Thank you, Will Wallace, for paying $10 to explain that to people. You're amazing. Also, if you're on an iPhone, sometimes you need to go into like Safari and open YouTube on your browser. It's weird. YouTube is owned by Google, so it doesn't really play so well with iPhones because, they make their own phones. Barbara Hall, please help. My son was murdered in Frederickstown, Missouri, and I can't get the police to do anything. And there's 5 other cases. Justice for Timmy Dees. Timmy Dees. I'm so sorry about that. Thank you for everything you do. I don't know what I can do to help you. I don't know what I can do to help you, Barbara, but my email is in the show notes below if you want to email me some articles and stuff. I don't know when it happened. I don't know much of anything about it, but listen, if we can give your son a voice and bring some attention to his case, send me some stuff. I'll take a look. Thank you, Barbara. I'm so sorry. No one should ever lose a child. I'm really, that makes me want to cry. I'm sorry. Woohoo Worldwide says we all have a dog in this fight for real justice. Woohoo to you-hoo. That's right. That's right, we do. Jay-Z, thanks for becoming a member. Not the Jay-Z, a different Jay-Z. And Busted Flush. Kai says, didn't Jen McCabe open the door to say the FBI were also investigating when she said something to the effect of, and I stopped the FBI investigation on the stand? Yes, that argument could be made. I have not seen it yet made on paper, but I like the way you're thinking. Michael, thanks for becoming a member. Sharon, thanks for becoming a member. Jimmy from Lynn. Melanie, the guy was so handsome. The ladies on the jury are believing him and crediting him regardless if he told them he can walk on water. Commonwealth's witnesses appeared terrible. Thank you. I'm glad. Thank you for your insight. Judy became a member. Welcome. Massachusetts said that it helped. DiSogra helped in that he presented as truly having no dog in the fight, in my opinion. Thank you. Zoe B. Today's trial stats. Did I read this already before? Yeah, I did. Thank you, Zoe, for keeping track. Matt says, if I have to proctor, I have to gamble. Thank you. Dennis the Menace said that basking sharks eat plankton with relish. Spanky. Crystal said DiSogra was a palate cleanser after Welcher and Burgess. Lindsay, usually they can track location just by phone data. Do you know why they can't do it in this case, comparing John O'Keefe's to Karen Reed's? Yeah, I know. I know why. Because all the GPS data, all the location data of Karen Reed's phone was wiped from her phone while it was in MSP custody in April of 2022. Yeah, you heard me right. Say it louder for people in the back. All of Karen Reed's location data was wiped from her phone while in MSP custody in April of 2022. That's what I've been saying. Why couldn't they, instead of using John's phone and her car data, use Karen's phone? They can't. Wouldn't that have made more sense? Use your imagination on why that was done. Thank you, Kelly, for ordering a sweatshirt. Welcome. Congratulations. I hope you like it. None biz. Hot Mics with Billy has a video I watched last night explaining why he thinks the Commonwealth wants a mistrial. Love Billy Bush. Karen Reed's not guilty verdict. Turtle Boy tweeted, jurors look aghast, like they are just realizing they've been lied to this whole time by Hank Brennan. Yes, that was earlier. We went through his tweets as he was kind of live tweeting. And then I think he had to leave to go to maybe the bus stop for his kids. I don't know. Thank you, Bev's White Claw, for the 10. Gail says, I'm not feeling very positive, Mel. Bev, the lies from Hank. OMG, help. Yeah, I'm not getting like the greatest feeling after today, but buckle up. Wait for us. We have that emoji in the first trial. Remember, David, in his opening, King David said, wait for us. That was like, and I have the emoji and it's right there. I'm going to put it there and just say, wait for us. Wait for us. Don't worry, Gail. I'm here to hold your hand through this. We're all here. We're all in this together. Court's closed. I wasn't waiting for anything. We're just going through some final questions. Dwayne is pointing out they have lost every single piece of relevant data that would prove her innocent or guilt. The library, the library camera footage, the ring camera footage, location data. It goes on, and anything that could clear or convict is gone. There was an amazing. Let me find this because I think I saved it in my bookmarks, and I just want to make sure because I want to show it to you. Somebody did a map, and they posted it on Twitter. And it's a map of all of the locations that had ring cameras and or surveillance cameras on the route from 34 Fairview to 1 Meadows that Karen would have taken home after dropping off John. So let me see if I can quickly find it for you. And the number of points on that map would astound you. Nobody ever looked for any ring camera footage that would have shown Karen Reed leaving the neighborhood with a shattered taillight. They never even looked for it. Never even looked for it. I don't know. I can't. It's not at my fingertips right now, but trust me, bro. It's out there. If you want to find it, it's out there. Because Aiden also went outside the courthouse to do a Facebook Live and annoy John DePetro. He's a multitasker. Lainey says they got rid of it because it's exculpatory. Right. Right. Why do you think they hid all that Sallyport camera footage in a drawer? Even the judge blamed it on Brennan. Keldell, welcome to membership. Life Goes On says, sorry for the confusion. When the last witness went through, who was on the high school chat, first chat was identified as Proctor. Oh, the first and the last one identified was local user. That witness also identified as Michael Proctor. I don't have the answer to that. I just don't know. I don't know where they extracted these messages from. I don't know if it depends on how the recipient has that person listed in their phone. And if that's the way it comes up, I don't know where they pulled that from. If it was a Celebrite extraction, I don't know, because it was done by the feds. And so we have very limited information about it. So I just don't know. If anybody in the chat knows, feel free to tag Life Goes On in your answer to that. Genius Dr. Alessi saves the world. Hulda from Iceland says, should we start a rehab for those of us who are addicted to this case? It's funny. Thank you, Jules. Karen, thanks for becoming a member. Netwoman Defense is strong. Dream Team is on the Dream Team is in the house for the playlist. Is that a song? New watcher, and I even watch you on normal speed. Thank you, Netwoman. I appreciate you. Mom Bearcat says, I didn't watch the first trial. DiSogra completely canceled the guys from Aperture. Good. Free Karen Reed. Thanks for all you do. None of those guys, Welcher, Burgess, and DiSogra, none of them testified in season 1. So they're new to all of us. I'm going to end the poll now. See how many, oh, there's only 3,400 votes. Come on, we could do better. There's still over 11,000 of you here. Can we get some more votes on this? Here's the poll. Matthew DiSogra, help the defense, help the Commonwealth, neither, or hella confusing. So far, 72% of you say he helped the defense. That's encouraging to me. That's encouraging to me because I found it confusing. I it seemed to me that maybe Hank Brennan might have scored some points with the jury. I don't know, because the witness in his honesty said yes, but that these things might be wrong. They might be I'm going to have to go back and watch it again. And so I just don't know that anybody's live tweeting about their reactions at that particular time when we were as such actually watching it. I just got, how did that happen? Thank you, Trish, for buying a matcha and says I would be lost without you. Thank you. You're the best. I need to move out of this state. It is so scary. Got to do what you got to do, girl. You got to do what you got to do. Stephanie, thank you so much for your generous Venmo. Says I have no words after today. This is corruption with a capital C, a true S storm of corruption. The world is watching, Stephanie. So are we. We're here again. We're watching. And I know you were here the first time. We're here again. We ain't got no quit, and we're not shutting up till those magic words, not guilty, are read on all 3 counts. Tammy says, thanks for your labor of love to try to make sense of this nonsense. I know. It's not easy. It's not easy, you guys. This is a lot. It's emotionally draining for all of us. I know that. If you need to take a break, take a break. I mean, people are losing sleep over this case, me included. Keeps me awake at night. When you're dreaming of a case that you're covering often, it's disturbing. And it's disturbing on many levels because many of you who are interested in this case are also empaths. And so you absorb the emotions around you and of others. How do we get your email? It's in the show notes below the video. It's also on the landing page. I read all emails. I do not get a chance to respond to all of them because I get 700 a day or more. I can't be your pen pal. I can't pick up your kid in California, fly them to South America to meet you, even if you promise me 10 acres of land. Kindergarten Cop and Little Cupcake and Miss Jessica and Team Brittany, they're my only pen pals. And they're also moderators for my channel. And I couldn't do this without them, without each and every one of them. So please thank the moderators because that too is a labor of love. Paris Ray and the Crush is also a moderator for the channel. Aaron Ashley says, this is what I got from DiSogra. Any way you work the data, John O'Keefe's phone lock happens after the trigger event, i.e. crushing the Commonwealth's timeline. Right. Because if John O'Keefe was incapacitated and killed by the car at a certain time, how could he have looked at his phone, read a text message, opened his phone with his face, and then locked his phone? Make it make sense. You can't. You know why? Because it's impossible. With that massive head wound that he had, for him to operate his phone after being incapacitated. It just can't happen. Hang on a sec here. Just can't happen. He proved that the data was not accurate, said ZZ Box and Cat. They just issued a tornado watch in Pennsylvania. That's crazy. Mods are the best. Thank you to the mods. As always. It's been a long day. Indie Girl, Mercy by Duffy for the playlist. Thanks, Melanie. Did I put that on there already, Indie Girl? I'm not sure if I did. She's been with me for a whole year. 12 jurors will never convict. Thank you, Stephanie. But are we going to get another mistrial? Stephanie's been here for over 11 months. She knows the drill. She knows how it goes. I don't have a P.O. box, Aaron. I don't. I don't even want to know. I don't even want people to know what town I live near because the hatred and vitriol that I have suffered from covering this case is like nothing else. Thank you, Black Rose, who's also an amazing moderator. Princess Mish. I don't know who else is here today. Having breakfast in California. Camille says Gen X here. I've admired how much more the younger generation have to understand corruption in today's world. So grateful the jury is young. Me too. Me too. They're going to understand corruption. They're going to also understand the data and the technology that many of us have trouble Derek Carney says, can you please say you were seen in a Free Karen Reed shirt? What do you have to say for yourself so I can use it in a video? How do you want me to say it? Give me like I need a backstory. You were seen in a Free Karen Reed shirt. What do you have to say for yourself? I could give you a couple of takes on that. You were seen in a Free Karen Reed shirt. What do you have to say for yourself? You were seen in a Free Karen Reed shirt. What do you have to say for yourself? All right, that's enough. Thank you, Derek. Mel, thanks for being my pen pal and picking up my kids. You're welcome. You are so very welcome. Here's a shout out to one of my kids who was in this band. You know them. You love them as much, if not more. No, you couldn't love them more than I do. Paris Ray and the Crush, Green Flag, which I have been advised is now on the Miller High Life official playlist. Enjoy this to play you out. Smash the like button on your way out. We'll be here tomorrow doing something. I love you with all of my heart. I will see you real soon. I'll come back after this to say goodbye. But enjoy this banger from Paris Ray and the Crush. And go follow them on all the socials.
You're like a breath of fresh air. I love a man who's healing. Baby, you're so self-aware and in touch with your feelings. No holes in your bedroom walls. Nobody's makeup in your bathroom. You always answer my calls. Nothing suspicious about you. Babe, I think you're just my type. Feeling high when I'm stone cold sober. Got me staying up at night, thinking about the next time you'll come over. You're a walking green flag, and I want you so bad. The way you're communicating, ooh baby, it's making me wanna get naked. Telling me how you feel. Oh my God, are you real? No vices and no trouble. You're working through your trouble, getting me hot and bothered. Oh, I really wanna. You know you're turning me on when you post me to your story, where you admit when you're wrong. Oh, it's really doing it for me. Babe, I think you're just my type. Feeling high when I'm stone cold sober. Got me staying up at night, thinking about the next time you'll come over. You're a walking green flag, and I want you so bad. The way you're communicating, ooh baby, it's making me wanna get naked. Telling me how you feel. No vices and no trouble. You're working through your trouble, getting me hot and bothered. Oh, I really wanna. Woo! You wanna get deeper, that makes me want you deeper. I think you're a keeper. My standards were too low. Baby, you respect me, so I'll let you undress me. Therapy is sexy, and green means go. You're a walking green flag.
That's awesome. Congratulations on making the official Miller High Life playlist on Spotify. Paris Ray and the Crush. Amazing news just breaking. I'm going to bring this to you before we wrap because we've been waiting for this news for a damn long time. It feels like it may have been more than 3 months. I know it's more than 90 days, but this is breaking. So let's talk about it. When was this? Well, 3:00 p.m. As of 3:00 p.m., Boston Globe is reporting, give me a second, that there is a grand jury investigating the death of Enrique Delgado Garcia. Praise be. J.M. Lawrence at Boston Justice is reporting special grand jury has been hearing about the death of Massachusetts State Police recruit for weeks, the Boston Globe reports. Special prosecutor David Meyer is leading independent probe into the death of a 25-year-old Enrique Delgado Garcia, who was injured in a boxing ring during academy training exercise. He was actually killed during fight night. He was killed. Not just injured, he was killed. And there were a lot of witnesses, and fight night is a real thing. And here it is. Special prosecutor escalates probe into state police recruit's death, calling a grand jury to hear evidence. Praise be. And they've been hearing it over at least several weeks from police troopers and other closely investigated. There were tons of witnesses there. And just when you think they're not doing anything, they're doing something. This was updated 1 hour ago. For those of you who don't know, Enrique Delgado Garcia was a trooper. He was in the police academy. And he was murdered during a fight night exercise at the police academy. His family was lied to. I forget all of the injuries that he sustained. Something like lost all his teeth. Look at Cindy RN crying like a baby here right now. You know what? Maybe it says in the article. Maybe I can just skim this real quick. Remember his injuries, you guys? Like all of his teeth were knocked out. I think he had a fractured vertebrae in his neck. He was 25 years old. Serious injuries in a boxing ring during an academy training exercise, and he died a day later in New Braintree. The circumstances of Delgado Garcia's death and the nature of the grand jury proceedings remain unclear. Nobody has commented. Meyer has not commented publicly about the investigation. That's amazing. He's got his own investigators investigating the probe. And if I had any more energy, I would read this whole thing to you right now. But go look at that tweet on Twitter. Go look at the Boston Globe. The injuries were horrific, and I can't wait for justice for Enrique Delgado Garcia too. I can't wait. So there's that. Thank you, moderators. Thank you, everyone. Each and every one of you who chose to spend your 8 hours and 42 minutes of your day with me today. You're amazing. Miss Jessica pointing out, most of justice work is quiet. Keep that in mind. The feds left the Karen Reed trial. They didn't. And that they can take years. They can. They can. I know that you have many, many places where you can watch your Karen Reed trial coverage, and I am grateful for each and every one of you who chose and chooses on a continuing basis to watch your trial coverage with me. I am honored and proud to call you my friends, my cupcakes. I'm going to end the poll now. We have 5,000 votes. In your opinion, Matthew DiSogra, 72% of you said he helped the defense. 15% said it was hella confusing. 10% of you said neither. And 2% of you said help the Commonwealth. Only 2% of you. Okay, well, that's good. That's good to know. That helps my internal. I don't know. I don't know how I ever find the poll results after the stream is over. And if you're watching on replay, you can't participate in the poll. I'm sorry. It's only for live viewers. But if anybody knows on the back end how I can actually find the poll results after the stream is over, there may not even be a way. One more thing here. Andrea Collins has been having a very hard recovery day today. So everyone send Andrea Collins your best healing vibes and prayers. She's been going on her public journey with us to recovery from anorexia. So, and I'm not doxing you because you publicly talk about it. So, Andrea, we are with you one day at a time. We love you. You can do this. You're a warrior. Thank you on top for the last minute super sticker. We'll figure out something to cover tomorrow. Put in the comments things that you would like to cover over the weekend, since we're going to need some content before Monday. And as I say, to end each and every stream, stay cool, stay kind, stay classy. You can do it. Your life will be so much better for it. Go do all the things and stuff. Be nice to people, and just keep on being the great, amazing you. Smash the like button on the way out. Do all the things that YouTube likes. Comment respectfully. Share the stream out. Let people know where they can find us. You're here. You know that you have found your people.